To be listed on the last week of January, but still not yet listed. So
give the list to my court office. Whatever the mentioning, give the reasoning, it will be automatically listed. If there will be no reason, it will not be listed. And with regard to the what is the date fixed, you contact my court officer, you find from the diary of the court officer.
If I am mentioning a matter,
My lord, I have been declared to be a willful defaulter, my lord, without supplying the forensic audit report. Now, in respect of the same bank, in another matter, my lord had directed them to sub the forensic audit report. My lord, in this case, I have been declared to be a willful defaulter, my lord, some precedence.
When you have been declared the
My
will,
lord, I have been declared to be a willful defaulter on 23rd December. I have filed a writ in or around January 6th.
okay, you mentioned that. You mentioned that due to the after seeing the mention, after going through the urgency, automatic the date accordingly date will be fixed. No problem.
Lordship, I am mentioning a matter.
Yes.
similar prayer, my lord.
Lordship, I had mentioned the matter for
Just a minute. Senior is mentioning.
Okay, I'm sorry.
Lordship, I had mentioned the matter on 13th of January for urgent hearing. After being apprised of the urgency, your Lordship had fixed it for 6th of February. It has not come.
6th of February does not come.
No. You consulted the diary and you fixed the date as 6th February.
So why it is not 6th February? It is not there.
My lord.
Okay. It is 6th February. The matter is not in the diary.
Similar prayer, my lord.
Give whatever the urgency you mention in your mentioning slip. Accordingly, the item is considered and you check the date when the date will. Accordingly, it will be fixed. Because as per the urgency, my diary is fixed till the April. I don't know when you get. That's why you mention the urgency, then we'll see.
Have you got to rejection one matter, my lord?
I already stated give the urgency.
Personal notice for personal hearing has been given, my lord. I am challenging such notice.
Personal hearing by whom?
My lord, notice issued by Punjab and Sindh Bank, brother. Petition already filed challenging two show cause notices. Or in that
Challenging show cause notice declaring default.
Yes, willful defaulter, my lord.
Willful default.
The notice has been given, calling the directors to appear for personal.
So willful default, the show cause notice was given. Have you submitted the show cause reply?
Yes, everything, my lord.
So what is the ground for filing the writ application?
Writ petition is pending. Affidavits complete, my lord. The writ petition is pending for.
What is the ground? What is the ground for writ petition if the show cause?
I'm challenging the show cause notice and the notice, my lord, declaring the petition is.
What is the ground of challenging?
My lord, the constitution of the committee which issued the show cause notice, my lord, that is not in proper form as per RBI guidelines, my lord. My lord, now on 28th of January 2026, my lord, the Punjab and
Okay, give.
But no, my lord, hearing is fixed on 18th of February, my lord.
Mention the reason. I will see to that. After seeing the reason, accordingly that will be fixed.
May I have my lords kindly to mention a matter, extremely urgent matter, my lord. Here, the State Commission, this writ petition was already admitted. There was no execution case. Thereafter, execution case was filed. Now they have passed an order, the State Consumer Forum, that the directors have to present before the court with 5 lakhs of check when this is a quorum non-judice orders, my lord. It has been fixed on the 27th of February. Your lordship, can you give me a date?
When your date is fixed before the
27th of February.
Mention it and give to my court officer. I will consult the diary. Mention the urgency. What you mentioned.
I've said that, but
yes.
New motion. New motion.
Item number for upgradation. There's one urgency, my lord.
Where is your list?
Okay,
Okay, I will see to that. You mention the urgency that court will consider.
My lord, may I be permitted?
Yes.
My lord, may I be permitted to mention, my lord, 2 identical matters, my lord. My lord, urgency is that, my lord, the district project officer Malda floated a tender, my lord, for supply of free education school kits, my lord. My lord, in the tender, my lord, tender documents, my lord, one additional clause has been added that availability of the office in the district of the tenderer in the district of Malda, Dokhin Dinajpur and Uttar Dinajpur only. My lord, the petitioner's office is situated in the Murshidabad, my lord, which is also the adjacent district of the Malda, my lord. And my lord, in addition, my lord, the petitioner is, my lord, affected by that clause because my lord, he cannot participate.
When is the last date of the opening of the tender?
18th, my lord, at
18th of
18th of my lord, day after tomorrow, my lord, 18th February, my lord, 2 p.m. last time for submission of documents, and bid opening time is 2:30 p.m. at 18, my lord. So, my lord, your lord.
So when the tender notice was issued?
Issued, my lord, on tender notice was issued, my lord, on my lord, it was issued. My lord, issued, my lord, 21st January 2026.
21st January, you are aware of the conditions. So now you're coming in the last 19th hours.
No, my lord, date of issuance is 21st, but it was uploaded, my lord, later on, my lord.
Maybe, but
My lord,
21 days is necessary for the tender notice.
No,
You served over the 21 days and you come on the last.
Kindly consider, my lord, date is, my lord, 21st, but it was uploaded later on. The petitioner came to know.
When you came to know?
My lord,
Okay, come karo. You have filed?
Oh, I'm paying for a leave, my lord, to move it on.
Leave is granted
Maybe.
to move tomorrow. List tomorrow as urgent motion.
May I be permitted to
Mention as
May I-
serious
may I
citizen
pray for
matter.
Give.
Mention on 2nd February, and your lord can speak about 28th February. 28th February is a Saturday, but
Okay, no, might be changed.
My lord, may I be permitted to mention a senior
Yes,
citizens matter?
next working date will come.
My lord, may I be permitted to mention a senior citizens matter?
No urgency, file it.
My
Yes.
lord, a senior citizens matter, my lord.
File it.
Senior citizen matter, my lord. The affidavit from the parents were received late.
Okay, no problem. You file it when you have a business account, you're not having the money to eat food. What you are telling, sir? Maybe.
My lord, the affidavit from the parents were received late.
Yes.
The affidavit in opposition from the parents were received late, my lord, in the senior citizens matter. Accordingly, my affidavit in reply is taking time, lord. I've got it affirmed. I've served the advance copy. My lord, the matter is due to be listed tomorrow. My lord, the papers, they are stuck in courier, my lord. I'm just praying.
Okay, let it come tomorrow. If it is not, you
My lord,
come.
because the parents, they appear in person, my lord, so I don't want to inconvenience them. That's why I'm mentioning today. My lord, in this matter, the parents, the other side, they appear in person. That's why. The matter is fixed tomorrow, my lord. I don't think
Which parents?
my lord, this is Dr. Roy, Kushal Roy.
So what you want?
My lord, they serve the
You are
affidavit
appearing for?
for the son.
No,
So they serve the
I
affidavit.
will not grant time on that. Please note. They are appearing in person, senior citizen. You are appearing.
My lord,
Sorry.
my lord, they served me late, my lord.
Maybe.
My lord, I am a depositor under the Sukanya Samriddhi scheme, my lord. My money is not being released by the post office in spite of repeated requests. No consideration is being taken, my lord. My money is required for my educational expenses, my lord. I'm mentioning on urgent basis, my lord.
My lord, may I please, my lord, I am filing this petition, my lord. I am seeking leave to file this. My lord, urgency is the bid document was opened and my bid was rejected on 9th. And same day they opened the financial bid also, and they are in the process. My lord, they did not follow the procedure. There was mandatory requirement under by the government circular itself that they have to give time to the other bidders to rectify the defects. My lord, on 7th of February, I wrote a letter that please let me know you need to comply with this circular. Now, they did not, and they opened the financial bid same day, and rather there were deficiencies and defects in the successful bidder. They didn't. They said that they were not material. However, my defects were material. They did not follow the circular. They are in the process of issuing the letter of award also contract. There is urgency. If it can be listed, I am seeking leave to.
Not before this week.
Because they will issue the contract.
What can be done? Why you waited for the last days?
It was on 9th of February only I got to know, Milord.
So 9th February, 10, 11, 12.
Milord, I filed it. That is why I'm.
When you filed?
When today.
When it was affirmed?
On 9th of February, Milord.
When it was affirmed?
It was affirmed on 11th, Milord.
So then,
Milord, Saturday, Sunday.
11th February, 12 and 13 was there.
Milord,
12th February, 13th February was there. Why you not mentioned?
Milord,
sorry.
Milord,
if you want, it will be taken on 5th or 6th March. It will be taken. Otherwise, no, because you are act with regard to the delay. I will not condone that. 9th, there was a 1 week time with you. You have not taken a step. Now you are coming in the last time. I will not allow.
9th.
Yes, if you want, I will fix it. Yes,
Milord, fix it at 5th.
Give.
he's retiring on February.
Milord, 5th
Maybe,
March. Milord,
maybe
5th
give,
March.
give.
Milord, 5th March, Milord.
No leave.
Milord, 5th March.
No.
Milord, 5th March.
But in 2012,
Hmm. What is the prayer? It is not in the list. Fixed under the heading hearing.
Milord.
Fixed under the
Milord,
heading.
can it be on 6th March, Milord? 6th or 5th or 6th March. Milord, because they will award the contract, Milord, they will proceed, Milord. That is urgent.
So,
Milord, if it can be taken next week, Milord.
List as urgent motion on 6th of March.
May I have your lordship?
Grateful, Milord.
Senior.
Milord, Milord, this is in relation to Milord, residential building 23 towers. There are no fire norms, Milord, have not been made, 18 breaches. Now, Milord, the urgency is, Milord, in another tower, Diamond City, today morning news, there's a fire all over, Milord. This is the urgency, 5,350 families are residing, 3,000 families, Milord, and Milord, there can be in this building also, Milord. So I am mentioning it. Otherwise, I would not have. It is a fire, Milord, in the similar building, Milord, in Joka. Everyone is on the street. There are 18 breaches, 5 complaints, Milord. Nothing done, Milord. So that kindly look at, this is the urgency. If this is not the urgency, Milord,
When you file the writ application.
Milord, I have filed on 6th of February, keeps it any date convenient to your lordship. This has to be done, Milord. Again, it will be a Diamond City, Milord.
10th,
Any date, Milord. I am not
10th March.
10th March.
10th March urgent motion.
Grateful.
Inform the
This
other
is
side.
the urgency.
Inform the
Again,
other
the
side.
same thing in the buildings.
Inform the other side. Yes. So what you want? So go to the civil suit, take an injunction. So what the RTI will do? So what is the urgency? You give in writing. I will see if the dairy permit, it will be listed.
May I be permitted?
I will see you mention the urgency. I will take that.
Lordship, may I be permitted to mention this matter? This matter is running as item number 272 of your lordship list, my lord. My lord, the petitioner is a poor grandmother, my lord, where she has lost her son. My lord, after that, the daughter-in-law, my lord, forged a birth certificate of her grandson, where the name of the son of the petitioner has been removed and some other name has been incorporated. My lord, several representation has been made to the registrar.
So what is the prayer?
My lord, my prayer is only my prayer is for upgradation. My
Now
lord.
what is the prayer in the writ application?
My prayer is to make a correction of the birth certificate, my lord.
Have you made the representation to the authority?
Several representation has been made.
So
No,
who has changed? How it has been changed?
my lord, by applying before the sub-registrar Uttarpada, my lord.
Okay, you give you mentioned the urgency.
Yes, my
Okay,
lord, I have.
give it to my court office.
Last occasion also I have mentioned it.
Now it has been done. I am personally seeing the all urgency. Then it will be listed. Give. Give all urgency or no personal hearing. What is the urgency?
My lord, there's only one urgency, my lord. My transaction will be foiled. The state was making me, my lord, put in stamp duty for a conveyance when I don't want a conveyance. I only want an assignment of the reversion, my lord. I had mentioned this on the 19th of January. My lord was pleased to fix it on the 6th of February. Ever since the matter has been running in the list. But my lord, my prospective vendors are going away. State is
What is
forcing
the
me.
serial number?
30, my lord, 30, my lord.
30. Son, 30, it is urgent motion. Then
30
what
it
is the
is-
urgent
Milord,
part?
may I, Milord's kind leave to mention a matter, Milord.
So because kindly see, Mr. Banerjee, if the bar will continue mentioning up till 12 o'clock,
Yes,
so
yes, yes.
the listed matter cannot be taken.
My lord, today
So
I
I
am
will
not.
take every day only the urgent motion. I will take list all the matters urgent motion. That you will be happy.
No,
That
no,
the court will not take the hearing matters.
no, my lord, that is not
That
the
is
way.
the bar thinking.
No, as far as today
They are
is
not
concerned,
understanding. Since morning, I am telling you the urgency in the writing to my court officer. I will take 1 hour in my chamber. Why you are wasting the court time?
yes, yes. No, I
Milord, I tender my unconditional apologies to attempt to mention. Milord, may I kindly attempt to mention one matter? I tender my unconditional apologies, Milord. The situation is such, Milord. May I kindly mention, Milord?
Yes, who is for the petitioner?
I have mentioned my urgency.
Yes. Item number 1, who is appearing?
Milord, may I hand over?
And appears in first. The matter is listed as to be. So why you are not
Inclusion.
Inclusion.
Yes, why it is mentioned?
Your lordship, remember this was extensively argued by my seniors.
Ah.
Badminton related matter, your lordship.
Ah.
However, the kids had apologized before the committee and they are looking into it, your lordship. So for that reason, we are withdrawing this writ petition.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. The petitioner submit that the dispute between the petitioner and the authorities have settled outside of the court, and accordingly petitioners are not
However, your
intending
lordship,
to
if
proceed with the matter.
without any prejudice, your lordship, if things go south,
Intending to proceed with the present writ application. Accordingly, WPA number 28985 of 2025 is dismissed as not pressed. Interim order, if any, is vacated.
grateful, your lordship.
Next.
It pertains to that matter, my lord, where in Purulia,
Yes.
the construction of boundary wall of an ashram that was sought to be resisted by, my lord, the state administration, despite orders being there, my lord, and despite a judgment to that effect, my lord, declaring the right title of that particular ashram, my lord. Because there were certain villagers who were claiming that it belongs
So
to.
now what is the situation?
Now, my lord, during pendency, my lord, the boundary wall has been constructed. I'm sure, my lord, the state will not be disputing that.
The civil suit is pending.
Civil suit is not pending. The appeal is pending.
Appeal is pending. The appeal is pending. Appeal was the date for passing order. You is already secretary.
For further directions. Na?
So now the boundary wall has been constructed.
Boundary wall has
So
been
nothing
constructed.
remains in the.
No, because it was put.
Disposition. There is that construction is over. 2 million Mr. Ashram Ganguly is appearing in this matter. He has not come in now, but if it is over, so.
My lord may record that and my lord may dispose it of.
Yes.
Because what was sought for, my lord, has now been achieved. The SDO, my lord, upon hearing of the matter, my lord, the SDO has disciplined himself, my lord, automatically.
It is submitted from the bar that after filing of the present writ application, the police authorities have have provided sufficient protection for construction of the boundary wall of the
boundary wall, my lord.
Boundary wall of
in and around, my lord, the ashram known as Multiversity or Ayochok Ashram.
In and around of the ashram, namely
Multiversity, which is also known as Ayochok Ashram.
In and around the ashram, namely the Multiversity. Yes, multiversity.
Yes.
Okay.
Ayochok Ashram. This is paragraph number 3 at page 91, my lord, of the second volume. You will find it at para 3 of the petition itself also.
In and around the ashram, Ayachak ashram, situated at plot number so and so. Police. And the construction of the boundary wall for the safeguard of the ashram has been completed. It is submitted that as the boundary wall has been constructed and nothing remains in the present date application. In view of the above, the WPA number 28157 of 2025 is disposed of.
Extremely grateful.
Thank
you. But may the state administration also ensure, my lord, that the law and order is not disturbed. It's an ashram, my lord.
Already disposed.
I did not know about this ashram. Saturday, I went to Varanasi for Shivratri. So I saw it in front of the temple. It was very close to the temple. I went inside. It's a very age-old institution.
Okay.
Great,
Thank
great.
you.
My lord, item
Yes.
number 5, my lord, it is wrongly appearing in the list, my lord, I believe, because of.
Why wrongly appeared?
We have not mentioned, my lord, urgent
Mention, you have see the cause list.
urgent motion.
See the cause list.
Yes, my lord. Urgent motion.
See the cause list.
Take out my phone, my
Take
lord.
the cause list and see the cause list of the heading. See,
Having the case diary, otherwise.
there is a specifically mentioned. Every day under urgent motion one criminal revision application will be listed specifically as per the year of the case.
My mistake, my lord. Then it's
So
my
need not to mention.
No, my lord. It's
So
my
because
mistake.
the criminal matter is pending, nobody because of the urgent matter, it cannot be. So every day one criminal matter will be listed as urgent motion.
My lord,
Because
my lord.
2008 you are enjoying.
No.
What order you are enjoying?
Lord, an interim order was.
Then
my lord.
2008 you are enjoying the interim order. Proceeding is pending before the trial court. Good. And state is sleeping over the matter, not mentioning nothing. By that time the witness will passed away. The accused might have been fled away. And when the matter go to the trial court, nothing remains. It will again in the dock, either warrant of arrest or either attachment or something else. There will be no disposal.
Not that heinous crime, my lord. My lord.
Heinous crime that 2008.
Yes, my lord. Not that heinous.
When you will be ready?
My lord, anytime fixes it, my lord, because Mr. Bhattacharya,
Not time. You tell I will fix any date in the urgent motion. I will not fix a time. It will come as a urgent motion in any day. You tell as per your convenient because you are ready with the case diary.
My lord, any day, my lord fixes it. Any day, my lord fixes it.
The Learned Counsel appearing for the petitioner submit that the matter is suddenly listed as urgent motion and as such is not ready. Is not ready to argue the matter today and he prays for fixing the matter to some other date. In view of the submission made by the counsel for the petitioner, let the matter appear on 10th of March 2026 under the same heading. Come ready on that day, no adjournment. Criminal matter, no adjournment.
Can it be 11th or Monday and Tuesday? I'm having some problem.
Okay, 11 March.
I am otherwise ready, but my lord understands, my lord, when there is a senior in the
11 March. Next. Yes.
That matter, my lord, with regard to Bhandara, on the last occasion, they took time
Bhandara,
to file the
yes.
report. Yes, I have, my lord, already obtained a report. Yes, my lord. Now, your lordship kindly straightway, my lord, come to page number, my lord, 13.
13 of
the writ petition, my lord. They are from, my lord.
Now, what the report you have submitted? I have got the affidavit
Yes,
report.
in the report, my lord, they admitted that they did not, my lord, obstruct in our way. On, my lord, it is their own admission, but on the next breath, my lord, they said that yes, we have encroached certain land. The measurement of the encroachment which they are alleging, my lord, that is actually the deed. Schedule of the deed, my lord, I am showing it to your lordship, my lord. So my
only difficulty is that land belongs to the
Defense.
straightway, your lordship kindly come to.
security, my lord.
Yes, yes. That has already been, my lord, in the letter. Your lordship kindly come to page 13, my lord.
Page
number 2.
Page
13, 14, my lord. Relevant portion is page 14, my lord, paragraph 2. Neither government nor the military force came to Barakpur to interfere in any way in the gift deed and the present officer.
Paragraph, which
Paragraph
page you are
2, my lord.
referring?
Paragraph 2.
of the
Page-
deed of gift.
Page 14.
Page 14.
Yes.
Yes. Neither government nor the military force came to Barakpur
Hmm.
to interfere in any way in the deed of gift, and the present officer commanding now in Barakpur shall keep special care for the temple in all respects.
Hmm.
All the rent of the shop attached to the temple, the said Mohant shall be authorized and empowered to realize the same and spend for the work of the temple.
Hmm.
Ultimately, paragraph 5, your lordship will find, with these conditions and on free will and liberty with the consent of the officers of the platoon, this deed of gift has been executed on a 5 rupee non-judicial stamp paper at that time, my lord.
Hmm.
This is the deed of gift.
Hmm.
Now, your lordship, kindly come to the title suit. That is, my lord, page number 16. Next page. It starts from page 16.
Hmm.
I am just taking your lordship to the relevant portion, my lord, at the dictatal portion. That is, my lord, page 20.
Hmm.
Middle paragraph, second paragraph. In view of my findings above, the plaintiff is entitled to get a declaration and permanent injunction as prayed for. This issue is answered in favor of the plaintiff. My mandatory injunction that was refused because I already admitted I am in
So
possession.
what was the issue? Finding of the what was the issue? Issue number?
Sir, my lord,
What was the issue number 6?
Our entitlement that was challenged by some of the
The
parties,
plaintiff
my
is
lord.
entitled to declaration of permanent injunction.
Yes.
Okay. So what is the suit property?
Suit property, yes. That your lordship kindly come to, my lord, the next, my lord, the compromise decree.
Huh?
Compromise decree, that, my lord, starts from 22. Relevant portion is, my lord, schedule. That is, my lord, page 23.
Hmm.
District 24 Paragana, schedule, my lord.
Ah.
Subdivision Barakpur,
Ah.
Mouja Barakpur, about 2 bighas of rent-free debated land
Hmm.
with temples, outhouses and trees standing thereon north-south. These 2 bighas of land, my lord, it exactly, my lord, we just
Just a
measured.
minute.
Yes.
District 24 Pargana, subdivision Barakpur, Thana Barakpur, Mauza Barakpur, about 2 bighas of rent-free, Debatto
Debotto,
land and with temple,
outhouses
outhouse and
and
trees standing thereon, north, south and west by cantonment,
Yes.
east by ground,
Yes.
by the public road.
By the public road.
So,
This is, my lord, the schedule.
so the three surrounding 3 area, there are the cantonment.
Yes.
And one is the public road.
One is the public road.
Yes.
Now this is, my lord, the compromise decree. Now your lordship kindly come to next paragraph. That is, my lord, later paragraph, page number 26. It is there.
What is the compromise decree?
That is the compromise decree.
The Royal Calcutta will build the Goshala, demolished by the petitioner, wherefrom it is marked a plan here to and not in the Royal Calcutta. The plaintiff agrees to undertake for himself a successor of assignee to keep the compound a flower garden only as a land out of the Royal Calcutta. Yes, then?
Yes. Now your lordship kindly come to page 26. It is their letter, my lord. They are writing this letter to us, my lord. Paragraph number 3. Gate 4 is the nearest to the temple. Access to this gate has been permitted throughout. There is a sentry at this gate as security check is essential. There is no truth whatsoever in the allegation that this gate is enclosed or opened at the sweet will of the troops manning it. There is, however, a sentry at this gate round the clock, and personnel going to and returning from the temple are always permitted to go through, even though the arrangement no substance in the allegation that O.C. Bihar uttered words to the effect that he would arrest the Pujari. The Pujari has always been respected by the troops as he is the head of the place of worship. It has been proposed to create a more suitable access to the temple and the mosque by constructing a boundary wall enclosing 2 places of the worship and the approach thereto through a separate.
only for 19th of February.
3 weeks.
So the respondents are directed to file affidavit within 3 weeks. Reply, if any, there to file within 2 weeks
Within 1
thereafter.
week.
List the matter on 27th of March 2026 under the heading adjourn motion.
Obliged to your lordship.
Okay, 8th of April kar do. 8th of April as adjourn motion.
Obliged to your lordship. Yes, my lord. Are you already have a copy,
File the
my lord?
copy. Yes, next. Yes.
My lord, may I take your lordships? Please.
Report filed.
দুটো ম্যাটার নাকি?
Yes.
Now I take your losses to that. Ojha.
Oh, there is one report is there. Affidavit.
Well, there are two reports.
Report by way of affidavit of the respondent number 3. And there is an another affidavit in the form of report by the state respondents.
Both are state respondents, my lord.
Fifth of July 2025. So you file the exception to
No necessary.
Yes. Yes. Today. Yes. At the commencement of hearing, audit report was placed before the petitioner. Observation is yes. Yes.
Now, my lord, I take your losses to the petition just after showing two documents from our exception, because that is also in the writ petition. Earlier, I have not filed. It's not required. Now, your lordships kindly take your lordships to page 14.
14.
But this is the quotation notice. There were two notices. I will give your lordship the work order number. Well, your lordships will find the type of work. This is in regard to
Preparation of wooden rack.
the exception to the first report.
Earlier exception.
The preparation of the wooden rack as per drawing and direction, ceiling, all that. Your lordships will find last paragraph. The specification of works. একটা copy থাকলে আবার দিয়ে দাও. The specification of works is attached herewith in separate sheet, schedule. Kindly come to your lordships the next page. Approved rate for Contai subdivision of decoration pandal works in connection with the parliamentary general election. Well, these are the rates approved. Now, my lord, according to this, I submitted, my lord, my work, my lord, your losses will find at the page 23. This was
Page
the approved
23.
rate. Kindly see, my lord,
Yes.
page 23.
Yes.
Subdivisional officer, Contempt, Mednipur. Rate offered by quotationer. I offer my rate above item work 0.30% less. And then, my lord, this was signed by the sub-contempt division. Now your losses will find another, my lord, page 24. These are in respect of the same election process. Your losses will find schedule rate from page 25 onwards. Now your losses will get the same signature. Your losses kindly see page 31. Rate offered by quotationer, rate is accepted, my lord, 0.22 less, percent less. So one was accepted, your loss is 0.30, another was 0.22. Now your losses will find page 33, comparative statement. The others also file. Now your losses will find OJA, nature of work, your losses given. Quotation notice number 2339. As you also got the left hand side
Page
after
30.
the page 33.
Yes.
Left hand side, date of opening before that.
Yes.
Date quotation notice, because for identification your losses.
Yes.
Now I stood, Malad, my quotation was accepted with 0.3% less. Kindly see, Malad, subdivisional officer accepted.
You are OJA construction.
OJA construction.
So 0.3.
0.30. Your losses will find, see the next page 34. I was given the work order on the approved quoted rate.
0.3%.
0. Malad, there is another your losses will find. The next one, Malad, page 36. I have placed before losses two notice. Malad, work, Malad, quotation notice. Kindly see, this is quotation number 285. Earlier one was 233, 21. Now kindly see your lordships. This was accepted, quoted rate 0.22% less. Subdivisional officer as the then Malad work order.
Yes.
Now I tell you lordships, Malad, this is accepted. Work order I completed. So far, Malad, pendency, they have paid 35 lakhs rod. My total came 49 lakhs. Malad, I will show your lordships. My first concern, this is concluded contract with the state authorities. Once the rate concluded, Malad, state after having received the work and rate the concluded beforehand, state cannot come up and say that the rate was higher. Malad, I take your losses to that. That's the dispute. I will show the Malad the other documents. I just request your losses. There was, Malad, I believe, Malad, this was before your losses, a para-wise statement of facts. Then I will take your losses to the reports to give your losses a sequence of facts. Para-wise statement, your losses will find. Finally, the heart. The what?
Yeah, only report. We have finally report. We take that and pay. Admitted amount, you not be known. Admitted amount, otherwise, you have to go for money. Because this will get question. This will get question.
I will not agree.
You're not in. I cannot, I'm not, our of the but however, that there are and but admitted amount, I report to the and allow me to
Yes. If
report twice called for, kindly have a look at that, your lordships. Kindly, report is in the office. No, not regarding the payment.
order.
That's the argument I will make. You will make argument. Well, kindly your losses take up. Do that. Now your losses kindly take up the para-wise payments. Oh, Baba, so what I have come up here? For what hearing? Not payment. This is a final hearing. Well, after kindly see the orders, the call for. The report is in the form of affidavit. Now they have I take your losses to their report. Oh, I will. This is the. Lord, I don't. I think. Lord, I will. My Lord, I will not file. I will show this is not required. About again file. Para 3, I will show.
Mr. Banerjee, the matter is taken up since the April 2025. Correct. The matter is taken up since the month of correct. The matter is taken since the matter is taken. No, that is different thing. That I will consider. That I am not going into the merit. Now, with regard to the affidavit in opposition which you are asking, the matter is taken up from the
Kindly consider 5th August order.
March of 2025. Correct. And you state has appeared. Even the earlier the AG has also appeared. And you have not raised the point of maintainability of any point of neither you have taken the time for filing affidavit.
Lordship has, Lord, what was passing through the mind of the court? Actually, he has asked for money for his work, and what is the amount payable? But we filed an affidavit earlier, then your Lordship has directed, kindly ask the SDO to hear out, and thereafter, my Lord, we have done so, and this affidavit is being filed. So far as the, my Lord, my learned friend is now actually going into the merits of the writ petition and say, my payment is such and such, but according to us, this payment is being made, this payment has been calculated.
Correct.
But in that event, my Lord, I am only, I beseech to your Lordship, kindly allow us to file an affidavit, short affidavit. I will come with the records. Why? And this payment, 58 lakhs already paid. He has received. And he has said we have no claim.
I have never said, Malak.
No.
No, Malak, kindly let me proceed.
On affidavit, I have said so.
No,
Then your lordships will consider, Malak.
Once they wanted to file the affidavit, let them come with the affidavit. Though they
That's not required. Everything before your lordship.
No. But once the authority is asking for the affidavit, let them file the affidavit.
Kindly have a look at lots of feet.
Pass the order. No, he has praised the court. No required. No requirement. Everything is. Yes.
Let me, your lordship, hard.
Kindly make your submission because you are a senior counsel.
But
don't make such submission before this.
But Mr. Banerjee.
I'm sorry.
Now, see, first you have come to your first exception report. Exception to the report. Can you come to the first exception to the report? Page number 7.
একটু দেবে আমাকে দাও তো বাবা এক্সেপশনটা
Got it.
এই রুদ্র দাও তো একটু
Kindly come to the page number 7.
Page number 7. Mine.
Got it.
Mine.
So this is your parawise comments which is given to the government feeder. Got it.
Mine.
And we go through. Date 18th of March 2025.
I know that. But below your lordship, because I'm not satisfied. This parawise comments I've handed over. He asked me a copy. I've supplied. But lordship, kindly consider this. My 2 points. Number 1 is, Lord, admittedly there is a dispute. He is asking for such money, and I am actually calculating such money, and I have already paid. He has received, and on affidavit I have said he was called for before the subdivision officer, and he said I have no further claim. Number 1. Number 2, when a dispute arises, then your lordship has gone into the merits of the case without affidavit. I'm asking question to myself.
How soon you will file?
2 weeks time, your lordship.
Let them file.
No.
Though the authorities have filed
2
reports, and out of 2 reports, one in against one report, petitioner has filed exception. The reports are on record. Then your counsel for the state press for time to file composite affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. Within a week.
But I think, my lord, all the records are here with. I need not file any reply also probably.
Within a week, if any,
Do that,
reply,
all
if
the
any,
records are here.
reply, if any, within a week thereafter. List the matter.
Now, kindly fix a date, your lord.
List the matter on 2 weeks, 1 week, 3 weeks. No? List the matter on 24th of March under the same heading.
Well, your lordship, kindly give any time, your lordship.
Same heading. Adjournment. Next.
Next, my lord, this
It
same,
is the same matter.
same matter, similar order.
And a similar order may be passed on the same.
আমি রিপোর্টটা দিয়ে দিয়েছি আপনাকে
Yes, taken on record.
No, no, 8 so far as 8 is concerned.
Okay.
I'm taking
এই
right.
একটুখানি কাগজ নাও। এইটাও appearance-টা same.
I appear
Yes.
for the petitioners, my lord,
Yes.
in the matter, my lord.
Let's appear respondent number 1 to 4.
My lord, on the last occasion, my lord, the respondents had cited certain judgments, my lord, on the ground of territorial jurisdiction, my lord. A compilation whereof had also been, my lord, handed over to your lordship. My lord, I'm being led by Mr. Jishnu Chaudhary, my lord. I'll begin, my lord, and he can join. My lord, I'm being led by Mr. Jishnu Chaudhary, my lord. I'll begin, my lord. He may join once he comes.
Okay.
My lord, the first judgment, my lord, that they had cited was the Kusum ingots matter, my lord. If your lordship takes page 5 of the judgment, my lord. This is a matter, my lord, where, my lord, the viries of the securitization and reconstruction of financial assets and my lord, the Surfacy Act had been challenged, my lord. My lord, the challenge was made, my lord, in Delhi on the ground, my lord, that the legislation had been passed by the parliament. Now, my lord, if your lordship sees paragraph 2 and 3, my lord, of the judgment, my lord, if I may just read the relevant paragraphs, my lord. The appellant is a company registered under the Companies Act. Its registered office is at Mumbai. It obtained a loan from the Bhopal branch of the State Bank of India. Respondent number 2 issued a notice for repayment of the said loan from Bhopal, purported to be in terms of the provisions of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. Questioning the viries of the Act, the said writ petition was filed before the Delhi High Court by the appellant herein, which was dismissed on the ground of the lack of territorial jurisdiction. Now, my lord, the company is based out of Mumbai. It obtains a loan from Bhopal, my lord. And now, my lord, if your lordship takes, thereafter, my lord, I'll not trouble your lordship with the following paragraphs, my lord. Thereafter, my lord, at para 29, my lord, 28 rather, my lord. If I may just read, my lord, learned Lieutenant Colonel Khajur Singh versus Union of India, whereupon the learned counsel appearing on behalf of the appellant placed strong reliance was rendered at a point of time when clause 2 of Article 226 had not been inserted. In that case, the court held that the jurisdiction of the High Court under 226 of the Constitution of India, properly construed, depends not on the residence or location of the person affected by the order, but of the person or authority passing the order and place where the order had effect. Now, my lord, this order had been passed when 226(2) was not there, my lord, in the Constitution of India. And therefore, my lord, this judgment said that you'll have to challenge the order where the legislation has been passed. Now, my lord, after 226(2) having come into force, my lord, it will have to be filed where the cause of action has arisen. Now, my lord, my case is that the show cause notice was received by me, my lord, in my registered office, which is based at Calcutta. Now, my lord, my registered office is at Salt Lake City. If your lordship will only take page 527 of my writ petition, my lord, which contains the show cause notice. My lord, if your lordship will just take for once, my lord, page 527 of the writ petition. Now, my lord, on the first page, my lord, if your lordship will see, Gupta Power Infrastructure Limited, Managing Director Mahendra Kumar Gupta, my lord. Now, thereafter, my lord, the registered address is Salt Lake City, Kolkata, West Bengal. And thereafter, my lord, the address of the guarantors are given. Now, my lord, clearly, this notice was received by me at my registered office in Salt Lake. So, the cause of action, my lord, had arisen in Salt Lake at Calcutta, which comes within the jurisdiction of the Honorable Court. Now, my lord, the next judgment, if your lordship sees, My lord, I'm being led by Mr. Shaunak Mukhopadhyay.
My lord, kindly grant me leave, my lord. Mr. Chaudhary is on his way. We're just distinguishing the judgments, my lord. My lord, Kusum Ingot, my lord, will kindly note paragraph 10, my lord, my learned friend has already shown. My lord, the next judgment, which was already dealt by Mr. Chaudhary on the last occasion, my lord, here, my lord, the business, this is a case in respect of imposition of tax, my lord. Here, the entirety of the cause of action had arisen within the state of Goa, my lord. The business of the person exigible to tax was also carried on in the state of Goa, my lord. But the writ petition was filed before the Sikkim High Court, which is, my lord, not the correct territorial jurisdiction. My lord, will kindly grant me one moment. Only 2 paragraphs I'll just indicate, my lord, of this judgment. Yes. My lord, will kindly take 15 and 16, paragraph 15 and 16 of the judgment.
Yes, Mr. Chaudhary already argued.
Yes, my lord. Yes, my lord. Therefore, I'm not bothering, my lord, with this. My lord, the next judgment that is there, my lord. Yes, one second. I'm sorry. My lord, the next judgment is Om Prakash. Here again, my lord, we'll kindly see paragraph 18 of this judgment once. Nothing is finally decided in this judgment. Here, the point of territorial jurisdiction is raised. Cause of action is discussed by the Honorable Supreme Court, but nothing is finally decided. Paragraph 18 only may I place only, my lord. Nothing more. My lord, will kindly take paragraph 18, that's page 23 of the judgment.
Yes.
In the instant case, may I just place this very quickly, my lord? In the instant case, the High Court has not dealt with the question of whether it had jurisdiction to deal with the writ petition. It is only observed that the Delhi High Court may have jurisdiction, but the issue relating to the conditions of the prisoners in the state of UP can be more effectively dealt with by the Allahabad High Court. As noted supra, there are 2 grievances of the appellant, but only one of them, that is, alleged lack of medical facilities, has been referred to by the High Court. It was open to the Delhi High Court to say that no part of the cause of action arose within the territorial jurisdiction of the Delhi High Court. The High Court in the impugned order does not say so. On the contrary, it says jurisdiction may be there, but the Allahabad High Court can deal with the matter more effectively. This is certainly not a correct way to deal with the writ petition. Accordingly, we set aside and remit the matter to it for fresh hearing on the matter. Therefore, the question of territorial jurisdiction is kept open by the Honorable Supreme Court. Well, the next judgment, that is Pintu Muhanta. This is a judgment of this Honorable Court, my lord. My lord, will kindly see paragraph 1. Kindly sees the factual conspectus in which this judgment was pronounced. The petitioner is a permanent resident of Orissa. He was serving as a constable attached with the CRPF. He was appointed on 19 January and was posted with the battalion. My lord has the judgment. Yes. Paragraph 1. He was posted in Patna, Bihar. Resident of Orissa, posted in Patna, Bihar, writ petition filed here. My lord, why it was filed, that is explained, my lord. We'll kindly see paragraph 16 and 17. May I please, my lord? Paragraph 16 and 17. After hearing the submissions made on behalf of both the parties and upon perusal of the judgment relied upon by the parties, it seems that the learned counsel for the petitioner has simply misread and misinterpreted the law laid down on the issue of the provision of Article 2262 of the Constitution of India. It lays down that the High Court can issue writ if the cause of action wholly or partially arises within the territorial jurisdiction of the court. Cause of action is a bundle of facts. Well, that sentence is repeated over and over again, which is necessary for the litigant to prove his case. In the instant case, very important, my lord, the entire cause of action arose outside the jurisdiction of the state of West Bengal. Under no stretch of imagination, the territorial limits of the Calcutta High Court can be invoked for maintaining the writ petition. None of the cases cited by the petitioner comes to his aid. On the contrary, all the cases speak against him. Paragraph 17. The petitioner, in practically all the paragraphs of the writ petition, has tried to establish the fact that certain correspondence in respect of the petitioner were forwarded. Mallar will kindly see, forwarded to his learned counsel having his office in Kolkata. A part of the cause of action arose within the jurisdiction of the Calcutta High Court. The learned counsel vehemently argued that forwarding of communications to the learned counsel forms an integral part of the cause of action, and he falls back on the doctrine of forum convenience. Paragraph 22 only, my lord, last paragraph I'll place of this judgment. Paragraph 22, in the instant case, none of the notices issued to the petitioner were served within the jurisdiction of the Calcutta High Court. The order of removal was sent to the petitioner's permanent address in Orissa. Only a copy of the order of removal of the petitioner from service was forwarded to the address of the learned advocate in Kolkata. On his request, forwarding a copy of the impugned order at Kolkata does not give rise to cause of action. So the notice and the order were all issued to Orissa. It was forwarded on a request of the advocate. Therefore, my lord, here factually distinguishable from our case. The next judgment, my lord, that is the Bombay High Court's decision. in my lord trust cap. My lord, here this judgment relates to my lord section 148 AD of the Income Tax Act, which my lord will kindly appreciate that's a completely separate jurisdictional issue, and this is the Supreme Court has clarified that tax. Yes, yes. Oh, I'm sorry. My lord, here income tax related matters, my lord, are governed by a separate jurisprudence altogether. My lord, you kindly see the facts of the case. My lord, here the writ petition was filed in Bombay High Court, paragraph 2 of this judgment. The petition challenges an order dated so and so under section 148 AD of the notice dated so and so issued under section 148 of the Income Tax Act by the Income Tax Officer Kolkata and the Chief Commissioner of Income Tax Kolkata. So the Bombay High Court here finds that since the taxation officer was in Kolkata and the notices were issued from Kolkata, therefore no part of cause of action arose. My lord, here the only relevant portion of this judgment, my lord, will kindly come to paragraph 8 and 9. My lord, we'll kindly take only paragraph 9, my lord. Paragraph 9 will suffice. Admittedly, the impugned order notices were issued by the income tax official in Kolkata. The case papers and material on the basis of which notices are issued are at Kolkata. The petitioner's assessing authorities are based at Kolkata. Thus, a substantial portion of the cause of action accrued in Kolkata. Applying the principles of forum convenience, it would be appropriate if the petitioner was relegated of availing of his remedies at Kolkata. Now, last paragraph of this judgment, paragraph 18, my lord, that's at page 35 of the compilation. Paragraph 18. In the context of, I'm sorry.
Why not 8?
Yes, my lord. 18
Why not 8?
No, I appreciate, my lord. 8, of course, I'll place. The fact that the petitioner has a registered office in Mumbai may not be very relevant. In any event, if we assume that a minuscule part of the cause of action could have been said to have arisen in Mumbai, that by itself is not a factor upon which the petitioner can compel the court to exercise its jurisdiction under Article 226. I appreciate. One second. Yes.
So why
Here, no, exactly.
Why only a registered office?
Yes,
Calcutta
no.
can
Here, my lord, I have also received. Here, the order that has been declaring me as a willful defaulter was received here. We will show the judgment of Lalit Kala, which my lord Mr. Chaudhary was placing on the last occasion. Lalit Kala says that the citus of the petitioner is relevant when there is a civil consequence of an order that is received within the jurisdiction. That is what Lalit Kala says. And here, my lord, will kindly see this is a tax case. Paragraph 8, there is no dispute with the proposition of law, my lord. I cannot say anything because the Supreme Court has also said mere existence of a registered office within the territorial limits of my lord's court does not confer jurisdiction. I am saying cause of action has arisen because an order has been received before within the local limits of this honorable court, my lord. My lord, Mr.
Affectation of rights.
Affectation, exactly. My lord, Mr. Chaudhary.
Very briefly. My lord, my learned friend has, my lord, dealt with the judgments. One sentence for each, my lord. Kusum ingots. Their first judgment. I will not distinguish it because it's distinguished in Lalit Kala Academy. I will only read that paragraph. State of Goa. Justice Dipankar Datta's judgment of the Supreme Court. A Goa legislation was challenged in Sikkim. If your lordship, my lord, just considers paragraph 2, 5, and then, my lord, 16. Yes. 2, 5 will give your lordship the facts. It's a Goa GST notification challenged, my lord, in Sikkim.
Yes.
And 16 is, my lord, tax levied by government of Goa can't be, my lord, challenged elsewhere.
Yes.
And the crucial, my lord, sentence is.
Which judgment you are referring?
My lord, this is, my lord, state of Goa. It's, my lord, these are misplaced.
Yes.
My lord, please see paragraph 2. After 5 lines, appellants had pleaded in the applications that inter alia notification issued by it was under challenge in writ petitions, and that if at all such notification could be made subject matter of challenge, High Court at Goa is the appropriate court where remedy ought to be pursued. According to the appellant, a notification issued under a statute enacted by a state legislature cannot be subjected to judicial scrutiny within the jurisdiction of a high court of a different state. This was the issue.
Okay.
And my lord, 5 is the same, and 16, my lord, are the reasons. So this has nothing to do with, my lord, anything. This is a statute, a notification, a tax levied in Goa being challenged in Sikkim.
Okay. Next.
Now, my lord, next is Om Prakash Srivastav, my lord, reported at 2006 6 SCC 207.
Yes.
Extradition Act resulted in somebody being brought from Singapore to, my lord, UP. This person, my lord,
Delhi.
filed a writ petition in Delhi complaining of conditions of jail in UP.
Correct.
And, my lord, the certain other issues. I will just give the paragraph numbers, my lord. Please, just paragraph 18, my lord, is enough. This has nothing, my lord, to do with this. This is judgment number 3. Judgment number 4 is this Honorable Court's judgment in Pintu Mohanto. This is, my lord, a matter, my lordship has seen it, my lord. This is a matter, my lord, of the petitioner who was, my lord, in employment with CRPF, posted in Bihar, being removed from service. The argument, my lord, is unique. Petitioner said to court, to this Honorable Court, I am only advised by my advocate. My advocate is in Old Post Office Street. So, you forwarded all my notices to my advocate. So, affectation doesn't matter, I'm in Bihar. Doesn't matter that UP, my lord, ADG responded. But because my advocate is in Kolkata, my rights are affected there.
Not advocate in Kolkata. Advocate received the order.
Order in Kolkata.
Termination.
No, my lord, paragraph 17. My lord, kindly see
And yes.
page 25 of this compilation,
Correct.
which, my lord, will give you paragraph 17
Yes.
of his my lord, affidavit.
With respect of the petition were forwarded to the learned counsel having the offices Calcutta.
Forwarded.
That's why.
Yes. Not the same as, my lord, an order of blacklisting being received, which is there in a judgment I am going to show your lordship. So, my lord, paragraph 7 and 22.
Seventeen 22. Yes.
1722.
Yes. Next.
My lord, important, my lord, is 22. One sentence only.
Yes,
In the instant case, none of the notices issued to the petitioner was served within jurisdiction of Calcutta High Court. Order of removal was sent to the petitioner's permanent address at Odisha. Only a copy of the order of removal was forwarded to the address of advocate at Kolkata. So, my lord, it's not the same as service of notice of removal.
Yes.
Next is, my lord, trust cap, which is, my lord, the Honorable Bombay High Court's judgment. This is, my lord, totally inapplicable with respect to my learned friends. This was, my lord, a challenge to an order under section 148 capital A of the Income Tax Act. My lord, the order was passed by the Income Tax Officer, Kolkata. They, my lord, went to Bombay and challenged it. Bombay, my lord, sent it back. Paragraph 9, my lord, is important, and paragraph 18 is the main reason that the income tax, relevant income tax assessing officer and commissioner is in Kolkata. So you have to go to Kolkata. My lord, this is not the same as our case. Please see just paragraph 18. My lord, and now, my lord, the last judgment.
Yes.
Delhi. Service matter. Whole, my lord, proceeding, disciplinary proceeding, show cause, everything happened. Nothing happened in Delhi. Petitioner came to Delhi. Paragraph 29. So, to summarize, and to quote Justice Dipankar Datta from, my lord, the Lalit Kala judgment, it is now the practice to come and confront this honorable court with inapplicable judgments and say that you don't have jurisdiction, with, my lord, an undernote that Calcutta High Court assumes jurisdiction over matters where it does not have jurisdiction. Okay. These are, my lord, the judgments which they have referred to. Now, my lord, I want to show your lordship that this is not the correct position. He has not shown, my lord, the relevant judgments. Please, first, my lord, take Lalit Kala Academy, which is the single bench judgment reported at AIR 2015, Calcutta, page 67.
Yes.
Please see, my lord, paragraph 41 of this judgment. Lordship has read the judgment before. I am not, my lord, going into the earlier paragraphs.
Yes.
Lordship will see, my lord, paragraphs 2, 3. Lordship will see, my lord, paragraph 11, 12, that this happens. And the same judgments, my lord, are cited. But, my lord, the law is laid down, my lord, from paragraph 2018. Lord, please come to paragraph 28.
Paragraph?
28, my lord. Paragraph 28. আমাকে দিয়েছো অনুপাতরা প্রিন্ট করে নিয়ে এসছো SCC অনলাইন।
Yes.
Milord, I'll just compare, Milord, the paragraph. No, of course not. Milord, I'm very sorry if I marked on Manupatra. I will just, Milord, find the paragraphs, Milord.
That's why keep one software only.
I only have, Milord, SCC online. From the decisions of the Honorable Supreme Court. এটা দেখো না। It is so easy on the software, my lord. Oh, I'm sorry, my lord. I think whole mistake was mine. When I opened another judgment. My lord, please see paragraph 48.
That's why advocates should not be busy. It may be busy, but so not busy.
But you should not have thick fingers now. Because these are two dots. You press the wrong dot, wrong judgment jumps up. Milord, please see, Milord, paragraph 48.
48?
Yes. In fact, 41 to 48. Turning to the objection at
41 starts, yes.
41, Milord. Turning to the objection at hand, it must be decided in view of the pleadings and not on the basis of conclusions in Swaika and Utpal Kumar Basu that the Calcutta High Court assumed a jurisdiction that it did not possess. The decision in the former case never laid down the law that receipt of a notice within territorial limits of a high court is not sufficient to clothe such court with jurisdiction. On facts, it was found that it was not necessary to plead service of the notice. What the Supreme Court said was that the receipt of the notice, in order to confer jurisdiction on the Calcutta High Court, must have been an integral part of the cause of action. In the latter case, every event or incident material for a decision on the list was held to have occurred beyond the territorial limits of the Calcutta High Court. And even if the averments in the writ petition were taken as true, it could not be said that any part of the cause of action arose within the jurisdiction of the Calcutta High Court. Milord, the important sentence is, Milord, fourth line, The decision in the former case never laid down the law that receipt of notice within territorial limits is not sufficient. This law was never laid down. Yes. Now, my lord, please see paragraph 43. The claim of the petitioner that this court has territorial jurisdiction is based on the situs of affectation of rights. This is the main issue. Mr. Krishna has referred to two decisions in National Textile and Alchemist. The reasons for upsetting the judgment and order of the division bench of the Calcutta High Court are recorded in paragraph such and such of National Textile. It is clear that the point based whereon the division bench has held that part cause of action had arisen within its territorial limits was found by the Supreme Court not to have been pleaded, and that mere carrying on of business by the writ petitioner Calcutta or receipt of correspondence in Calcutta were not integral part of cause of action. That's why, my lord, this happened in National Textile Corporation. What was received at Calcutta was not a part of the integral cause of action. Some letter coming is not integral part of cause of action. Here, my lord, show cause notice, order, and order of review committee. All have been, my lord, Calcutta. It's not printed there. Although in Alchemist, point of consequence of the letter of revocation was raised, Supreme Court held while affirming the order, the writ is not maintainable as none of the facts pleaded constituted cause of action. Decisions are distinguishable on facts. It cannot be disputed whether or not, that's fact. 45, my lord, Justice Chitutosh Mukherjee's judgment, my lord, in Everest Coal is quoted. My lord, just see the underline. This was also receipt of notice of deallocation, my lord. Just see the underlined portion. In other words, in order to maintain his writ application, petitioner has to establish that within the territorial limits of the court's jurisdiction, prima facie, a legal right claimed by him has been either infringed or is threatened to be infringed by the respondent. Accordingly, when the impugned act of the respondents takes place within the territorial jurisdiction of a particular high court, it may entertain the writ petition. Notwithstanding. Yes. And then, my lord, at the bottom of the quotation, another underlined sentence. Obviously, for giving rise to cause of action for filing writ petition, what is material is whether or not within territorial limits of High Court there has been any proximate or direct effect upon the petitioner. Now, my lord, see the conclusion at paragraph 48. To hold that service of an order or a notice on the addressee would never give rise to a cause of action to move the court within whose territorial limits the order or notice is received may not be reasonably good. Sound. If service of an order or a notice is an event of substance, that is an event which is material, essential, or integral part of the list connected with the action that is impugned in a writ petition, there is no plausible reason as to why the same should not be construed as constituting a material, essential, or integral part of the cause of action. The plea of affectation of right or interest by reason of such order or notice being served, if based on a substantial fact forming part of bundle of facts, would indeed be relevant for determination of the question. Here, the decision to withdraw the award and plaque from the petitioner was never communicated to him prior to public notice, and that was, my lord, with him. So, my lord, what is material is what is sought to be served to you within jurisdiction. Service. And what is being, some letter. In my case, both orders and show cause being served here. Yes. And Please, my lord, now have a look at just two judgments. One, my lord, following this view, division bench of this honorable court, my lord, in Eldine, my lord, this was a matter where, my lord, RDSO in Lucknow issued a notice to the petitioner delisting its, my lord, code or, my lord, product. My lord, the RDSO certification was, my lord, being delisted. It was argued, my lord, on the basis of Lalit Kala and several judgments that petitioners' rights are affected at registered office at Kolkata. It's a Calcutta company. My lord, just two paragraphs, 28, my lord. On the decision of the Honorable Supreme Court, case in such and such, and my lord, Lalit Kala and Madras High Court, and my lord, all other high courts, my lord, it is clear, in the middle of the paragraph, my lord, it is clear that for the purpose of deciding whether the facts averred by the writ petitioner would or would not constitute a part of the cause of action, it has to be considered whether such facts constitute material, essential, and integral part of cause of action. In order to maintain writ application, petitioner has to establish territorial limits of court's jurisdiction, prima facie a legal right claimed by him has been infringed or threatened to be infringed. Such infringement may take place by causing him injury or threat thereof. So, my lord, the writ petition is maintainable. 29, 30, my lord. And all these judgments, my lord, we tried to show, my lord, that
Yes.
all high courts, my lord, are of the same view.
Yes. Next.
Next is just in this, my lord, connected matter. Bank of India, my lord. This is willful default. Huh? This is not
Fraud. That's on fraud, my lords.
Lord, please come to, my lord. Paragraph 4, my lord. Show cause. Only the show cause. This petitioner and Bank of India. Only the show cause and the communication declaring the petitioner's account as fraud was served within jurisdiction of the Calcutta High Court. That too because petitioner number 1 has registered office within jurisdiction of Calcutta High Court. That apart, everything is outside jurisdiction. Paragraph 6, my lord, all the judgments were, my lord, cited. Same, Alchemist, Swaika, ONGC, all cited. Then, my lord, paragraph 7, in all the aforesaid matters, court consistently held that mere service of notice in registered office could not give rise to cause of action within that jurisdiction unless service of such notice was an integral part of cause of action. For the purpose my lord, the judgment is in the petitioner's matter against a bank. Argument is the same. Not included in, my lord, the respondent's compilation. Therefore, my lord, the alarm. My lord, it's an indication that a wholly relevant judgment.
Now, this court is thinking other. Today the court is very cold. Why that is siren?
My lords, I'll just clarify in two submissions, my lords. Mr. Chaudhary.
No, I haven't finished. I'm only commenting on the alarm, which is an involuntary act from your side.
No. My apologies.
Paragraph 7, my lord.
Yes,
in all the aforesaid matters, the court consistently held that mere service of notice in the registered office could not give rise to a cause of action within that jurisdiction unless the service of such notice was an integral part of the cause of action. For the purpose of deciding whether the facts averred would or would not constitute a part of the cause of action, one has to consider whether such fact constitutes a material, essential, and integral part of the cause of action. It is no doubt true, even if a small fraction, court would have territorial jurisdiction. Bank contents will not same. Everything outside, merely having registered office would not do. Now, my lord, paragraph 11, we cited, my lord, the two judgments, Eldine, the division bench judgment, and Lalit Kala Academy. Lord, paragraph 12, upon hearing the parties and on perusal of the material on record, it appears that because of the petition number 1 having its registered office within jurisdiction, all notice orders were served within jurisdiction. Right of the petition defend themselves accrue within jurisdiction. Record of the case lies within jurisdiction. Forensic auditor conducted forensic audit within jurisdiction. Same here, my lord. This matter itself. So, my lord, in this matter, what is relevant is, please have a look at, because I showed this on the last day. Please come to, my lord. What is page 527, volume 4. Just to, my lord, refresh my lord's mind, my lord. Registered office is the first address.
Yes.
Lord, 8th August 2024. Lord, please see borrower, Salt Lake. Now, my lord, if your lordship scrolls down, all the allegations are on the basis of show cause, on the basis of a forensic report. For forensic report, lordship will kindly see the judgment of the coordinate bench, my lord. It's recorded, paragraph 16 of that judgment. Lead Bank, Canara Bank, engaged a forensic auditor conduct audit of the account of the petitioner. Said audit report formed the basis of issuance of show cause notice to the petitioners for declaring the bank account of the petitioners as fraud. This audit is also, my lord, within jurisdiction, as I, my lord, showed your lordship.
Yes.
Now, my lord, please look at page 561. Declaration, same. Kolkata. And then, my lord, the review court order, which is applied at page 614. Same.
Yes.
The main argument, my lord, on the first day, I had shown your lordship, in both orders, if your lordship, my lord, has 614 open, this is the review court's order.
Yes.
My lord, no reasons are given. Review at page 616. Identification committee, then my lord, please see last paragraph of 616. Review committee have assessed the facts, material on record, including written representation, and has decided to declare the borrower and its director as willful defaulter. No reasons. And my lord, your lordships have laid down, appeal court must give independent reasons for affirming or dissenting from the view of the learned Lord trial court. Now, if your lordship sees the, I've got a judgment for that. I don't, should I cite it? Lord? Next is, my lord, learned, the first authority also, my lord, does not give any reasons.
Yes.
And that, my lord, order
Page.
your lordship will see at page 561, at page 562. One paragraph.
The first declaration on.
Yes. That's all. No reasons. So, my lord, the whole process is, my lord, it has the following flaws. Number one, it, my lord, no documents, my lord, are supplied. The procedure which your lordship also, my lord, laid down in that Hemant Kanoria matter. That recently, my lord, when it was too allowed to dismissed. My lord, in that one. But your lordship, my lord, laid down the procedure. That has not been followed. Then, my lord.
Because of the procedure, 2 has been dismissed.
Yes. My lord, there we have given notice. And we'll come back if they don't give. My lord, that no procedure followed here. Next, my lord, no reasons given in the order.
Yes.
And the most shocking part is that page. Please, my lord, come to page 557.
Yes.
My lord,
Furnish the details.
yes, as requested by you, forensic audit report has been shared on 24th September. We request you to furnish details within 15 days.
Forensic audit you received.
Yes, but then Lord, other documents, my lord, I have to write. He's given me he's in fact followed your lordship's directions. We request you to furnish details sought within 15 days from the date of hearing, latest by 9th October 24.
But where is the documents we have?
No, now, my lord, this order comes on 25th of September. He gives me time till 9th October. Now, please see the date of the order at page 561. 28th October. 1st October. First paragraph at page 561.
561 is the
Yes.
28th October.
No, my lord, please see the first paragraph.
As an order, 1st October.
So, my lord, he gave me time till the 10th to respond. I would have asked for documents. And he, my lord, passes an order on the 1st. 2 days after giving me 15 days time.
No. Defaulter has decided to classify the internal as willful defaulter and pass an order.
What is going on?
And what is this 561 communication?
Yes, my lord, it's communication. It records, and the order is at page 562. The order shows it's 1st October, page 562.
Achha.
In the meantime, my lord.
Achha, decision taken by the committee.
Yes. So, my lord, he gives me 15 days, and in 2 days he passes an order. And that also, my lord, without reasons. And then I file an appeal. Appeal court also doesn't give reasons. Judgment no reasons. Reiteration.
Yes, next.
My lord,
That's all.
Same judgments, my lord, I keep citing. I've decided not to.
My lords, may I clarify in 2 minutes, my lords, on the submissions of what So Chaudhary has already submitted, my lords.
10-13 though. Now you're confusing me. 10-13 again though. You know, I'll just you've handed up 11-4 too. Yes, no, this is my favorite, which I've cited before. 2010 13 SCC 427. Milord, show cause notice was, Milord, if your lordship remembers, it's set out again in the judgment of the authority. Milord, paragraph 22 is the show cause notice, and Milord, paragraph 24. Let me. That's Milord, show cause is bad. And Milord, it's a mere reiteration.
29 close mind.
Yes. And Milord, it's a complete reiteration. Yes. Milord, paragraph 36 also, Milord.
Yes.
And paragraph 37. Bias of the third respondent, which was latent in the show cause notice, became patent in the order of cancellation of the registration certificate. The cancellation order quotes the show cause notice and is a non-speaking one and is virtually no order in the eye of law. Since the order is an appealable order, it is an appealable one, it is incumbent on the third respondent to give adequate reasons. So, Milord, quotation of show cause in the order is, Milord, no order in the eye of law. Patent illegality. Milord, I think I shouldn't cite the same judgment.
My lords,
Yes.
my lords, may clarify, my lords, on the factual submissions what the learned counsel for the petition has submitted. Well, the sole issue which comes up for the consideration before this court is, my lords, whether the petitioners who are the guarantors before this court can rely upon the registered office of the company who is the borrower to seek territorial jurisdiction before this court or not. This is the sole issue, my lords. My lords, as far as the company is concerned, my lords, company is a borrower. Company is a separate legal entity, my lords. Company is not the petitioner before this court. Company being a separate legal entity, my lords, they cannot seek the reliance of the registered office of the company to seek territorial jurisdiction of this court, my lords. Secondly, my lords are very well aware, my lords, proceedings against the borrower and the guarantor are independent to that fact, my lords. The lender has a separate right to initiate proceedings against the borrower and guarantor. Since the company is not a petitioner before this court, the petitioners are primarily the guarantors before this court who are having their addresses in Bhubaneswar. Despite the fact that the company may be having an address in Calcutta, not being a petitioner before this court, the petitioners cannot take territorial jurisdiction before this court. This is my first submission, my lords. Second, my lords, the company being a borrower here, my lords, is also under CIRP by virtue of an order passed by the NCLT by order dated 26 September 2025, my lords. I am also supplying a copy of that order to this court, my lords. Company is under insolvency, my lords, and my sole purpose of submitting this court to this, my lords, when a company is under insolvency, my lords, Section 17 of IBC comes into the picture, my lords. Section 17 categorically states that the rights of the directors are suspended, my lords. When the rights of the directors are suspended, my lords, they cannot seek also the reliance of the registered office of the company to seek territorial jurisdiction before this court, my lords. In a way, my lords, my friends have factually admitted that they are having the registered office of the company in Calcutta, but the petitioners' addresses are in Bhubaneswar. The proceedings against the petitioners are initiated in Bhubaneswar. So notices have been served in Bhubaneswar, my lords, and entire order has also been passed in Bhubaneswar altogether. But noting that fact in my lord, company being in insolvency, company being a separate legal entity, and by relying on section 17 of IBC, my lords, I submit to this court, my lords, the petitioners cannot seek territorial jurisdiction before this court by relying on the registered office of the company, who is a borrower and who may be having territorial jurisdiction before this court, but not a petitioner before this court. My friends have relied upon Bank of India judgment passed by coordinate bench, my lord, Justice Sinha's judgment, to seek to submit before this court. In relation to that judgment, my lords, what my friends have cited, that judgment, my lords, company was the petitioner, my lords. Since the company was the petitioner, my lords, therefore, the court had entered in that. My lords may see the cost title. It is indicated Gupta Power Infrastructure Limited versus Bank of India, my lords. It is not the case here. Here it is the case, my lords. Mahendra Gupta, Kiran Devi Gupta, Jitendra Gupta, and Abhishek Gupta to be the petitioners, not Gupta Power, my lords. Therefore, my lords, the petitioners do not have territorial jurisdiction before this court. This is my broad submission.
Thank you. Just one clarification. If you please see the order, it says company and petitioners and its directors.
Okay.
So it clearly says that.
Co-petitioners are there.
Registered, yes, a company and its petitioners. And forensic audit report is challenge writ petition before my lord's court. So my lord, all other consortium banks, they've already, my lord, fraud, all before this honorable court, jurisdiction point taken, gone. So only this matter will go to Odisha. All other matters will be in this court. So this is, my lord, my submission.
By that time, my lords, company was not under CRB, my lords. When the application writ petition was filed before this court in November 2025, the company was admitted to CRB, my lords, by virtue of an order dated 26 September 2025, my lords.
Okay, thank you.
Grateful.
Grateful.
Hearing concluded, CM. Next.
My lord, I'm sorry, just one. I should have said this in answer. My lord, when the order is served, that is the relevant date of cause of action. Petitioner was here. Company was not in CIRT. My learned friend should have said that. September 26th September 2025 is the date of the company going into CIRP. My lord, and on the date of affectation of petitioner's right, the three things, the two orders and show cause notice, company was under control of petitioner, operating from Salt Lake, registered office, petitioners were here.
Next.
My lord, I am appearing for Reserve Bank of India and Banking Ombudsman.
Last occasion, your lordship heard this matter. But here, without following the due procedure of law, my lord, by bank action.
Yes, who is for the bank?
And I'm for the bank, madam. Before my learned senior friend comments his submission, my
No, my point is very simple. Last occasion, I also indicated, my lord, now the Kerala judgment and Delhi judgment, my lord, clearly says, as per the new BNSS, 107 and 108 has to be complied with. And magistrate, magistrate has to pass an order regarding freezing of the bank account. That has not been done. Subsequently, these two orders was challenged before the Supreme Court. Supreme Court dismissed the SLP and uphold the view of the Kerala High Court.
Yes. On the last occasion, my lord was pleased to direct me that at the bank to file a report. My lord, I tender my unconditional apology for my personal difficulty. I could not prepare that. But my lord, I am not standing in the way. My lord, I have faced some document from the client, my lord. I have also advised that they could not have freezed the account, my lord. And my lord, I have instruction that order may be passed that the account may be freezed, my lord. Yes. Being an officer of this court, my lord, I should not say anything more.
My lord, so far as Banking Ombudsman is concerned, when they lodged the complaint, and the complaint at the time of disposal, we had very clearly indicated that what had fallen from the regulated entity, the bank concerned.
Yes.
The bank had said that they have acted on the basis of the order which was passed by Indian Cybercrime Coordination Center, which is established by the Ministry of Home Affairs, I'm sorry. And that too because it was available in the portal of the National Cybercrime Reporting Portal. And on the basis of the information and order, bank had acted. And when this order was communicated also to the petitioner, which is available in the closure of the complaint, the Lordship will find the date 16th of April 2025. Whereas the petition was filed prior thereto on 10th of April 2025. So after coming to know about this order also, they ought to have come and they ought to have made the necessary amendments by incorporating them as party, because the relevant order was passed by a third party which is not before your lordship today.
Okay.
Those are my respectful submission.
Yes. The petitioner has filed the presented application, praying for a direction upon the respondent number 2 and 3 to take appropriate steps for defreezing the account of the petitioner. Police. The petitioner submits that the petitioner is having the saving or current?
My lord,
saving account or current bank account?
Current bank account.
And only, my lord, there are certain amount lying in the account which are subject matter of certain suspicious cyber complaint, my lord. Keeping that amount aside, my lord.
That let them take appropriate steps in accordance with.
But I have a bank. How can I?
Yes,
I can only keep aside that amount. That amount.
No, you cannot.
You can
You
take
cannot.
the seal from the court. You
cannot.
take appropriate steps. Because this is only with regard to defreezing, not
Yes,
with
yes,
regard
yes,
to the amount disputed.
My
You take steps. क्या बोला? Having the current bank account with the Axis Bank, Kolkata Regional Office, Kolkata, Axis Bank. Huh? Which bank? Kolkata?
Yes, bank.
Yes Bank.
Yes.
Yes Bank, Kolkata region.
Yes.
Kolkata.
Yes, bank. Yes.
Kolkata. Police stop. The petitioner. No. How many petitioners are there?
My lord, there are, my lord, five
Five.
company and 6 is the, my lord, the director of the company.
Petitioners are maintaining altogether 5 accounts in the said bank, 5 current account in the said bank. Full stop.
My lord, kindly mention the name of the, my lord, the petitioners also.
क्या बोलना? Namely, Xenixt, Xenixt Technology Private Limited, having the account number 1215277 7 times 0 41. Then Zenith Agrotech Private Limited, having account number 1215270000011. ठीक है? Then Zenith Marketing Private Limited, having account number 1215227 6 times 0 or 7 times 0 31. Then Zenith 21. Zenith Industries Private Limited, having account number 21, and Zenith Medical Service Private Limited, having account number 61. Full stop. It is the case of the petitioner that on 9th of October 2024, the petitioner number 6 was informed by the respondent number 3 that the bank account of the petitioners have been frozen. Accordingly, the petitioner has made a request to the respondent number 3 to defreeze the said account for the purpose of a smooth transaction of the business of the petitioner, but in spite of the receipt of the request made by the petitioner, the respondent number 3 failed to defreeze the said account. Accordingly, the petitioner has made a request to the Reserve Bank of India, but the Reserve Bank of India also passed an order on
3rd of June 2025.
3rd of June 2025, holding that the complaint is closed under clause 16 within bracket 1 within bracket A, read with clause 10 within bracket 1 within bracket A of the RB-IUS, 2021, as the dispute in which action is initiated by the regulated entry in compliance of the orders of the statutory or law enforcing authority. And as such, they have not passed any further order for defreezing the account of the petitioner. Finding no other alternative, the petitioner has filed the present writ application. Full stop. By an order dated 11th of February 2026, this court has directed the bank to file report, but learned counsel appearing for the Bank submitted due to some inadvertence, the bank could not file the report, but he submitted they have not received any order from the court for freezing of the account of the petitioner. But why you freezed?
My lord, they are supposed to freeze that only that amount that for which the suspicious transactions was done.
Police, the bank has found some suspicious transaction in the account of the petitioner. Accordingly, bank has freezed the said account. Police. The learned counsel appearing for the petitioner has relied upon the judgment passed by the Kerala High Court in the case of
But should I keep the judgment?
Headstar, this one, no? Headstar Global Private Limited versus State of Kerala, passed in criminal CRL miscase number 3740/2025, dated 2nd June 2025, wherein the Kerala High Court has considered the question whether the bank can freeze the account of the parties, and the Kerala High Court held that paragraph 13 and 14. Okay. In the present case also, full stop. It is not the case of the bank that the bank has received any information from the investigating agency for
Yes, ma'am, they are.
Yes.
no, not received any document from the investigating agency that the investigating agency has received has obtained any order from the court under section 107 and 108 of the BNSS. The bank has seized the said account of the petitioner only on the basis of the information received from the investigating agency. Full stop. The petitioner has made the party. No, you have not sent the notice to the investigating agency.
We do not know who is the investigating agency.
No, that is indicated.
No,
That is indicated in the complaint, in the closure of
they
the
are saying
complaint
ACC
also.
RP portal.
No, that specifically says that they have
What
received.
instruction you have received?
My lord, it is there in. Okay, down the court.
No, nothing. No case has been registered. How they can freeze it?
No, क्या बोला?
These are the cases, my lord, we have received from the Ministry of
Full stop. It is the case of the bank that bank has received an instruction from the MHA portal through NCRP, and accordingly the bank has seized the same. But you have to meet the party here.
That is what my submission was before your lordship, that when they were apprised of.
Portal.
Because
No, not portal.
Not portal,
The
sorry.
concerned authority, MHA, which is Ministry of Home Affairs, Indian Cybercrime Coordination Center. The order was passed
That
by
is not
this
the investigating agency. Only the agency can go and ask for an order under section 107, 108.
Sometimes what's happened nowadays.
Now, kindly see the Kerala High Court's last para.
That's how you
Kindly see the
quoted.
last para,
That
what
how
it
you
says.
quoted. But with regard to
The
because
last para.
no, here is the part. They are not the party. They might have been obtained the. They might have been obtained the report from the.
It cannot be. That is the reason when I'm telling you, Lordship, kindly see the last para once.
Yes, another aspect of the importance which section 22. In
Para
the
22. In the light of the frequent filing of the matters concerning blanket freezing of the account as court feels, Ministry of Home Affairs, Government of India should take positive steps to address the same. It may consider the consulting all the stakeholders, including the respective state duty and the so-and-so to the union policy, standard operating procedure and guideline to ensure the matters handled with the requisite consideration and compensation.
No, that's correct. But you have not made a party. If you made a party, notice is sent. Then the question arose for deciding that. You do one thing.
As your lordship,
you made a party, send a notice. That will be better. Otherwise,
Then all the other matters also similarly placed, your lordship had done that.
director, because in all matter, what are your
as your
order?
As in when they don't appear, then your lordship disposes of
As
the
your lordship,
writ petition.
Kindly give me the liberty to make them as a party.
This court find that the bank has taken a specific. This court find that the bank has freezed the account of the petitioner on the instruction received from the MHA within bracket 14C portal through NCRP acknowledgement number 31308240047031. ये सब दिख लेना. ठीक है. Considering the above, this court find, but full stop. This court find that the petitioner has not made the MHA as a party. MHA as a party. And as such, before passing any order, one opportunity is to be given to the MHA who has instructed the bank for the freezing of the account. Accordingly, petition is directed to implead the MHA as a party to the present date application and serve the notice to the added respondent intimating the next date of hearing. Please the matter next date of hearing and to file affidavit of service on the next date fixed. It is made clear that if on receipt of the notice, if the added respondent failed to appear before this court and to file any report, under what circumstances the instruction has been given to the bank for freezing of the account, this court will pass appropriate order.
Can you give the name?
Let the matter appear. Today we are on 16. So 5th of March.
As your lordship.
5th March under the same heading.
March.
now तो बोला तो डायरेक्टेड टू फंडिंग ना ऊपर बोला ऐड ऊपर बोले according petition director is granted due to made a party. Yes, next.
Order has been complied with. But I am for the CISF. But just one problem we are facing, I need to tell it to your lordship. But pursuant to your lordship's order, my lord, we have already handed over 8 rooms from the school. But total 130 CISF personals are there. And this posting was done pursuant to the direction given by the Supreme Court upon the state of West Bengal. Now, state of West Bengal is not giving us a accommodation, separate accommodation. 130 people in 10 rooms. Your lordship, now we are lying in the veranda. Your lordship can understand the situation. But kindly take care of this situation so that the state can provide us adequate place so that the Supreme Court's order can be complied with.
Yes, Mr. Singh.
Otherwise, state is maybe directed to release us and intimate to the Supreme Court, because this was done in terms of the direction of the Supreme Court. Your lordship knows the Arjikar rape case, and that is the reason Justice Chandrachud has directed the posting of CISF, and state will take all responsibility, including the accommodation. Now, this is the kind of accommodation they are giving. 10 rooms, 130 people. Your lordship can understand the situation. They are lying in veranda with their guns and ammunition.
Yes.
I want to be disposed of the with an undertaking that which date they will vacate the entire.
There is a report.
Kindly take care of the situation now. Until and unless they give us a alternative accommodation.
Why?
Veranda belongs to me also. So I am not complaining about that now.
Mr. Sen, when you will vacate the premises and make necessary arrangement for I am not on vacating. When you make necessary arrangement for
necessary arrangement will be made. My lord, my learned friend, my lord, he may not know, my lord, or may not in his knowledge that actually, my lord, what happened during these proceedings. My lord, we have filed an affidavit before your lordship and we prayed for some time. It is not that we shall not vacate, we cannot say all these things. An alternative accommodation, my lord, we are looking for, we are, my lord, searching for. I think that will be, my lord, available within a 2 or 3 months. My lord, almost, yes. Just a minute. তুমি আটকে উঠছো কেন? ভয় লাগছে তো already respondents has fallen flat. So now, my lord, now my lord, in the midst of the, my lord, the hearing of this matter, when my affidavit was taken by your lordship, or the report was taken by your lordship, and when my lord was was about to grant some time, and my lord, it fell from your lordship that only 2 months gone. from the affirmation. At that point,
That's why I'm asking.
at that
you
point of time, Lordship, kindly.
very outset, I
But
am asking.
at
how
that
much
point of
for-
time, all on a sudden, my lord, they approach that because of their, my lord, the ensuing the New Year's, so they can, so that they can, my lord, because of their festival, they want some rooms. Immediately, my lord, on the basis of that, my lord was kind enough to ask me to whatever can be done. My lord, the letter that was, my lord, written to the CISF personnel, the commandant, and commandant said yes, for 7 days, out of 18 rooms, 6 rooms can be vacated for 6 or 7 days. That was the, my lord, the letters exchange between the, my lord, state and the, my lord, the commandant. Now, my lord, when it appeared before your lordship on the next day, that whether actually handed over or not, my lord, on behalf of CISF, they yes handed over. We also inform. They say no. At this juncture, my lord was kind enough, my lord, to appoint the special officer. Now, eventually, it has been done. 6 rooms, my lord, or 8 rooms already handed over. Now they are occupying 10 rooms. Now, if it is possible, lordship, kindly, that after that, because the order was passed on this basis, this temporary order, that for 5 or 6 days after the, my lord, it is over their celebration, let that be again, my lord, handed over for a limited period. After that, entire, my lord, the school will be vacated by the state. Lordship, my lord, it failed from a lordship. And so far I recollect that once my lord said that maximum 30th April. My lord, we agree to this. 30th April is the, my lord, the last date. By that time, my lord, we shall vacate the entire premises.
Okay.
But
Undertaking may be given to the lordship so that I can proceed further.
yes. Yeah,
And
this
an
is
undertaking on affidavit may be given to a lordship, the 30th April, the last date, they will vacate it. That should be on record. So that you
And
can
my lord,
take further.
there is an
one
affidavit
more
also.
thing,
That is
my lord, their requirement for 6-7 days. Until 30th of April, let us, my lord, stay in that premises.
Lordship,
up
kind.
to 18 rooms. And after April, my lord, let the state take adequate steps
That
to
we take.
remove us. But kindly record that also.
But
They
whatever
will
we
be
have
relocated.
received, my prayer will be, let us be.
No, that prayer was made. That prayer was made
Mr.
because
Basu,
of that
Mr.
their
Basu, after
New Year.
after all, they have the BSNL, they are the defense personals, correct?
They are in
We
very
have to-
difficult,
we have to
shortage
give
position.
some
Yes.
respect to them. So now, when only I will say, let we remain in the premises, as they should not face any problem to be there. And I am recording the undertaking of Mr. Sen that they will vacate the premises on 30th. So before 30th April, I am fixing the matter before this court, what the steps they have taken. Let they file the report in the mid of March, what steps they have taken. Let it, because
And my lord, one
নাহলে অসুবিধা হবে, সকলকারই অসুবিধা হবে। তোমাদের স্কুল তোমাদের থাকবে তো, স্কুল তো নিয়ে যেতে পারবো না, তোমাদের স্কুল
In
তোমাদেরই
law,
থাকবে।
whether a single day this can be accommodated.
আরে our law.
That's correct. That's why I'm asking with regard to they are the defense personnel. We have
No,
to.
that is separate thing. That's why on the very first date, I don't ask your lordship to give it entirety. I could have asked for that. I have not.
That's why.
But
For humanitarian ground.
Because they have been brought some out of place. They are not there. So and they are
not outsider. They are defense personnel. I am not
that's
problem
what
with that.
not
But
outside
the
of it
state
because
government-
out of the state.
Maybe, but they are also the part and parcel of the India.
Correct.
So
Correct. So
the state government should accommodate in a proper place.
that's why what now you have seen my attitude on that day, but
I can, my lord, don't record my concession. It is lordship's order, but I want an undertaking by a competent person.
okay, Mr. Sen, we do one thing.
Secretary of the department
Do one
should
thing.
file an
So,
affidavit. Undertaking.
So when you file the undertaking from your secretary home, let you file the secretary home by 30th April. You will vacate. I will take on that and I will allow.
My lord, my lord.
When you will file the affidavit.
My lord, আজকে কত তারিখ 16 my lord, affidavit 17-18 by 19th
And my lord, one request, my lord, after their festival is over within 7-8 days, let us accommodate in the same premises. Let us accommodate.
That's why. That's I'm telling because they are asking 7 days.
I understand.
So let's on today we are on 16.
Hmm.
When 19 or 20 or 23, whenever how soon we will file, then they will be allowed to be in the, enter into the room and to
19,
have a good sleep.
19.
19.
After tomorrow.
হ্যাঁ আজকে তো 16 না
Mr. Sen is there and everything is possible.
19.
It will work.
That's why.
I also applied that medicine and it works.
The a special officer submit that. And in terms of the order passed by this court dated 13th February 2026, 8 rooms were handed over to the petitioner for celebrating Chinese New Year. Full stop. Learned Counsel appearing for the Union of India submit that though the CFSL persons have vacated the 8 rooms, but 130 CFSL persons have been accommodated in 10 rooms, due to which they are facing difficulty and they are sleeping on the veranda of the room. And as such, he submit that if the festival is over, and unless the state government make necessary arrangement for alternative premises, the CFSL persons may be allowed to continue in the other 8 rooms. Full stop. Learned Counsel appearing for the state, Mr. Amar Kumar Sen, Learned AAG, appearing for the state, submits that he submits on instruction that the state government will take necessary steps for accommodating the CISF personnel in the alternative premises.
On instruction, Lordship. On instruction.
I recorded. Alternative accommodation by 30th April 2026. In view of the above, the state government is directed to file an affidavit through an responsible officer stating that the state will take necessary steps for accommodating the CISF personnel in the alternative premises and will vacate the premises of the petitioner by 30th April 2026.
One thing, my lord, as soon as the program is over, let us.
That's why 19 I fix.
On that date, after
Let
undertaking.
the matter appear on 19th, full stop. Let the affidavit be filed on 19th of February 2026 after serving the copy to the Learned Counsel for the petitioner. List the matter on 19th.
Lordship, kindly, my lord, keep it at 2 p.m. Lordship, kindly.
19 देखो 12 बजे है क्या?
না না আমাদের তো কমেন্ট লাগবে
Slot আছে কিনা? Nowadays this is very difficult to find
this
the
matter
slot.
will not take much time, I think. আমাদের কোনো এখানে তো কোনো আর্গুমেন্টের স্কোপ নেই
12 बजे है।
We to argue the matter.
है ना? ठीक 1 PM I am keeping.
Yes, a short matter, it will hardly
1
take
PM I
5
am
minutes. Yes,
at 1 PM.
Deep.
I have an apprehension the adjournment will be short, because undertaking is something else, not filing affidavit only.
Experience, man.
I think so.
File an affidavit by way of an undertaking.
Undertaking, that's the main thing.
File an affidavit by way of an undertaking.
Grateful. 14. But not saying that the secretary of the department should file.
Responsible person of the
Kindly
state.
make it secretary of the department. My lord knows the
Okay,
court judgment.
Secretary. 14, who is appearing?
My lord, I am for the petitioner, my lord.
You got the?
My lord, the petition.
What is the prayer?
Paragraph 2, can you have a look at it?
Issue written on their man and agent particular respondent commission to treat the EWS candidate in connection with. Yes, paragraph?
Paragraph 2 of the petition, page 2.
Yes.
My lord, this matter.
What is a prayer?
My lord, prayer is to treat the petitioner as EWS candidate and give benefit accordingly, my lord.
Yes, EWS, not.
Can you see the averment because of the non-functioning of the West Bengal Advocacy Tribunal? They have been compelled to move this honorable court.
Yes, my lord.
First 2 lines.
Already, my lord, in this regard, coordinate bench decide the matter whether there is, if there is urgency, my lord, the High Court can hear, my lord.
Before the honorable judge taking up the group 6 determination.
No. What is your prayer?
My lord, to treat the
Pray
petition,
for an appointment.
to treat the petitioner as
No, service, it is correct. Service matter, but their prayer is with regard to the EWS certificate. Her candidature is to be considered as EWS. With regard to the EWS and all these things is the group 9. This is not asking with regard to the. Yes, what is your submission?
my lord, the
Can I release?
My lord, if they have object, my lord, how can I, my lord can have determination.
Can I release? I am releasing, no problem. The court has no interest to any of the matter.
My
If
lord,
the party
kindly
will
hear
say
the
it
matter, my
release, I
lord,
will
because
release.
there is some urgency, my lord.
So what do you want?
My lord, the petitioners.
If you satisfy this court is having determination, this court will continue. If
Yes, your lordship.
if will
My
not
lord,
satisfy this court, this court is not having determination. As per the respondents, so I will release the
yes,
matter.
my lord.
So
My lord, the respondent commission has, my lord, published one notification regarding the appointment of the, my lord.
What is the post?
West Bengal Civil Service Examination 2023.
Correct.
My lord, the petitioner participate in the selection process. My lord, initially they have not included the EWS category. After that, my lord, kindly come to page number 26. By an addendum advertisement, my lord, they have included the EWS category, my lord. As per this advertisement, my lord, the petitioner upload his documents, my lord, which is at page number 28. My lord, the petitioner mentioned her categories are EWS. Later on, when the interview later come to the petitioner, my lord, he found that no EWS mentioned in beside her name, my lord. Kindly come page number 37. My lord, bottom, my lord, 11. My lord, the Sotto Sadhon Mondol, the instant petitioner. My lord, beside her name, my lord, no EWS mentioned. At this point of time, the petitioner came to know that her EWS candidature has not been considered, though petitioner upload his documents.
You are having the EWS.
Yes.
But not considered.
Not
Yes,
considered.
Go to the other court.
There is some urgency, my lord. That is why, my lord.
This court find that this court is not having the determination. This court find that this court is not having the determination according the WPA number so is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination. No, if regarding only issuance of EWS certificate, it can be, but your candidature has not been considered as the
Yes, your lordship, because my lord, there is.
and this court can. No, that's correct. No, I am telling you. Thank you.
Yes, your lordship.
Next.
15, I am for the WBACDCL lordship. Respondent number 3.
Why before this court?
I am appearing, my lord. My here respondent number, I don't know whether the respondent number 1 and 2 has been served or not.
We have served, my lord. If it is served. My lord, because we are challenging an office order, I'm sorry.
What is the prayer?
My prayer is, my lord, an office order issued by WBACTCL by which they have prevented me from participating in any tender if there is a litigation pending before, my lord, any forum. I'm challenging that, not a tender, because in terms of this, my lord, they have issued tender. My lord, I participated, I was disqualified because of this office order. This office order is what is under challenge. My lord, kindly take up this office order first before I go into the facts. My lord, page 375. And then I'll go in the background, my lord, as to why I am aggrieved by this.
Yes.
My lord, page 375, kindly see, my lord, issued by West Bengal State Electricity Distribution Company Limited, dated 8 September 2025. My lord, subject is incorporation and redesign of forms in e-bid technical proposal. In compliance with the recent amendments in the revised purchase policy of WBACDCL, the following new forms have been incorporated in the e-bid technical proposal for mandatory submission by bidders. Form 9, Form 10, I am agreed by Form 11. Form 11 is, my lord, declaration
regarding no litigation against WBACDCL. So I have to give a declaration that there is no litigation. Now kindly see what has happened. My lord, for years I have worked for them. My lord, they have given work orders. I have delivered. Money is due. I am an MSME entity, my lord. I have initiated conciliation proceedings. It has failed in Bhatinda. It has failed, my lord. Now it is an arbitration proceeding. I have filed a section 29A there in Bhatinda. Arbitration is pending. Now, my lord, I cannot proceed in participating, my lord, in other tenders because they say you have initiated a litigation against me. Money is pending 44 crores. Look, they have not paid 44 crores for which I am litigating. I am an MSME entity. I'll show those documents, but this is my case, and this is why it is before your lordship. It's not an electricity dispute.
No, I
This
haven't said
dispute
that,
is-
that it's a electricity dispute.
No, I'm only
I
indicating.
never,
But
never
no,
said
of course,
that.
Of course,
No,
it's
no,
not
the
that.
court was of the view.
My lord, I am only, my lord.
So why, how this,
This is
I
the
will
dispute.
let my learned friend complete. I will
Lord,
certainly satisfy you.
I will quickly indicate what the, my lord, facts are. Your lordship will take up
no, it's
page.
okay. Let you satisfy.
Lordship. Here,
May I only, before my learned senior friend starts, may I only indicate, I have not indicated, my lord, the copies of the work orders which has been placed over the years, my lord, from 2012 till 2025. They've issued work orders. We have carried out the work. May I quickly indicate in 5 minutes, my lord, then I'll not trouble my learned friend. My lord, kindly take up page 33 first. This is, my lord, the registration that we have in the GST regime. And, my lord, page 36 is the MSME registration, my lord.
33.
33 is, my lord, the GST registration, and 36 and 38 is the MSME registration. 36 and 38, my lord.
Yes.
We are an MSME entity, my lord. This is, and the type is the first line in page 38, medium enterprise.
Correct.
Now, my lord, kindly see page 40. And the reason I'm indicating this, show me the MSME Act, that the payment has to be made within 45 days. My lord, page 40 is the work order which was issued.
Yes.
In the year 2012. Top right hand corner, my lord, 27 September 2012. Kindly see the subject. Order for manufacturing, testing, supply and delivery. Distribution transformer against tender, this due on this. So this is what we deliver. We manufacture this and we deliver this. Now, my lord, relevant documents, kindly see page 132 onwards, volume 2, my lord, of the writ petition.
Page.
My lord, all these work orders I'm not going by, my lord. All the work orders are serially annexed. Page 132, volume 2, my lord.
Yes.
My lord, this is the auditor's report, my lord, where we have stated, we have calculated, my lord, all the balance sheets are there. First one I'll show, page 142, my lord. This is March 2024.
Yes.
My lord, amounts due from my learned friends. I'm only indicating this and not trouble your lordship. All the audited accounts are there to show that there's a huge outstanding from, my lord, WBACDCL, almost 44 crores, for which, my lord, in terms of the MSME Act, your lordship will kindly take up section 15 of the MSME Act once. It provides that after delivery, 45 days is the time limit. If they don't, then, my lord, the subsequent sections come into operation where they are bound to give me the money along with 3 times interest. That's the MSME, my lord, Act.
Section 15.
My lord, section 15.
Yes.
Then section 16, read together, my lord.
Yes.
And this is, my lord, the 3 times interest rate. Now, my lord, page 212, volume 2.
Now, what you are for 142, what you want to show?
My lord, these are the records in the balance sheet, my lord, we have indicated. This is the balance sheet, 2024 balance sheet, where, my lord, we have shown that this is amount are outstanding, but I'm not troubling your lordship because of this reason. My lord, kindly take up page 212, because that issue is pending before, my lord, a separate forum. So I'm not troubling your lordship, and that forum I'll quickly indicate. Page 212, my lord.
Yes.
Can you see top, my lord, before the Micro and Small Enterprises Facilitation Council, Chandigarh.
Yes.
This is the conciliation proceeding, my lord.
Yes.
Can you see the claim there, my lord? Claim petition, the first page, bottom. 2 crore 38 lakhs.
Yes.
And this, my lord, has the next document, if your lordship kindly takes up, page 222.
Page?
My lord, 222.
Yes.
Again, at the bottom, your lordship will find 3 crore 29.
Yes.
The claim. Next, my lord, is 232.
This is also concealed.
All conciliation proceedings, my lord.
Yes.
And the, my lord, here the claim is at page 238. Your lordship will find 8 crores. Page 238, paragraph 17. 8 crores odd, my lord.
Yes.
And the next, so my lord, these are the conciliation proceedings. These have failed. So now, my lord, kindly take up page 239.
Yes.
Now is the arbitration proceeding, my lord. And since we are going out of time, we filed a petition under section 29A of the Arbitration Act for extension of time. Your lordship will find that from the district court cause list at page 239.
Yes.
The subsequent page, page 240. At the bottom, your lordship will find
page
240, my lord, at
Yes.
the bottom.
Yes.
Application under section 29A.
Correct.
This is pending, my lord. So this is my claim.
Yes.
And my lord, this is my learned junior's right. So this is filed page 252. And the affidavit page, your lordship will find that this has been filed on 26 December at the bottom, my lord, at 252. 26 December 2024.
Yes.
So this is before, my lord, the office order. Now with this pending adjudication, now comes, my lord, the impugned office order, which is, my lord, volume 3, page 375.
Yes.
And with this, my lord, kindly take up two things. At the bottom, your lordship will find at page 375. This is as per resolution taken in the 133rd meeting of the Board of Directors of WBSEDCL held on 12th August 2025. And this form is at page 378, my lord. They have given the pro forma form at page 378.
378.
Page 378, my lord, form 11.
Achha, this is the
This is the pro forma, my lord. On the bidders letterhead, declaration regarding no litigation against WBSEDCL.
Yes.
We hereby declare that no legal litigation, I do not know legal litigation or arbitration, because the arbitration is pending or ongoing against WBSEDCL in any court or forum against or by the bidder or its sister concern, director, partner, proprietor. So they have hedged that even if there's a due, you can't file. If you do file, if you're contesting, then you can't participate. So it violates Article 19(1)(g), Article 14 and 21, my lord.
Which one?
Lord, I am not troubling your lordship with, my lord. Of course, it's the Contract Act, the provisions of, my lord, 28, because they can't really stop me from, my lord, entering into a contract where there is a clear option that you can't approach the recourse to law. So that itself will render this as, my lord, a violation. Kindly take up section 28(1), my lord, agreements in respect of legal proceedings, void. So my contention is this is hit by section 28.
28 of MSME.
The 28 of the Contract Act.
Contract.
27 and 28, both, my lord. 27 is agreement in restraint of trade, that's void, and 28, my lord, agreements in restraint of legal proceedings, void.
Yes.
So I am submitting that, my lord, they are acting in clear violation of the statutes. That itself, my lord, renders the action as illegal in law. I am not troubling your lordship with any case laws at this stage, my lord. If my learned friend, my lord, indicates anything specific, I'll come up with judgment. Lord, may I also file the affidavit of service? We can file this later. This is my submission, my lord.
Yes. I don't know whether they have, since they are saying that they have already served the state government as a Union of India, since they have challenged these notifications. Now at the outset, but there are the issues what my learned friend is saying, challenging a purchase order. But there are several purchase orders. This is one ancillary to that purchase order, where specific there is a purchase order where this a fresh purchase order has been issued. Now my learned friend is taking plea under section 28 of the Contract Act, which with deepest respect is not applicable in the context of this case. My learned friend has submitted
if your lordship kindly come to the first volume of this writ petition at page 36. My lord, my humble submission before your lordship, this is a court of equity. One who seeks equity must come in the court with a clean hand.
Correct.
Now, in this paragraph, first of all, I am drawing your lordship kind attention to paragraph. That is at paragraph 15. Lordship, kindly give me a moment. Paragraph 15 of the writ petition.
Yes.
Your petitioner states that the respondent have failed to consider the registration certificate. I am asserting on that. Kindly take note on that. Of the petitioner as a MSME unit through the Uddam registration is valid, and the respondent number 3 and 4 being the W have placed order with the period for manufacture, testing, supply and delivery of different types of what is the work for which he has been registered, lordship. Kindly take note on that. MSME, that is for the manufacture, testing, supply and delivery of different types of distribution transformer at the rate and the terms and conditions stipulated in separate purchase order on and from 2012 till 2025. Now kindly take note from 2012. Now according to him, my learned friend, he has submitted that he has been registered since 2012. Kindly come to page 36 of this writ petition.
Yes.
That's why at the outset I submit this writ petition should fail for suppression of material fact. Kindly come, and I will show their conduct also. Kindly come to page 36.
Yes.
This is the Uddam registration certificate. Kindly tally this. What my learned friend has submitted. Kindly tally this with this.
May I have a copy?
And তোমার কপি দিচ্ছি দাঁড়া পরে দিয়ে দেবো তোমার কাছেই কপি আছে lordship kindly come on the bottom serial number. Lordship got that?
Yes.
Serial number, manufacture of electric motor generation, NIC manufacturing activity. Lordship got that? Now kindly come to next column. He has been registered on 30/5/2017. Now his claim is in 2012 to 2017. At that juncture, he was never coming under the purview of the MSME Act. And deliberately and willfully, he is trying to suppress the material fact, specifying the date. Kindly see the registration date 30/5/2017.
Correct.
But in the writ petition, interestingly, this date is missing. Kindly see.
No, in 36, they have, this is all the Uddam registration
Yes.
certificate.
Yes.
Now kindly come to the middle.
Yes.
Date of incorporation, registration of the enterprises 10/2/2007. 10/2/2007. Then commencement of.
That is the registration. That is, lordship, with deepest respect. That is the registration GST.
Correct.
Yes, but so far it is for coming under the purview of the MSME Act. He has to register before the concerned Uttok authority. That has been.
So this is the Uddam registration.
Yes, but when he has registered, kindly see the writ petition. In the writ petition, here in the last column, he has deliberately, the date he has not annexed. Kindly compare with the document which I have submitted before your lordship. That is, the date is missing, and that's the best reason for them, because their claim is from 2012 onwards, and so far up to 2017 they are not coming under the purview of MSME Act. But this is the first contention, with deepest respect. So one who seeks equity must come in the court with a clean hand. And very interestingly, deliberately and willfully, they have suppressed that fact. Till date, before the authority, they never submitted any document where they has been registered concerning these activities, that is the manufacturing of electric distribution. Nothing has been submitted before the authority that they has been registered prior to 35/2017.
35?
35/2017. Lordship, kindly say activity type added on.
Correct.
35, Lordship got that?
Yes.
35/2000. So their right accrues from 35/2017. And their claim, they are saying they are coming under the
So you're relying upon one document.
Lordship.
That you file the affidavit.
Yes, yes, certainly. And the second contention is that,
Yes.
if your Lordship kindly see, we have got the 7, we never acted contrary to the provision of MSME Act. A standing committee has been already created by the WBACDCL, keeping in view of section 15 of the MSME Act, specifying that whatever the legitimate claim they have, they could have placed before the standing committee, and that has to be dealt with by the standing committee within a period of 45 days if they have got the legitimate.
See, that all the things is with regard to the claim of the
Claim.
petitioner. The court is not going to decide the claim that is pending before the authority, and you can take all the decision. Now here only the question with regard to, okay, you have raised one legal question, this certificate is not, and with regard to the how you can impose the condition that
Lordship,
how you can impose the
because
condition.
what happened, your Lordship?
Show me the law that
I will show. This WBACDCL, your Lordship knows, is a public utility company.
Maybe.
And this public utility company, there are certain hassles we have faced.
Correct.
That for that they withhold certain things, and for which there was a power cut everywhere. Correct. It is not that for the particular this petitioner we have issued this purchase order. This purchase order has been issued from 2012 onwards.
Correct.
And from 2012 onwards, in 2025, we have issued several purchase order. I am showing to your Lordship.
That's correct.
Yes.
Again, I am asking you. You issued the purchase order. He has submitted the fraud document, misleaded the authority. That this court is only the question is that how you can issue this letter.
This letter. This is not the letter. This is the purchase order. In previous, there was in 2025 on 8/9/2000 purchase, a fresh purchase order has been issued.
Now that's why how you can incorporate even the purchase order, you leave the purchase order.
Yes.
How you can incorporate this?
That no legal proceeding.
Legal proceeding can be.
It is not here only. That's why I said that the Union of India is very much important here. Because in Telangana, as well as in Maharashtra, in Odisha, similar type of purchase order has been issued for the protection.
Maybe they are not challenged. Now here it is the challenge. They are not challenged. You show me that this condition has been upheld by the court. I will throw the writ petition out from the court.
But from the
maybe all authority have been disclosed whether that nobody has challenged. Now the petitioner has challenged this condition before this court. Now the only question is that how
I tell you, Lordship. I tell you.
An authority can impose a condition. No case can be registered. You suppose the same thing. The petitioner is with work with you. Several litigations, several amounts are pending. He has initiated the arbitration proceeding. Can you rest and you cannot participate?
But so far he is pleased for MSME Act. He is pleased under the MSME Act. Kindly take note on that.
That is different thing. MSME Act
so far
or,
the
or
petition
Contract Act or tender. I am not on that. Any act. Whether you show me the MSME Act provide that you can put this condition.
But MSME Act, Lordship, so far the MSME Act, with deepest respect, I humbly submit. So far we have already prepared the standing committee under the MSME Act.
Correct.
And if they have any grievances, they can ventilate that.
That is different thing. One which is glaring in the face
that is the legal proceeding, whether the legal proceeding can be made or not. That is the Lordship knows that offer and acceptance makes a contract. Now under section 7 of the Indian Contract Act, your Lordship knows That offer is fresh offer. This is the fresh offer has been given. And by virtue of the offer, certain condition can be imposed. It is suppose I gives an offer that these are the condition.
What I am telling, it is that way the Supreme Court also. The authorities are
free to
put the condition. But this court have a can interfere in the judicial review if it is arbitrary.
Lordship.
So that's why I'm telling you satisfied that
It
this
is not, but
arbitrary.
it is not arbitrary because it has not been made against any particular person. It is in general.
Not even general also.
General.
Even general also. If suppose there are 25 contractors, they are the general. 25 contractors, out of the 25 contractors, 2 persons is having the criminal case or the case against the WBSCDCL. Can you restrain? No, you have you filed the case against me. So that means you are restraining indirectly to the contractor not to initiate any case. To future, you will not get any contract.
No. That is not the.
That I will record in my order. I will record in my order. That is the contention really revealed from your face of the record.
If your lordship put up his mind, then it is my humble submission before your lordship is.
Show me the law. That's why I am hearing you. Show me the law which the law provides you to putting this condition that if a person is having any case against the authority, he cannot go for the tender. Show me the condition. I will decide this. Show me under what authority you put the condition. That is the only question here. In regard to what are the other things, I am not.
I understand. I understand. Lordship kindly takes up this matter on some other day. I will try to satisfy your lordship. Certainly. But lordship kindly take into consideration this aspect also.
That's why I will take.
That's the one who seeks equity must come because there is a very good reason why they are saying this.
That's why again I am telling this.
I understand. It is not for the particular petitioner. It is in general what's this troubling in your lordship mind that one cannot put any impediment to anybody else if pertaining to legal proceedings. That is the only thing. So far the contract is concerned, that I am free to do that under section 7.
There are several.
I understand.
If you are having the criminal case,
lordship,
can you not apply for the excise license?
Lordship, I understand.
No, it should be a moral character. There is a condition in the moral character, but does not mean the pending case is moral character is reputation of the applicant who has applied.
And I bow down to your lordship since it has fallen from your lordship. Certainly, kindly give me some date. Kindly take up this matter on Wednesday. I understand.
My lord, may I only take 30 seconds? What my learned senior friend has just indicated, date is missing. Page 37, first line, date is not missing. That is the date. 5/5/2021, page 37, the first line. So date is not missing. And second thing, my lord, kindly take up page 38 once and indicate 5/5/21. So date is not missing. That's the first line, my lord. Page 38, my lord. 3 things I'll show. Name of the enterprise. Page 38.
Yes.
Name of the enterprise on the right hand corner, my lord. First, second line. Second line, my lord. Name of the enterprise, PP Industries. My lord, at the bottom of, my lord, at that box, date of incorporation. Left hand side, my lord, 10/2/2007. On the right hand side, date of commencement of business, 29/8/1999. So all the dates are there.
36 is there. No,
And
he is
my lord,
telling,
no.
he is telling that with regard to the registration.
I am not on. I am not on.
He is not on.
Yes.
He is telling that registration of your.
MSME.
I understand that.
But he is telling that registration in
Was
the Uddham.
later. Uddham registration is later, and you've claimed for 2017 when you did not. What my
So under the MSME Act, he can come after
that's on the merits of
2017.
the arbitration. He can answer in the arbitration.
But the thing is,
But
he has
what my
suppressed
learned-
that.
No, I've
He has
suppressed
not specified.
I have
that.
not suppressed anything.
Yes.
Also,
I will certainly
since my
find
learned friend said equity should always follow the law.
The only grievance of the petitioner in the present application that in the work order, this is a work order.
No, purchase order.
It is a purchase order.
But one thing I just like, it is my duty to bring to your lordship kind attention. But this is the purchase order. He has challenged the ancillary part.
No,
He
but
has not challenged the original part, which is lordship. I will tell you, lordship.
May I only indicate this is an office order. It is not a purchase order. Page 375 is
I
an
tell
office order, my lord. It is
I
not a
tell you,
purchase order.
but it's an office order. Kindly come. That is, he has not challenged the original purchase order. Office order,
No,
lordship.
he has not challenged. He has
It is
only
not.
challenged
I've only
this.
challenged
But
this.
the
In the original, this condition is there.
Yes.
Where is that?
I will show. Because it is my duty to bring to
Where
your
is
lordship kind notice.
Where is that?
That has not been challenged here. He has to bring to you.
Okay, come on the next day.
I will show that.
The only grievance of the petitioner in the present case that by an office order dated 8th of September.
This one, may I say?
2025, comma, the
তোমাদের কাছে এইটা নেই,
authority,
ওইটা আছে, এইটা নেই,
the
হতে পারে?
WBSCDCL has put the condition that put the condition that
Same day তেই তো হয়েছে।
put the condition that declaration regarding no litigation against the WBSCDCL is to be provided by the contractor of the firm who is participating in the tender process. Full stop. Learned counsel for the respondent raised where which condition?
Same
Clause
day, my lord,
14,
8/9/2025.
If your lordship kindly see, that is the office order number 2514. Dated 8, because it is my duty, since they have not challenged, but it is my.
Whether they have participated in this.
No, it is the office order.
This is also.
We didn't
Yes,
know,
all
we
the
didn't
office
know
order.
about this. We'll file a
Are-
supplementary.
You should,
Kindly
they should
permit
put
us,
it
my
in the record by your supplementary
lord. We will,
affidavit.
my lord, we will.
Because in the prior portion, they never
The
challenged.
only challenge in the present writ application with regard to the office order number 2518 dated 8 September 2025, wherein the WBSCDCL incorporated the clause declaration regarding no litigation against the WBSCDCL by the firm.
Lordship, kindly see office order.
Who is intending to participate in the tender process.
2514, Lordship.
Learned counsel. The learned counsel for the respondent WBSCDCL submits that the petitioner has not challenged the said condition which is appearing in office order number 2514 dated 8th of September 2025, which is the
Clause number 14.
original purchase order.
But this is the office order. In terms of that, purchase order has been issued.
With respect of the original purchase order, wherein the same condition has been incorporated. Full stop. Consider the submission made by the counsel for the parties. The learned counsel appearing for the WBSCDCL is directed to take instruction under which
Kindly keep up
provision-
next week, subject to
under
Lordship.
क्या बोला? Learned full stop. The learned counsel for the WBSCDCL prays for a week time to take instruction. Accordingly, case is adjourned. Let the matter appear on 25th of February.
I'm very deeply obliged.
My lord, item number 14, my lord.
Liberty to file a supplementary affidavit, we'll bring this on
My lord.
record. May we have liberty to file a supplementary affidavit and a CAN application, we'll bring this on. We will.
My lord, item number 14, my lord. My lord, a liberty is required to correct the representation form. My lord has released the. My lord, item number 14, my lord has released.
Given liberty to mention before.
No, my lord, correction of representation form. Otherwise.
Item number
14.
Item number 14. You have taken the dictation.
14.
Item number 14. Liberty is given to the petitioner. Liberty is given to the petitioner to correct the group number in the presentation form.
Yes, your lordship. Grateful.
The presentation. Hmm. Hmm. Hmm.
Have your lordships kindly to mention a matter.
So what you want here? Hmm. Ah. Hmm. 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 So your where is your writ petition?
Your lordship, I am leading Mr. Ganeriwala in this matter. We are being led by Mr. Ratnako Banerjee in this matter. Your lordship, there is a grave urgency in the fact that the registered office has been allowed to be changed in violation of the company incorporation rules. So we are challenging that. We are apprehending that they will very soon take steps for shifting the registered office to Bombay. If they change the registered office to Bombay, then we are the creditor. We will be in a deep soup in recovering our money. So that's why the urgency is there. They will shift the office very soon. In violation of the company's rules, the regional director has passed this order. Your lordship will kindly take it up either tomorrow or Wednesday, anytime your lordship pleases.
That is the summons of.
When you file the writ petition?
I filed it this morning, my lord.
This morning. So what you want? How it can be heard today?
Not heard today.
Ah.
Any day this week, I'll be really grateful if
Tomorrow or day after tomorrow.
So mention tomorrow morning. Why you are mentioning this time?
I come back to you.
We'll mention tomorrow morning. Great.
कौन इतना जगह में क्यों रखे इसको उठा के रखो यस कॉल आउट जरा दूर रखो गड़ी गड़ी गिरते हो
Yes. Not another show cause.
who is for the other side
Well, I am appearing.
Yes, Mr. Diwan is also there. Milord,
Well, we are the usual suspects before your lordship's court. So we are back, my lords.
Milord, page 661.
I am thinking all this all one day I will fix with regarding to all willful defaulter.
Willful defaulter, Monday willful default, Tuesday fraud.
Well, these, yes.
Milord, post-lunch session is classification, no documents given. Pre-lunch session is where documents have been given.
So what is not
Milord, show cause usual Milord argument. 661 is the show cause notice. This is dated 16th of May 2024. Thereafter, my lord, we filed page this is volume page 661. कौन volume
और volume अच्छे की
3 I think, my lord.
और नहीं है
661.
volume 3
এটা 1547
15362
এটাতেই তো রেডি হয়েছে 15362. Milord, how many volumes are there? 4-5 volumes. আপনার এখানে 6 volumes.
No, তো writ petition
Milord, may I? एक तो 1536 there तो Milord, in fact, let me, Milord, not show the show cause notice. Please, Milord, take the supplementary affidavit. It's already filed, Milord.
Supplementary.
Yes. Your Lordship knows the facts. There is no requirement, Milord. Please see, Milord, page 23.
No supplementary.
Supplementary. That supplementary affidavit copy though.
Only can is there.
Oh, can is there.
What is the can?
Oh, it's been discovered, Milord. এটা বোধহয় supplementary. হ্যাঁ। Actually, he's responsible.
Well, today it's Mr. Sen's draft. Lordship, I have just seen it, but it's Mr. Sen.
That's why he's smiling.
Yes.
In other formats, I am searching of one file. It was not fine, only one volume. Then I think you have provided the
Yes, the rest. Supplementary dated? Date বলো এখন
দে
23rd December. Yes. Not show cause notice, Milord, on 16th May 24. Thereafter, we filed the writ petition in June. Subsequently, Milord, December 24, we, Milord, issue page 23. And, Milord, at page 92, Milord, please come to page 92.
Enclosure.
These are, Milord, the documents which we have requested for.
So page 23 is your reply.
Yes, same letter, Milord, runs up to page 92. Milord, please see 92.
Yes, got it.
These are the documents which we wanted.
92 to 99 your doc.
93 to both KPMG report and Saxena report. Milord, I'll just give an example of, Milord, one issue. Milord, first defense of the company is that when loans were given by the banks to the Shrey entities, there were, Milord, constant appraisals done of past and present transactions. And bank employees, Milord, all the banks, Milord, were actually involved with the decision making as to who, Milord, Shrey should, Milord, lend to. So, Milord, those appraisal reports and the name, Milord, they can be, Milord, once they give all the appraisal reports, this, Milord, surprise now by the bank and the allegation of fraud will fall on its face, Milord, because banks are fully aware. So, Milord, this is, and we'll also track them by the names of the bank officials who were engaged, Milord, in each appraisal. So once we have the names and we have the appraisal reports, we'll be able to show that these particular loans, which Shrey has subsequently given to third parties, these were directly approved. Or subsequently, after the loans were rendered, the banks, Milord, have approved. So, Milord, this is just one example. Milord, because this goes on every day, Milord, in different courts. It's often argued that why have you asked for, Milord, appraisal reports? Why have you asked for the names of the bank officials, etc.? In any event, Milord, these are the documents which we have requested for. Now, they have, Milord, made a declaration, which, Milord, is page 41 of the CAN application, without providing a single document. my lord, I am, my lord, in terms of your lordship's judgment, without going into the same arguments for the nth time, only requesting, my lord, that the fraud declaration without documents will not be set aside, and they should give us the documents which will not be asked for in our reply. These are my submissions.
Yes, Mr. Diwan.
Yes, my lords. My lords, I am cognizant of the previous order passed by your lordships. Yeah, in the case of Indian Overseas Bank in Punjab National Bank. But my lords, may I say this case, the facts are a little different than what have been projected. My lords, may I first request your lordships to look at the writ petition once for a moment. Well, as writ petition, I am just showing to your lordships page 11, para 22.
Yes.
Now, your lordship will see that in the writ petition, the prayer is for in relation to an audit report submitted by KPMG and circulated via an email dated 28 December 2021. So this writ petition is concerned with the KPMG audit report. This is a little important. Your lordship, my lords, will come to the next page, paragraph 23. 23 refers to the impugned SCN, which Mr. Chaudhary rightly pointed out is 16th of May 24, as containing contents of the said forensic report, which means the KPMG audit report. And it says respondent has failed to or neglected to provide copies of the documents on the basis of which KPMG issued the said forensic audit report. Now, in this vein, also please kindly look at the prayers also in the same writ petition, and your lordship will find the prayers at page number 47.
Yes.
And the prayers are, your lordship will see prayer number C, writ order or nature and the mandamus to issue commanding the respondent or its men or so and so from withdrawing, recalling the impugned show cause noted 16th of May 2024. So we are now in this case, first of all, the scope of the writ is the SCN dated 16th of May 24, which is based on the KPMG report. I hope I'm clear there. That's a matter of admitted fact. Now your lordships, my lords, will look at that impugned SCN itself, which is page 661. I hope your lordships are able to now get a copy of that SCN. And that SCN is also with respect to at page 661 of the writ petition.
Page 67. Which volume?
Plus this, Mr. Chaudhary may have to help me here because I have a separate
of course. What is
the ID?
661 is volume
SCN.
Yes, not volume 3.
Volume 3. I'm so grateful. Thank you.
আর্গুমেন্টটা বুঝতে পারছি না আমি। সেটাও বলছে না।
Yes.
Yes, kindly let us look at paragraph 4 of the SCN. The date your lordship will mark 16th of May 24, and just look at paragraph 4. Subsequent to this, your account was subjected to internal investigation by the bank, and April 21, UCO Bank and Axis Bank appointed KPMG to conduct a forensic review of books of account, etc. And then there are allegations based on the KPMG report, which is as I said, which is being challenged in the writ petition. In this light,
No, which portion? Paragraph 4.
Yes, paragraph 4.
Page number?
662.
662. Thank you.
Yes.
So your lordship will make a note here also references to KPMG because that's the writ petition. This is the show cause notice which is challenged.
Correct.
Also in the SCN. Now, Mullahs, in this background, please look at page 41 of the CAN as to the now what is being challenged before your lordships by filing the CAN.
It is not pursuant to that show cause.
Yes.
Yes. Now, your lordship, the declaration is at page 41.
Yes.
Lordship will just give me 1 second. I'm sorry.
Yes, 41. You're right.
Yes. Just, I'm just opening my, just 1 second. Sorry.
Yeah, no, this is on the basis of the show
Yes.
cause.
Now, my lords, your lordship will look at 16th of May. This is the fraud declaration order. Please look at the subject. Show cause notices dated 16/5/24. Kindly look at the second paragraph.
Yes,
Show
yes.
cause notices were issued to you on 16/5/24 based on the significant discrepancies and irregularities identified in the forensic audit reports submitted by KPMG dated 22nd of December and Saxena dated 7th of February 22, covering the period 1/4/2016 through 39/20.
On this
And
ground.
thereafter the reasons are given, and ultimately he's declared as a fraud. The point that I'm trying to make, my first point is that this CAN is outside the remit of the writ petition. The writ petition was only with respect to the KPMG audit report and one show cause notice of 16th of May 24. The fraud declaration is with respect to 2 audit reports. So the CAN in that sense is quite outside the scope of the main writ petition itself. The writ petition is not about Saxena report. The writ petition doesn't even annex the show cause notice issued by the bank pursuant to the Saxena report.
Yes.
It is only KPMG. So according to me, in my respectful submission, today no prayer with respect to CAN. This decision of 16th of May can be made because this is outside the writ petition. That's argument number 1.
Yes.
Saxena is not the subject matter of this writ. Now, argument number 2. Your lordship will recollect that in the parent judgment of 2nd of February 2024, there were steps specified as to how they have to comply with or to respond to the notice. Step number 1 was that within 14 days of the receipt of show cause notice, a preliminary response needs to be given, identifying the documents which are required. That's admittedly, the judgment which was passed. That judgment was reiterated on 9th of August 2024. And that very same judgment has been also followed by your lordships in the last orders which have been delivered. In this case, your lordship will take it, there is no preliminary response to the SCN given at any stage. So the petitioner before your lordship has failed to comply with the judgment of 2nd of February 24, reiterated on 9th of August 24, and followed in subsequent cases. And may I just make good that submission? As your lordship has noted, the SCN is 16th of May 2024.
Correct.
The first time the response to the SCN comes, kindly have a look at that, is 18th of June 24 at page number 19 of the supplementary affidavit. Kindly have a look at page number 19 of the supplementary affidavit.
June.
18 June. Now, this letter of 18th June
Yes.
says it gives no response at all. It only says there is a writ petition which is pending before the Honorable Court, therefore don't proceed ahead in the matter.
Yes.
And also at page number 19, your lordship will make a note of the subject and the second paragraph. The subject is show cause of 16th of May, and this show cause is the KPMG show cause.
Correct.
So on 18th of June, they say because the matter is pending, so therefore don't proceed. The bank issues a personal hearing notice on 2nd of December 2024. That is at page number 21 of the same supplementary affidavit. And also kindly look at the subject line of page 21. Your lordship will find there are 2 separate SCNs.
Correct.
I hope I'm clear. One of them is the one of KPMG impugned in the writ petition. The other is the Saxena SCN, which is not subject matter of this writ petition. This is 2nd of December.
Yes.
Now, my lords, your lordship will come to page number 23, which is 10th December 24. And please, again, page 23 of the supplementary affidavit, which is 10th of December 24.
Correct.
And your lordship will first look at the subject line, subject number 2 and 3. And your lordship will find there is reference to 16th of May 24, one show cause, and the other is the other show cause.
Correct.
So two different show causes. Now your lordship will look at, my lords, page number, straight away look at 26. I'm sorry, 27.
Yes.
And your lordship will find that a list of documents have been sought. But there is no response to the SCN. The implication of the judgment passed on 2nd of February 24 is that the person, the noticee, has to give a response to the SCN, and in the same response, he has to identify documents. In this letter of 10th of December 24, there is no response on merits at all. It is only documents. So my second submission before your lordships is, number one, that as per the judgment, response had to be given within 14 days. Here, no response at all is given. And even the documents which are sought on 10th of December 24, which is much after the SCN of 16th of May 24. So that's my second. So a person who comes to the court, he stands himself in willful violation of the judgment of this court on 2nd of February 24. That's a very important distinguishing factor. Your lordships, when considering the matter of PNB and IOB, your lordship will perhaps remember those matters, which just judgment was given a few days back. The main distinguishing feature of PNB's case is, in PNB, the gentleman had given a response on merits and asked for documents. Here, your lordship will find there is no response on merits at all, only documents. Okay. And he asked for documents. So that's my second submission. Well, my third submission is that, well, after your lordship's judgment in the last round of PNB and IOB, the contempt petition filed by the same petitioners in relation to not giving them documents came up before a coordinate bench of this court. And that contempt petition was dismissed. The averment or allegation there was that the banks are deliberately not giving us documents. That constitutes a violation of the parent order of 2nd of February 24 and 9th of August 24. Therefore, there is contempt. And that contempt was rejected. Please kindly have a look at that order rejecting the contempt. That's a little important because it has some observations.
Yes.
Yes. Now, my lords, I don't want to read the whole order, but your lordships, my lords, will look at paragraph number 3. In fact, I'm sorry, your lordship, my lords, will look at paragraph number 4 at page number 2.
Yes.
Which is the allegation. Alleged contemners have not furnished relevant documents sought by the petitioner in terms of the said order giving rise to present contempt application. And then is my submission paragraph number 5. Please omit that from consideration at the moment. Please look at paragraph number 7 at page number 3. Thus, it is contended that the alleged contemners' valid grounds refuse to give all such documents to the petitioner, particularly since those were not at all relevant to effectively rebut the allegations made in the SCN as envisaged in the parent order of this court dated August 9. Copies of the FAR and annexures which comprised of the primary premise were duly furnished to the petitioner. Your lordship, my lords, will now come to paragraph number 16 at page number 5. In such context, may I read that? In such context, it was observed, this is the order of 9th of August, that the documents which are required to be inspected to effectively rebut the allegations made. Your lordship may kindly please mark that expression. Not all documents have to be given. Documents needed to effectively rebut the allegations made in the SCN would be furnished by alleged contemners. Moreover, alleged contemners were directed to furnish copies of only the relevant documents to the petitioner. Now, please look at 18 on the next page, page 6. Use of the words effectively rebut and relevant clearly leave a scope of interpretation in tune with the respective perception of parties as to what documents would be relevant for effective rebuttal of the allegations made in the show cause notice. Please see 20. Since the alleged contemners has an arguable defense for not furnishing all documents sought by the petitioner, which is required to be interpreted in law, adjudicatory process is required to precede the decision as to whether those documents were at all relevant for the purpose of rebutting the allegations made in the SCN against the petitioner. Para 23. In the instant case, however, parent order is susceptible to arguments and interpretation as to whether the documents sought by the petitioner are at all relevant or required for effective rebuttal of the allegations made against the petitioner. And look at 27 and 28 kindly. However, it is made abundantly clear this court has not entered into the merits of the respective contention of the parties as to what would be the documents relevant or required by the petitioner to effectively rebut the allegations made against the petitioner by the bank in the show cause notice in question. It is kept open for the parties to argue such issue before the writ court, where we are informed challenge by way of writ petition is pending against the final decision of the petitioner as fraud, and the contempt petition was dismissed. Well, the burden of my argument is for the petitioner to come before your lordships and say that I have not been given documents is not a sufficient ground to question the decision. The relevant wordings of the order are relevant documents to effectively rebut the allegations made. So my friend has to discharge the burden of showing as to how the documents that he has sought are relevant for defending him. And this becomes even more significant because I've told your lordships that there is no response to the SCN at all.
Yes.
My friend had to give a preliminary response. Your lordship, I'm sorry, I'm taking a little time on this, but would your lordship please indulge me by having Yes, to lordship be so kind to look at the judgment of 2nd of February 2024 once again. Just only for that.
You're having. Yes.
Yes. Now, your lordships will see, this is the judgment which has been followed all along. And may I just show your lordships the relevant paragraphs? Would your lordship come to your lordship will just give me 1 minute, please. Kindly look at paragraph number 60 first at page number 18.
Yes.
What is to be ensured is that specific instances of allegations are to be mentioned in the SCN, although all particular documents which are to be relied upon and or intricate details of frauds need not be given at the SCN stage. Show cause is a mere indicator of the allegations made against the borrower, director, management. Now look at, kindly look at paragraph number 69. I'm sorry.
Yes, continue.
Very first step has been complied with in the present cases by issuance of SCN enumerating the exact allegations, serving a copy of the FAR which forms the basis of SCN. There is no scope or reason to set aside the SCN as such. Lordship will make a note in the present case, which is South Indian Bank, which Lordship today hearing. There is no dispute that the whole FAR, complete FAR, and the supporting documents have been given. So now your lordship, my lords, will look at the operative scheme, my lords, paragraph number 74.
Yes.
This is the scheme laid down. The scheme is in each of the writ petitions to furnish his reply to the show cause notice within a fortnight from date, indicating documents which are required to be inspected by furnished to the petitioner to effectively rebut the allegations made therein. And then 75, upon reply being given, respondent bank shall fix a date for giving inspection and shall furnish copies. 75 will come after 74. He has to first give a response to SCN indicating documents. Now, in this case, as I've shown the response of 10th of December, as the letter, there is no response, only documents. Now, last submission on this point. The the facts of this case disclose really that after the SCN was given, the person concerned stayed mum up till December 2024. And he only asked for documents in December 24, which the bank said are irrelevant. The bank has given a letter on 11th of December saying that the documents are irrelevant. The opportunity of personal hearing was twice given to him. He didn't turn up, and Manoj, now the fraud declaration order has been passed. The fraud declaration order is a reasoned order. If today Mr. Chaudhary's clients want to assail that fraud declaration order, which incidentally I am at pains to point out is with respect to two different audit reports, and in this writ we are only concerned with one audit report, he has to show as to which all documents were relevant and were not given to him. In other words, by virtue of failure to give some document, how has he been incapacitated? Only giving a list, my lords, and saying I wanted all of this and all of this not being given may not be sufficient. There has to be some nexus, because that's my respectful submission insofar as this is concerned. Mullahs, ideally, that's my last real submission. Because this whole matter now keeps turning upon documents, whether this was given, not given. Mullahs, according to me, the mandate of the contempt order is that I am at liberty to show that the documents are irrelevant. If your lordship permits and thinks appropriate, we can in fact file one more affidavit now showing as to how each of the documents are completely irrelevant for the purpose of whether there is a fraud or not. I can even do that. But to only set aside the decision because we have not complied with this long laundry list may not be a justified outcome is my respectful submission. In this writ, in item 2.
I congratulate my learned friend, my lord. In every matter, he finds, my lord, a distinction. Every matter. This morning, we did a matter before, my lord, Justice Omnarayan Rai. He found a distinction. Here also, my lord, he's found a distinction. But, my lord, fact of the matter is, my lord, there is no distinction.
No?
My lord, they're all the same. My lord, if your lordship looks at, we are trying to get over, my lord, round 1. In fact, my lord, it should be the bank.
No, he has raised two legal questions. One is with regard to the KM. You have prayed only the KPMG in the main writ petition.
My lord, the next writ petition in the list is Saxena. My lord, please have a look at.
Why you have not given the reply to the so?
I'll just that also I'll explain, my lord. That is first, my lord, is the show cause notice. I immediately filed a writ petition. 18 June, which my learned friend is showing, is my advocate's letter informing the bank, please don't take steps. I have filed a writ petition. Then, my lord, comes a notice for personal hearing. At which point of time we advise the client, see in the other matter there are orders. Court wants to see reply, where you also ask for what documents you want. So we immediately gave a reply and said that please give me the documents before you proceed for the hearing. They don't, my lord, give a single document, proceed for the hearing, which is in violation. Okay. And now, my lord, please have a, I'll just show your lordship, my lord, and contempt. Contempt was, we filed a contempt saying despite that order, that first order, you are not giving us documents. So, my lord, when we moved the contempt, they said that A, we don't have documents, B, these are not relevant documents, etc. So, and anyway, this is not contempt. Because there are two, my lord.
Now, what is the relevancy of this document?
I'll just explain that to your lordship. Would your lordship please, my lord, have a look at the order once? Because I want to make that very clear. So I'll deal with the first point regarding the two audit reports. Now, please see, my lord, page 41 of the CAN application.
Yes.
Second paragraph, which my learned friend pointed out, show cause notices were issued to you on 16th May 2024 based on the significant discrepancies and irregularities identified in the forensic audit reports submitted by KPMG dated 22nd December 2021 and Saxena dated 7th February 2022, covering the period 1st April 2016 to 30th September 2020. So, my lord, show cause notices issued on 16th May 2024. Now, my lord, please take the writ petition in the next matter. What the marker? I got a number, sir. Number 15471. Show cause ka dekho. Page 353 of the second writ petition.
Give the second volume. 353. Second volume. Other volume.
That second volume. Take a copy down. Oh, little bit. This is regarding which one? Agita is regarding my lord, the earlier one was relating to Saxena. This is, my lord, if your lordship sees page 35C, this is relating to, my lord, KPMG.
No, earlier was the KPM.
Oh, KPMG, this is Saxena.
The Saxena.
This is Saxena. Volume 2, 353 at 354. Second volume might be. So my learned friend's argument is with 50% of the challenge, you can't get 100% result. But the challenge is 100% in both the writ petitions. That's why, my lord, they are one after the other and tagged for hearing together. My lord, please see 354. Lord, please come to paragraph 4. The show cause starts at 353. Paragraph 4, my lord, is the Saxena report referred to.
Yes.
The combined effect of both the writ petitions is 100%, is equal to 100% of the order. So, my lord, the first point, my lord, is a non-issue. With respect, my lord, I submit. Now, the second point. Second point, he says that you did not reply to the show cause notice. So, therefore, you cannot gain advantage of the order. My lord, you cannot gain advantage of the order. To which, my lord, my submission is, please, my lord, take the supplementary affidavit now. The documents are one after the other. I'll just show your lordship. No, in the first matter which your lordship was seeing. We are now back to the first matter. Here are, let's show records which are confused corona. Amar second hyperlink korani. My lord, please see. 16th May 24 is the show cause. In the month of June, my lord, I filed the writ petition. Then, my lord, I issue this letter on 18th of June, page 19.
Correct. After 1 month.
After 1 month, but this is not a response.
And that's why he's telling, because his contention is that as per the order of the
you had to respond.
You have to respond within 15 days.
That is the time limit is not binding for the world over. It's not a notification.
That is a submission. That is a submission.
In all matters, your lordships have entertained. So this argument then would have resulted, my lord, in negating 15 orders which your lordships have passed. Justice Sinha has passed, Justice Shampa Shakar has passed, your lordship has passed in 4 matters. So this is not a reply to show cause. This is a communication that I have filed a writ petition.
No,
please see this.
That's why his contention is that first he has taken that within 15 days you are not given the reply. So that is one of the violation of the order passed by Justice Bhattacharya. Second, the reply which you have given on 18th of June, that is after the 1 month, that also not a interim reply to the so-called notice.
No, that
only you ask for the document. So once you have given the reply to the authority, so whether you can ask for the document.
Yes. May I show your lordship the sequence? Now, this judgment, my lord, is not, my lord, the respondent here, my lord, South Indian Bank was not a party. This is in another matter concerning the same petitioner, but another matter. It's a judgment inter parties between the parties. My lord,
No,
between
one,
Bank of India,
that is
Union-
correct. But the court has fixed the guidelines with respect of the master circular.
No, my
What
lord,
is-
in the
because-
facts of that case,
Kindly come
but
to
time limit also fixed.
Kindly come to the guidelines given by the, kindly come to the page 59. Paragraph 69.
Yes. No, my lord, perhaps the very first step has been complied with the
Paragraph 79, you come to paragraph 79. WPS so disposed of. Upon getting the audit report, the petitioner shall within a fortnight give a reply to the so-cause. Then 80. Within fortnight subsequent, necessary petitioner give the additional reply.
Yes.
So
In
this
that case,
this is the guidelines with respect of the master circular, not in that case. That is kindly come to.
my lord, please see, my lord.
Kindly come to the page 31, page
My lord,
paragraph 3.
My lord, may I show your lordship, my lord, paragraph 63, my lord.
Yes.
Paragraph 63.
Correct.
Keeping such backdrop in view,
Correct.
in the light of the judgments rendered in Rajesh Agarwal and Neptune, the following procedure is, in the opinion of this court,
Correct.
apt to serve the purposes of the master direction,
Correct.
as well as to take care of the principles of natural justice, in particular the tenet of odi alteram partem, and ensure that an effective opportunity of rebutting the allegations is given to the borrowers and its director. First, show cause notice is to be issued, enumerating exact offences alleged. If any FAR or other document forms the basis of the show cause, same is to be served along with show cause.
Correct.
Along with, in this case, we still haven't crossed that threshold.
Correct. Along with then.
So, Miller, they haven't given.
Correct.
Both the said criteria has been satisfied in the present case in respect of BOI, BOB, and UBI. Now, Miller, may I pause here? This your lordship can say is construction of the circular. This doesn't have time limit. Then, my lord, paragraph 65. A fortnight thereafter would be ample time to give reply to show cause notice. In its reply, notices shall, apart from addressing the allegations and controverting those specifically, specify the documents which are required to be provided to the noticee by the bank's financial institutions.
Correct.
If necessary, in the reply, the borrower, director, or promoter can reserve its right to give a further additional. Then, within a week, banks can give inspection further fortnight.
Correct.
Now, submission number 1. If your lordship, my lord, is pleased to consider, this is a matter inter parties. That's my lord, number 1. Number 2. In all the other matters, my lord, your lordships have considered the fact that the banks have themselves not complied with this. Banks have themselves, my lord, not along with the show cause notice, given a copy of the FAR and the further documents.
Correct.
So unless you do that, none of it triggers off.
Correct.
Number 3. In fact, last week your lordship, my lord, was pleased to pass a judgment permitting, my lord, reply to be, my lord, given, which we have done. This 15-minute time limit, 15-day time limit is not, my lord, considered. Even if your lordship considers that I can only, my lord, respond within 15 days and not thereafter, which none of your lordships have considered, or my lord, have taken to be a sacrosanct time limit, because it's not there in the circular. What is material is 18th June, I informed. This is not reply. This is a letter informing that writ petition has been filed. Then, my lord, please come to page 21. 2nd December 2024.
Page
I'm
21, yes.
to page 21.
Yes.
Supplementary affidavit.
Correct.
In connection with the aforesaid notice, bank has sought your explanation regarding irregularities observed. As you are aware, bank has shared complete forensic audit reports, findings upon of which were relied upon. Consequently, our Natural Justice Bank has decided to provide you with an opportunity for personal hearing.
Correct.
When this comes, we immediately, my lord, forgetting the fact that the matter is sub judice in court, we, my lord, give, my lord, page 23.
No, see this notice of 2/12/24. 2/12/24.
Yes.
Correct. And when you file the writ application, first writ application?
June. My lord, first one.
Hmm.
My
This
lord,
one,
June, my lord.
This one. This present writ application. You filed in June 2024.
Yes, my lord.
Okay, before that.
Writ petition was filed. They proceeded. We thought so writ filed against the show cause, and we said that you haven't given us anything, so you can't proceed. Immediately, my lord, that notice was issued, which is 18th June, which I've shown your lordship. Then, my lord, we expected them to remain quiet till the time matter comes up for hearing. They don't. They, my lord, issue this notice on 2nd December 24. When they issue a notice, my lord, I realize that I have to, my lord, I can't come to court because it's not possible every time to, my lord, get a listing within time in a pending matter. So, my lord, I comply with the judgment and I give them page 23.
Correct.
Which is 10th December 24. And in this, my lord, I give the full list at page 92. Now, my lord, I'll address your lordship on the relevance. In fact, my learned friend, my lord, may consider this to be a laundry list, but this is a matter which may send me to jail. So I take it very seriously. So that's why in my letter, I want your lordship to see the letter and the documents. On the right-hand column, please come to page 28.
Relevancy mentioned.
Relevance is mentioned. Milord, I'll just read one, Milord. To the best of, this starts at page 27. To the best of my knowledge and recollection, once a decision to grant a loan was taken and the matter was passed through the Board of Directors Credit Committee of the Shrey entities, these accounts were dealt with by the operating level management and coordinated with the borrower. This is also the case with the loan account of Shrey entities with the consortium of lenders, where the bank officials worked hand in hand with the respective department and officials of Shrey entities at operating level at all stages. This included the scrutiny of all the loans being given by Shrey entities.
Then in that case, what I propose, suppose. So because you have given the relevancy,
yes,
they have not considered it. Correct. Now, if the court has also passed, then tomorrow again, it is to be decided once for all. Let they give the reply affidavit with regard what the relevancy you mentioned. Let they say it is not relevancy. Let the court decide with relevancy. That will be better.
But in the meantime, Milord, please stay the fraud declaration. Otherwise, they will launch criminal proceedings against me. Milord, I don't mind. If your lordship doesn't set it aside, let them take no further step on the basis of their.
Because every time this is
yes, every time. Your lordship is absolutely right. What will happen is
this was on the earlier occasion I was thought, but I have kept the CAB, so I will let it now again. It has come. So it is been Mr. Diwan is also telling me, yes, Mr. Diwan, you can give the affidavit only with regard to the relevance.
I will give. No problem. I will give. Now, in the meantime, if your lordship, my lords, on the issue of stay, that's the issue of considering. I just need 2 minutes of your time whenever Mr. Chaudhary finishes. I'll address only on the issue of stay.
No, so what my learned friend wants to do is he has not given me a single document. I have given him the list with the relevance. Ignoring this, he has, my lord, declared me, my lord, as fraud without any reasons, on the basis of which he will, my lord, launch criminal proceedings against me. And if ultimately I succeed, I will not be able to have it reversed by your lordship, because this morning he showed a judgment of the Supreme Court which I was not aware of, which says that even when fraud is, my lord, set aside, even criminal proceeding launched on that basis cannot be quashed by the writ court.
That is.
So, my lord, he will take it to an irreversible situation, and in the meantime also file an affidavit. That's not, my lord, a fair stand of, my lord, a nationalized bank. Because if I, my lord, succeed here, either, my lord, let him do it de novo, give me whatever documents he wants to give me, and, my lord, proceed again. Or, my lord, let him agree to the fraud not being given further effect to. I'm saying further effect to.
Okay. Yes.
Yes. Now, it's only on the issue of stay now. Before that, just 2 points Mr. Chaudhary mentioned. One he said was that 50% of challenge is in the first writ petition and 50% of the challenge is in the other writ petition, 15471. Plus, your lordship will only make a note. 15471 is not affirmed by Sunil Kanoria. So I don't know on what basis Mr. Chaudhary says that this is covered in the other writ.
Two reports, KPMG, your argument is
Chaudhary, 1
KPMG
second.
succeed. I have answered the argument.
Mr. Chaudhary, I didn't interrupt you.
Challenged.
Mr. Chaudhary, I have not interrupted you.
Yes, yes.
There are today in your lordship's board, there is 15362, the one that both Mr. Chaudhary and I argued. That, as I showed, was KPMG. 15471 is the writ petition filed ostensibly in the name of Hemant and Sunil Kanoria. But it is not affirmed by Sunil Kanoria. There is no
authorized by both. Please look at the affirmation.
There is nothing on record to show any authorization. Mr. Chaudhary, please point me if
That is
I'm
the
wrong.
way filings are done in Calcutta.
Very good.
I am the petitioner number 1. I've been authorized by petitioner number 2. At the oath commissioner, you have to show authority. A
Very
copy
well.
also does.
Very well.
Page 25, paragraph 1 may be seen, affidavit portion.
Correct, but I have not seen any authorization. As it be that as it may, I will not take that point. Now, the second point was regarding a lordship noted that whether they gave a response to the SCN or not. Perhaps I was not able to clarify my position. They have not given, or Mr. Sunil Kanoria has not given a response to SCN at any point of time.
Correct, that's right.
Neither on 18th of June nor even on 10th of December. So 18th of June was neither merits nor documents. 10th of December is no merits but only documents. So now the judgment of this court on 2nd of February 2024, and your lordship will just make a note of 3 other paragraphs, 54 and 55 also. 54 and 55. They say that time is of the essence. If you have to give a response and ask for documents simultaneously. Please look at 54 and 55 also.
This is on the letterhead of Sunil Kanoria. How can my learned friend say Sunil Kanoria has not answered?
Yes.
Now 50, your lordship may see 54. Delay in reporting of frauds and consequent delay, etc. Now look at 55. Time is of the essence of entire master directions, which lends an extremely summary character to the process involved therein. Now, point number 3, the master directions itself have a time limit of giving a response. So my friend says that there is no time limit and your lordships can enlarge the time limit. No, that's not correct at all. Your lordships have a person today who has not given a response. If a person has not given a response, because I don't understand on what principle of law is he entitled to any order of stay. Only by asking for documents. A person doesn't give a response. He's supposed to give a response, both under the master directions as also in the judgment. He chooses not to give a response. He says, I am only going to ask for documents, but not give a response. And he says, I want to stay. Okay. Because according to me, for a stay, there has to be a prima facie case. He should have shown as to why the allegations on merits are wrong. He's failed to do so. Number 3, insofar as his threat of criminal directions are concerned. There is a judgment of the Honorable Supreme Court. My colleague may have a copy. Perhaps she can pass it on. The Supreme Court has said that there is no correlation between declaration of fraud and criminal proceedings. These are two parallel paths. So therefore, this being pointed out to your lordship that there will be criminal proceedings, etc., is completely wrong. Criminal proceedings are already pending. If the bank wants to further file criminal proceedings, the bank can file. This fraud has no nexus with the criminal proceedings. I am only opposing a stay. I am saying
Bank
I
has
can give
started
an
criminal proceeding.
Yes, the bank can file a criminal proceeding.
No,
Why not?
you said has. Every statement is incorrect.
I am sorry, Mr. Chaudhary. There is one bank which has already filed.
That is a different bank.
So I'm saying so.
For
One
which
bank
there is
is
a criminal quashing pending, and that is not South Indian Bank.
very well.
That is
Some
UCO
bank.
Bank.
If South Indian Bank wants to file a criminal proceeding, there is nothing in law which prevents South Indian Bank from filing a proceeding. But that does not mean the threat of filing a criminal proceeding cannot be a ground for stay of the fraud declaration. In my respectful submission, in the facts, when the person concerned admits, and I underline the word, admits his failure to give a response, which is a precondition under the master circular as also the judgment of this honorable court.
No, just one thing, because every factually incorrect. Page 23, my learned friend says this is not a response from Sunil Kanoria of the supplementary affidavit. It's on his letterhead. Please see page 23.
Yes.
It's on his letterhead.
That's only documents, Mr. Chaudhary. I said.
Number one, now.
Yes, right. Yes,
No.
with regard to the this
Now, my lord.
response to the
Now,
SCM.
so if he, my lord, doesn't draw your lordship's attention to, my lord, page, my lord, paragraph 4, paragraph 5, 5 to 14. What do I say in 5? Illusion of compliance with natural justice, no papers given. Then, my lord, 7, without having access to the documents and information on the basis whereof forensic audit reports have been prepared, it's impossible for me to independently verify the alleged finding observations made in the forensic audit reports. No way to verify. Then, my lord, paragraph 8, annexures, exhibits to the FAR which have been furnished to me are in the nature of secondary documents without in any manner, they've been prepared by KPMG and Saxena. I was not involved in the audit exercise. Then the documents and information have a material bearing on and direct nexus with the purported allegations made in the notice. I request to provide me with copies of documents. Any purported opportunity of hearing without having access to the documents is meaningless, ceremonious.
I didn't want to interrupt my friend. Mr.
Now,
Chaudhary,
my lord,
one second. Mr. Chaudhary, 1 second.
If I have to deal with the allegation is Shrey has lent money to X, that money has gone to Y, that money has gone to Z, and it's come back to Milord Shrey. Round tripping. I remember Milord rereading it. So unless I have documents, how can I respond?
Now, my lords, only 1 point. Mr. Chaudhary is at pains to show to your lordships.
280 loan accounts. How do I deal with? I'll be Einstein if I remember everything.
The interesting feature, the lordship
No interesting feature is factually incorrect statements. Number one,
I am not
no
in the
criminal
habit.
proceeding.
I am
Number
not,
two, no
Mr.
reply.
Chaudhary.
Number 3, Sunil Kanoria did not respond. Number 4, he has not filed a writ petition.
Yes.
And now he wants us to wait till he goes to file criminal proceeding.
There is perhaps a feeling that if you shout too much, then perhaps we score points on that.
No,
There
it's
are two
only the
brothers.
volume which is high. I'm not shouting.
There
It's
are
the mic,
two-
not me.
Your lordship, that's the last point. There are 2 brothers, Sunil and Hemant. My submission is Sunil has not given a response on merits. But equally the other brother, Hemant, he has given a response on merits to the very same SCL. Please see the dichotomy between the brothers. One brother, which is namely Hemant, understands the purport of the order of 2nd of February 2024, and at page 62 of Can in WPA 15471 gives a response to merits and documents. The other brother, which is Sunil Kanoria, he only asks for documents but does not give a response on merits. So to say that it was impossible to give a response is wrong, because one brother has given a response. Only the other has not given a response.
Yes.
In item 2, no response. In
There
item
are
3,
14 orders.
Okay, thank you.
now, in the other matter, only one thing. In your lordships have only heard item 2, because item 3,
2
the
and
submissions
3.
are different.
Same facts.
No, different facts, please. Item 3, I want to say, your lordship may either hear me today or some other day, because item 3 facts are different.
Milord, he'll go tomorrow and he'll file, Milord, a FIR
What is
against
this
him.
item? I'm
And
sorry,
that's the
Milord,
end of the matter. This whole exercise would become meaningless.
Okay, come tomorrow, come tomorrow.
For item 3, I'll come tomorrow, no problem. Item 3, I can address your lordship, because there's a difference in facts. Because in these matters, facts are a little important. My friend should not say that facts are not important. Item 3, and your lordship will record my statement, and I'm not in the habit of making false statements. In item 3, there is no request for documents by one of the petitioners in respect of one audit report. That's fatal. And I'll show it tomorrow. I can show it even now.
Please, Milord, it's just one document. Let him show it, Milord. Otherwise, we'll again.
It will take a little time. Mr. Chaudhary, it will take a little time. I think we have fought already enough today, and we can reserve our ammunition for tomorrow.
No. Milord, this is just one document. Otherwise, whole re-argument he'll do tomorrow again.
Why I will do re-argument? I don't know why, my friend. I'm your lordship's hands, whatever your lordship says. I can otherwise come tomorrow and address the other matter. Item 2 is over.
Parties to the proceedings have concluded their argument in respect of the WPA 15362 of 2024. Full stop. Due to paucity of time, WPA 15471 of 2024 could not be taken up for hearing. According to case adjourned, let the matter appear tomorrow.
Tomorrow, very well. Very well.
Not there tomorrow.
Then
Thursday.
Well, it's Thursday, it will be after 2 o'clock, no problem. If it's after 2 o'clock, no problem. Thursday or Friday, Milord, any day.
In the meantime, Milord, at least they should assure that they will not lodge FIR.
No, I have no instructions to make any assurance, Mr. Chaudhary. I have no instructions.
In that case, Milord, I'm paying for a Milord. 3 days, an order for 3 days.
Come, I will hear the on final. Let them 19th.
Yes, Milord.
19th. At 2 o'clock, Milord?
Not 2 o'clock. It will be listed as urgent motion. Because time तो नहीं है ना 12
Yes.
बजे भी नहीं है urgent.
I'm grateful.
FIR is lodged, we are sunk.
Nothing will happen. They have not done anything. What you will think?
No, now they are
The
doing.
bank will do within a day. हाँ एक ही साथ रहेगा. Hearing concluded हो गया. आज ये भी नहीं किया. एक साथ रहेगा.
Grateful, Milord. I'm so deeply obliged.
Lordship. Lordship, may I be permitted to mention one matter?
Just a minute. Yes.
Lordship, under compelling circumstances, I beg to mention one matter by taking leave of the Honorable Court, because my client has received a notice under Section 29(1) of the State Financial Corporation Act, and they have stated in the notice that on the 18th of this month, they'll come and take possession of the property. No, it is not listed. Appellate side. With the leave of this court.
When the notice was issued?
Lordship.
When the notice is issued?
Lordship, the notice dated is 13th, but the notice has been received by my client on the 30th of January.
30th of January.
So
what
they have
you have
post-
done for 2 weeks?
Lordship, my father had passed away on the 23rd. He's learned advocate Mr. Uttam Kumar there. And I was under mourning, so I could not take steps till the 6th. And just immediately after I resumed my work, I have prepared this. And the son of one of the directors is appearing for ISC, and his ISC is going on. I'm praying for an ad interim order.
What is the order? What is the impugned order?
There's no impugned order. They've just sent a notice stating that they'll take possession. But before that, they have already taken possession on the 18/4/2017. The notice is my annexure. But in spite of that, even in that notice, it is stated that in terms of the notice under section 21(1), in spite of that, on the 13th of this previous month, they have again sent a notice stating that
You granted to file the list tomorrow within 5 matters.
Grateful, my lord.
Yes, call the original side, original side. Huh? What? Original side? Please wait, please wait.
Lordship, may I mention one matter, Lordship, for upgradation, Lordship. Lordship, what happened, Lordship? I have submitted sale deed long back, Lordship, with all consideration amount. The authorities had tied over the matter. I have given representation.
You submitted the date for
Lordship, 2007, Lordship.
Huh?
2007.
2007. Now you are coming.
Lordship, no. Lordship, thereafter,
After
Lordship,
20 years.
I have moved writ petition, Lordship. I have moved writ petition. The Honorable High Court directed them to consider my representation. They did not consider. I filed contempt application. After that, they have reassessed the amount. I have challenged that reassessment, Lordship. I have challenged that reassessment, Lordship. Lordship, on 2 grounds, Lordship. Because after 5 years,
challenge the reassessment.
Reassessment, Lordship.
Then
Lordship, because
why you are telling that they are not registered?
No, registered that the reassessment
What is
order
the
passed
urgency now?
2024.
So what is the urgency?
No, so urgency is that my deed is pending, Lordship, since 2007.
It is pending since 2007. Now all of a sudden after within
No, Lordship,
after 8
I have given several representation, moved High Court. After that, they have reassessed, Lordship.
when the High Court was passed an order,
2024, Lordship.
and when they have passed a prepared order for
Lordship,
reassessment,
2025.
then
After filing contempt application, Lordship. In the contempt,
yes.
Much of it.
Lordships need to drop and complete judgment and decree passed by Lordships dated 11th November.
November decree till date you have not applied for.
Actually, we have received a notice recently
Ah.
to finalize the draft of the decree.
Ah.
So I have been told by the department that leave is required to complete. Grateful, Lordship.
If your Lordship takes up the 10 seconds of your Lordship. If your Lordship can accept the order of your Lordship of 11th February. Is that Blackstone tender matter? This is the order passed by your Lordship. Your Lordship was pleased to stay the
Auction.
auction process. Not after that, on that very day, we filed another writ petition. I mentioned your Lordship appreciated the urgency and directed the matter to appear. It is appearing today under the heading urgent motion as item number 50. All I was respectfully submitting, naturally the business of the court did not allow the matter to be taken. We are similarly placed. If it could be placed at the higher in the list, so that on 19th we can be heard along with the other petitioners, along with this batch. That's all. Because that restraint order cannot be passed once again. Your Lordship has already passed. Similarly placed, identical situation along with the other matter. This is all I am asking for. If it could be upgraded a little tomorrow.
So only it is to be listed along with this matter, nothing else.
Similarly placed, if your Lordship does not say, then I will not get into that frame. Because my rejection is also on the same ground. So if it comes a little, just a 10 seconds.
इसको कल ना उनको टू बी मेंशन में रख दो टू बी मेंशन में रख दो
Item number 55.
टुडे आइटम नंबर 55
कल के तुम्हें हमें खाओगे
टुडे आइटम नंबर नॉट दिस आइटम नंबर 55 है उसको कल टू बी मेंशन में कर दो उसको दे दो यस कॉल दैट
My lord, for the in item 2 we discussed
on 19 then
No, he was requesting for Friday. I thought your Lordship put it on Friday.
20
Yes.
ठीक है 20
Oh, it was 19th.
2020 kori.
We have no problem. He, my lord, has attended more of these matters from Delhi that I have attended from Calcutta.
Yes.
Cross proceedings will Chennai. Delhi versus Calcutta.
Yes.
Lord, good to see that smile. At least this pressure will not be on your lordship for a while, for an hour. It's been 6 months since your lordship took up the matter. I think September 9th is when I had last made my submissions. And
Yes,
I had made my opening submissions more than a year ago. So, Lord, much has flown since then. So, Lord, I suppose, let me remind your lordship, Lord,
December
in
it was, sir.
very short summary, let me give your lordship, Lord. And for that, Lord, as they say in the Sound of Music, Lord, let's start from the very beginning. A very good place to start. So, Lord, I'll give your lordship a very short summary, Lord.
Yes.
Well, the first part probably has nothing to do with this matter, but that background is necessary and your lordship remembers it. There was a probate proceeding in this court involving the estate of Priyamvada Devi Birla. Now, in that probate proceeding, obviously, my lord, the subject matter of this suit, which is not a school, a society, was not a party. So, my lord, South Point was not a party. Because their case entirely, my lord, depends on whether, my lord, those orders have any bearing on our matter at all. That's the principal defense thrown up by Mr. Mukherjee. So, my lord, I was not a party. I was never given notice of any application, nor was any order passed against me. This is the long and short of what took us probably half a day to explain earlier. But I was not a party, and that is the material factor. Now, why do I say I can't be bound by any of the orders? In a probate proceeding, the court only decides the genuineness and validity of the will. It doesn't decide any question with regard to the estate. But not even forgetting that, there is an affidavit of assets filed in a probate proceeding like any other probate proceeding. In that probate proceeding, and in the affidavit of assets, there is no mention of South Point, and there cannot be. Because, it is not a company where she has shares. A society does not have any shareholding, so I have nothing to do with it, really. Now, in addition to that, there have been a number of orders in the past which have made it clear. We have shown your lordship the affidavit of assets. We have also showed your lordship all those orders which make it clear that at the highest she could have been a shareholder in the company. Just because she was involved in a society, it's not a hereditary post that she will come in. So, there was no control per se. And in any case, even if it's a question of control, these judgments have held, that is not hereditary either. This is the background in which we come into the picture. No shareholding, nothing of that kind at all. Now, it's also important to just remind your lordship very shortly about the orders in those probate proceedings. So, the linchpin of their case is Justice Munshi's order. I'll just give your lordship the date. 18th of September 2020. So, that date becomes important only in the chronology. The date itself is not important. But in that, your lordship will remember, I've told your lordship this quite a few times. In that judgment, Justice Munshi says, in as many as 13 or 14 places, that no order can be passed against a third party. But two things in that order. So, one was in that, in the operative portion, there is an order not against the societies, but against Harshvardhan Lodha, who is a party to those proceedings. So, there's an order in personam saying that he is restrained from holding any office in any entity, what's the language? Any entities of the MP Birla group. So, that is the language. Now, that order is not directed against me, nor is there a order of cessation, that he will cease to hold whatever office. That is not there. So, maybe it is a personal restraint, which was a restraint which will carry on till the matter is decided. So, and this was one part. Secondly, there was an observation in that order after saying in 14 places no order can be passed against the third parties. There is an observation saying that now in the manner of voting, all entities will be guided by the APL committee. So, my lord, that question naturally arises now. These entities, whether they include me or not, my lord, that becomes an issue, but need not remain, because within 15 days of that order, my lord, on an appeal, there is a clarification granted by Justice Radhakrishnan's bench, and that's very clear. It makes it clear that the order in personam against Harshvardhan Lodha, if any, will operate only as far as companies are concerned.
Correct.
Places where on the strength of his shares, which must mean on companies alone. So, my lord, as far as we are concerned, as far as South Point is concerned, it's clarified once and for all, my lord, that look, we are not affected. And that is, my lord, later made absolutely clear, final hearing. But not for the time being, let's just put it this way, not societies and trusts go out of the purview of that order. Now, the other part of it is, once this clarification takes place, not my argument had been, it dates back to the date of the original order. So it is as if there was no order of disqualification at all. And if at all it was there, once the clarification takes place, it's gone. Now, in that chronology, not thereafter, not the division bench hears it and says that, look, and there's a cross appeal not filed by us, filed by them against that order. Not there's a cross appeal filed by them, which against those observations which say that no order can be passed against third parties. So that not cross appeal went. So not that is held to be good by the division bench. No order can be passed against third parties, and the division bench made it clear that neither the APL committee nor the probate court could have gone not beyond a certain jurisdiction. Not language used is very restricted. Could not have gone an inch beyond the jurisdiction of the probate court, etc. And Millard passes all the orders which bring it. Now, the only Millard factor now between these is that in between, the APL committee writes a letter to the society saying that HVL has, not remember, there's no order saying that he is removed. The APL committee writes a letter to the society saying that on the strength of the orders passed by Justice Munshi and Justice Radhakrishnan, he has ceased to be a member. The society itself does not remove him, only takes on record. And this not direction from the APL saying that he has ceased to be a member. Now, if it is found by your lordship ultimately or at any point of time that he had not ceased to be a member by virtue of Justice Munshi's order and Justice Radhakrishnan's order, then this letter which came in between would also be meaningless, because it only takes on record without a independent removal resolution. It only takes it on record. So if in fact not Justice Munshi's order and Justice Thotakil Radhakrishnan's order, if they say he is removed, that's the end of the matter. But if on the other hand they don't, then the question, then automatically it is clear that he continued. So this is what was the situation. Anyway, not all of this happened. No one made any noise about it. Now, thereafter comes the final order of the division bench. That also we have showed your lordship. I'll have to show it once more later on, but I'm just giving your lordship the summary. Now, in the meantime, one of the secretary and treasurer, Mr. Damani was the secretary and treasurer of the school. Now, in the meantime, it is found that he has been guilty of defalcation of funds, about 30 crores odd, removed, to companies owned by his wife, his daughters, etc., by handing out all these contracts. So this is found out, police complaint, investigation for a year, then he's arrested. Now, once this defalcation comes to light, a emergency meeting of the society is held by us. At that meeting, first thing which happens is he is removed. Second thing which happens is that there are some fresh appointments made. So these are the two major things which happened, and some people are appointed to administer the school, well-known, my lord, educationists or people of good repute, my lord, are appointed as administrators. Now, they are given notice of these meetings. Their complaint about this meeting is you did not give notice to or could not have given notice to Mr. Damani because by then he was in police custody. So that is their principal challenge. Now, as far as notice to the others, including Mr. Daga and others is concerned, receipt of notice is admitted.
Yes.
Now, once they know about these meetings, with notice of these meetings, they go and hold a rival meeting.
Correct.
They hold a rival meeting, which is the later meeting. And obviously, they have not given notice, my lord, to the people who are appointed there. Now, if my meeting is held to be not good, and for that also there's just one small point I'll get into. Mine is the earlier meeting. If my meeting is good and there are two other appointees and you hold a subsequent meeting without giving notice to them, that's the end of the matter, my lord. Their meeting goes. Their meeting goes. Now, in the meeting held by them, they seem to support Mr. Damani. And after this, my lord, countersuits are filed. One by us, one by them. Admitted position is there is a kind of stalemate. And it is in that background that we had asked for reliefs in our suit. They filed the suit. They did not move for interim reliefs. So ultimately, my lord, we moved our application and then, my lord, both were taken up together. But this is the background. Now, in the meantime, there were certain other actions, my lord. I've given you, my lord, it's no point getting into the factual detail. I think, my lord, your lordship has perhaps made a note of it. Otherwise, we'll give a note containing, my lord, details of the defalcation, suppression in holding the meeting. They filed a 144 and all of that. Now, my lord, the crux of this, my lord, is simply this. Their grievance against my meeting is that, look, in your meeting, Harshvardhan Lodha was present. And that is contrary to the orders passed in the High Court because he stood removed by those orders. Or he ceased to be by virtue of the order. So if that contention is correct, my meeting goes and his meeting may stand. If on the other hand, this contention is held to be wrong, if it is found that HVL did not stand removed by any court order, then, my lord, we are through and their meeting goes. But so therefore, this is the crux of the whole matter. Now, in addition, that is more or less not the crux of the matter. Now, it's in this background, I'll just give your lordship the legal arguments. Now, this is the factual background. The legal argument, but my argument when I moved it, apart from placing the facts, was, number one, there is no order of Justice Munshi or Justice Radhakrishnan because that letter which is forwarded says pursuant to these two orders.
Yes.
So, there is no order of removal by any court, is my first point. Second point was there is no independent resolution of removal. So, if I am correct in these two submissions, it means, Lord, if your lordship is with me on these two, then it means HVL was entitled to attend these meetings, in which case his challenge to my meeting goes. Challenge to my meeting goes means his subsequent meetings also get automatically, let's put it this way, vitiated. And they would go also. So this is the legal background, my lord. And the crux of the matter, therefore, ultimately turns back to, my lord, having a look at their resolution to see if it's an independent resolution, what did the resolution say, and whether the resolutions, what they record, is correct or not based on Justice Munshi and Justice Thotakil Radhakrishnan's orders. This is it. So this was, my lord, in short, my submission.
Yes.
Now, Mr. Mukherjee had countered these submissions. His counter was, number one, that he did stand removed pursuant to Justice Munshi's order. And Justice Radhakrishnan's order does nothing. It does nothing. The removal, the restraint, personal order of restraint remained.
Correct.
This is number one. So he says that Justice Munshi removed him from the society. Number two, he says that Justice Radhakrishnan's division bench order, that clarification is limited only to the companies. It did not relate to the societies. This is his second argument on that. Third, my learned friend also argued that Justice Munshi had the jurisdiction to pass these orders. So if he had the jurisdiction to pass the order, the fact that he may have passed an incorrect order, which was set aside by the division bench, doesn't make it a nullity. Because if he had the jurisdiction to pass the order, it doesn't become void. It is at the most, it can be set aside by the division bench, and it has, and therefore it does not take retrospective effect because it was not a nullity. This is the third limb of his argument. Fourth limb of this argument is that Justice Munshi's order remained at the time of the resolution which was passed on 21st of April, 16th of April, 2021.
Yes.
So he said that Justice Munshi's order was in operation, which again I'll show your lordship is wrong.
Yes.
And
Only the question is if that resolution remains, then you have gone. You will be out. If that resolution is not correct, not in accordance with law, then it has to.
so, no, I'm not even saying, I'm saying that there is no removal by that resolution. Correct.
Yes.
And the last argument made by my learned friend is, look, no proceedings were taken with regard to his removal. Therefore, his removal remains. Even if the order is set aside, he stands removed, he remains removed. And till he gets an order of court to reinstate him, he will always be out. He cannot automatically come back in. This was the last of his arguments. Then, in the alternative to this first round, first round of argument, like I said, is that, look, there is in fact a removal pursuant to court orders. He was justifying that by making these arguments. The second is, in any event, there is an independent resolution of the society. He is treating that 16th April as an independent resolution. I'll show your lordship it's not. Third point that he made was, our notice is bad because we did not give notice, or rather if notice was given, he did not have receipt, he did not have notice of the meeting because he was in police custody. Now, I'll show your lordship that's not ex facie wrong. A meeting can't be vitiated because someone is in jail. But notice was sent by email and received. And lastly, he said, the removal itself is bad because he is only in police custody. He has not yet been convicted, and he relied on a judgment for that. So, this is the full compass of the matter.
Yes.
In addition, there was one side point which is taken care of by me in two sentences. Mr. Mukherjee took pains to argue for a number of days that what's his name, Mr. Bishwajit Matilal has ceased to be a member of this, has ceased to be a trustee of this society. So he argued because he did not attend a certain number of meetings, he has ceased to be a trustee. So there I just pointed out straight away that this is not straight an argument from the bar. His case in the plaint is to the contrary. And please have a look at para 9 of CS16. Their suit. So, one point we can get rid of without any argument on this. Volume 1. But please turn to para 9. So, this is the first point which I make today. First, the argument that
page 6,
para 9, right at the bottom of the page.
Yes.
The present valid composition of trustees and the governing council of the society are as follows. A. Trustees. And please see item number 5. Yes. And then governing council. See item number 7. And this, according to me, is the present composition.
So this filed by whom?
Them, Mr. Mukherjee's client.
Valid composition of the trustee governing council.
This is pleading in the plaint.
Yes.
So that's why I argued, not this is a argument from the bar. It's
Not in the-
contradicted by his plaint. So, not the first point that Biswajit Matilal, who was present at the meeting, had ceased to be a member,
It's not correct.
and therefore, therefore the meeting is vitiated. This argument goes. This argument goes on the basis of their own pleadings.
Yes.
There are other paras to that effect. I won't trouble your lordship because I've showed this earlier. Now, okay, all the best. Okay, what are the resolution? Take it. 140.
Yes.
So, Mlad, one point is not easily disposed of. Now, Mlad, coming to the meat of the matter.
Yes.
Now, Mlad, the entire case of both sides, both suits will depend on this particular document and what it refers to. But I've showed your lordship this, but because of this not 6-month gap, I'm having to show your lordship this once more, Lord. Please don't mind. But if your lordship would take, not CS 21, IAGA 1, Volume 1. Hopefully, I won't trouble your lordship with too many things other than not the 3 judgments and not this. But your lordship, I'm seeing your lordship sleepy for the first time. Your lordship has, well, got bored of this by now, I suppose, and Lord, or this voice is being a lullaby.
Yes, paragraph.
Lord, if your lordship comes to page 42.
40.
42. Or 43. 43.
Yes.
Your lordship has got that? So, Lord, this is the resolution of which we are talking about.
Correct.
And Lord, I'll show your lordship this just once, Lord. Well, if your lordship would come to Lord, the first para itself. The society is in receipt of various communications dated 12th November and 27th February from the office of the administrator's pendant lighting of the estate, which are enclosed. Now, Lord, please mark this. These have not been disclosed anywhere. These 2 communications, not there, but they have quoted it. You are aware that during the lifetime of late Sri Priyamvada Devi Birla, she was a trustee as well as president of the governing council of the society. She exercised control over all the trusts and society of the MP Birla group, including this society. The other trustee and governing council members of the society were regularly guided by Ms. Srimati Birla as the promoter and acted as per overall vision, etc. After the demise of Srimati Birla, various disputes arose in connection with the succession and extent of estate of Srimati Priyamvada Devi Birla, and the same are still pending before the probate court. Late Sri R.S. Lodha, who had propounded a will of Srimati Priyamvada Devi Birla, bequeathing her entire assets to him, was already a trustee and vice president of the governing council of the society at the time of her death. So, Lord, please mark this. Lord, Mr. Lodha has been there in this society from the beginning. His son, Sri Harshvardhan Lodha, became a trustee and governing council member of the society in September 2003.
Yes.
So, Lord, he has been there all through uninterrupted. Sri R.S. Lodha passed away in October 2008, and after him, Sri Harsh Lodha, who has intestate successor of R.S. Lodha, is also one of the claimants of the estate, later became the president of the society. Then, Lord, by a set of judgments and orders, including a judgment and order of 21st August 2012, passed by the division bench of the Calcutta High Court, a 3-member committee was appointed as administrator pendent lighting for the purpose of administration. And my lord, the composition is given. Now, my lord, please take the second last para. On 2nd November 2020, the society received a communication from Khaitan Company, advocates for the defendants, enclosing the following decisions, judgments, orders, etc. So, my lord, your lordship finds 19th July, 30th July. These are decisions of the APL committee. Then, my lord, please come to item 3. Judgment and order of 18th September passed by the learned single judge of the Honorable High Court at Calcutta, and 4 is order dated 1st October of the Honorable Division Bench of the High Court. So now, my lord, please note this, that the 2 orders were also enclosed. Now, my lord, please turn the page. The letter of 12th November 2020 received by the society from the APL committee, copy attached. No, not attached here, and not disclosed, contains the judgment and order of 18th September of the learned single judge and the order of 1st October of the Honorable Division Bench passed in the matter of probate proceedings in respect of late Sri Priyamvada Devi Birla. Now, but please permit me to pause here for a moment. It's clear that up to now, not from 2008, Harshvardhan Lodha is continuing, not as president. Now, here on comes a series of letters. Before that, there is no dispute. Now, my lord, what do these letters say? Now, my lord, please see the next paragraph. The letter of 27 February 2021 received by the society from the APL committee informed that the APL committee at its meeting held on 26th had decided by a majority to nominate the following persons for being appointed as trustee member, etc. and names are enclosed. Not then after that, APL committee in the above letter of 27 February has also stated that the existing trustee, governing council, managing committee members of the society do not include Harsh V. Lodha anymore on account of the judgment of 18 September read with the order of 1st October. So, not if they had based it only on the single bench order, not there may have been something to say for them. But the moment they not show that they are aware of and this is happening post the clarification order, not the entire scenario painted here goes. 2 societies, namely MP Birla Nethralaya and MP Birla Medical, both part of the MP Birla with similar facts, have in the meantime. So, South Point has not. 2 other societies have in the meantime obtained opinion in the matter from Justice so-and-so on the following. Now, please see the question. 1. Whether Harsh V. Lodha ceases to hold office of trustee and chairman and member of the managing committee in these societies, consequent to the reading of the orders. Now, Lord, permit a major pause over here. Lord, it's clear that the orders themselves, therefore, did not remove. It needed a opinion to find out whether and what is the effect of these orders. Whether on a conjoint reading of these orders, Lord, he ceases to hold office. Lord, would a opinion have been necessary if not the order itself said he is removed or he has ceased? Answer is absolutely no. But this bears out the fact or my contention that no order said that he stands removed or he ceases to be a trustee. This in itself shows this. The fact that an opinion is being obtained on this topic.
Yes.
Then, my lord, please turn. Your lordship can leave to the opinion of Justice Ashok Kumar, Justice so-and-so on the above 2 queries is in the affirmative. Now, this opinion is not disclosed anyway. A copy of the opinion of 24th March is enclosed. Copy of the memorandum and articles is also enclosed. Now, my lord, please see what happens hereafter. In view of the above, your consent is hereby sought on the following resolutions which are intended to be passed by circulation. So, my lord, it's a circular resolution which they say has been passed. So, what's the resolution? Resolved that cessation of Sri Harsh Lodha as a trustee and president and member of the governing council, please mark the next word, consequent to the judgment dated 18 September of the Honorable Single Judge and the order dated so-and-so of the division bench passed in the matter of probate proceeding in the state of so-and-so as communicated by the office of the APL by their letter of 12th November, B, and is hereby noted, confirmed, and taken on record.
So this is the final resolution.
This is the resolution. This is the resolution. Now, my lord, if I may put it in very simple English, what does this resolution say? My lord, if I may put it in different terms.
You have cessation of the Harshvardhan Lodha as trustee.
Lord, we note, confirm, and take on record
Correct.
the cessation of Harsh Lodha.
Correct.
Not cessation per se. We are removing, not that we are removing, removal consequent to the judgment.
Correct.
So they are only taking on record, noting, confirming, and taking on record that he has ceased consequent to the judgment. Now, this is after cutting out all the unnecessary verbiage.
Yes.
We note, confirm, and take on record that the High Court pursuant to these orders has removed him,
Yes.
or he has ceased pursuant to these orders. This is not what the resolution says. That he has ceased as a consequence of the High Court orders. This is all that it's
So
saying.
this is not the decision. They have taken into consideration of the High Court order as he has been ceased to be.
Correct. Now, if there is no High Court order saying that he has ceased, then this resolution becomes meaningless.
Not conformity with the order.
Not only not in conformity with the order, it becomes meaningless because there is no removal by this. They are not removing, they are only noting. Let me not cut out 2 words. What if they simply noted that the High Court has removed, but the High Court has in fact not removed?
So continue.
Nothing happens. The resolution itself would be ineffective.
Okay. Yes.
But again, to put it simply, he says, this resolution simply says this, that HVL has ceased as a consequence of those 2 orders. Not that we are removing him.
Correct.
Your Lordship will note the word, there is no independent removal. But if that had been there, in any case we independently remove him, then, my lord, even if this part became meaningless, they would have still had some argument.
Yes.
And if your Lordship sees the next 2 portions, there is no removal. There is no removal. This is all that there is. Now, in this chronology, my lord, please, my lord, note the dates of the orders. Lord Justice Munshi's order was dated 18th of September.
2020.
Lord DB order was dated 1st of October.
20 days after.
And my lord, your Lordship will note this, 1st of October, clarification has come. The APL is writing after that.
12th of November.
Correct. When it could not have. Could not have after that clarification.
After division bench order.
Yes, could not have. And not just that, then, my lord, please see, they write in November, but the resolution is 16th of April, 2021.
Yes.
So, my lord, in this chronology, please see that how my lord, this argument is completely without basis, besides being, my lord, misconstruing 2 court orders. Complete misconstruction of 2 court orders. And even after I've pointed out, Lord, my learned friends have not showed anything from the order to contradict what I've said. That there is no part of Justice Munshi's order says he will stand removed from the societies. No part. And he says, look, third parties cannot be affected by my order. Completely, my lord, says that in 14 places.
Yes.
After that, my lord, if there is no removal by Justice Munshi, then, my lord, that's the end of the matter. If, on the other hand, there was a temporary disqualification on Harshvardhan Lodha, Lord, that went immediately on the clarification order of 1st October.
Correct.
So, Lord, after 1st October, The APL could not have written these two letters.
So they have not taken any independent decision for removal of the
Correct.
Vardhan Lodha
Correct.
and the High Court order, even though it taken the justice and order dated 18th of September, but they have taken the consideration of 1st October. So there will be no order of removal.
Correct. Correct. Not that is not that is
That
really
and the resolution is taken April after 5 months.
correct. So Milord, this is the long and short of it.
Yes.
This is the long and short of it. Now, to show your lordship that this stand is not permissible in fact or in law. This is all I'm going to show your lordship first. So, my lord, आगे मुंशी को देखो।
IGA4, CS16, GA4. अच्छा 132.
এটা কিছু করার নেই। হ্যাঁ। না ওই পেজটা বলো আমার এটা আমায় দিয়ে দাও আমার ভলিউম 1 Now, Lord, I'll just take your lordship first through Justice Munshi's order. Lord, it starts at page 40.
Yes.
No, actually, no. And put just what put with. This is where it starts, no? No. But please give me a moment. In a page, koto bolto eta? Please give me a moment. Yes. Yes, take it. Amlat, please come to the prayers in the application before Justice Munshi, which starts at page 7. But page 46 in your lordship's brief, and it would be, but the page number would also, inner page would be appearing on top, page 7.
Page
7. Inner page 7, page 46 of your lordship's brief.
Yes.
So, my lord, prayer A was asking for direction on the APL committee. Then, my lord, prayer C, if your lordship sees, prayer B was, my lord, APL committee, not directions were on A and B. C was they were asking for directions with regard to AGMs of 3 blood companies: Vindhya Telelink, Universal Cable, and Birla Cable, and Birla Corp, 4 companies in a probate proceeding.
Yes.
Now, my lord, if your lordship turns the page and sees prayer D, that's the only thing necessary for our purposes. They asked for leave to issue notice.
Yes.
If necessary, notice be issued to the concerned companies, trusts, and societies of the MP Birla Group, as mentioned in the schedule being Annex M, to ensure compliance of the decision, etc. Now, they did not serve any such notice on me. Although they asked for it, they did not. And they went and got some kind of ex-party order against these companies. But that was the subject matter of a different appeal. And the appellate court said, look, no order could have been passed without notice to these companies, and it set it aside. And directed them to give notice to whoever it wanted. Again, they did not give any notice to South Point. No notice to us. Your Lordship may make a note of the page where the first division bench order said that we make it clear. But page 550, your Lordship can make a note, para 5 of the operative portion.
DB order dated? This
4th May 2020. But which begins at, I'll give you a lordship the beginning page number. It's about 40 pages before that.
4th May 2020.
Yes, page 514.
Yes.
And what it says in essence is, no order can be passed without notice to a third party. That was the ground of appeal, and Lord, that succeeded. Now, from here, my lord, if I may just take your lordship to para 61, actually, page 112. That will be page 151 of the brief in a page 112.
Yes.
But I placed it in more detail earlier. I am not.
Yes, you already mean. I have taken note of it.
Yes, I know.
Yes,
Just reminding your lordship, we have been through this earlier. Wait, page
There is no
number.
difficulty to, yes.
Please give me one more moment. But there are many more places like that. I have too many marked over here. But if your lordship would come to page 112, Lord, there is no difficulty. Your lordship has marked that already. And then, my lord, probate court cannot extend its jurisdiction over a person or entity who is not a party to the proceeding. But please mark this, because this will be important for another argument made by Mr. Mukherjee. Probate court cannot extend its jurisdiction over a person or entity who is not a party to the proceeding.
Correct.
But again, 114, last page, your lordship must have marked it earlier. But page 153 of your lordship's brief.
Yes, last. Summing up the submission.
Summing up the submission as has been made on behalf of 3 notices
Order of
companies.
restraint any kind.
This court has a firm opinion that so far as they are concerned, no order of restraint of any kind could be passed by this probate court, since they are not parties to the proceeding. So, my lord, already, my lord, decided by Justice Munshi. And he says this not in the same vein in many other places. Now, my lord, from here, if your lordship would come to page 190. 190 of your lordship's brief, which would be in a page 152.
Yes.
তার আগে এটা দেখিয়ে দিই। Okay, থাক. Yeah. Only. Lord, your lordship will take the second line. Accordingly, now such entities would exercise voting rights.
Page. 1.
Very good.
According now, such entities exercise voting.
So, my lord, after, my lord, point I'm making is that after saying in, my lord, a dozen places that he can't pass orders against third parties, my lord, this stray sentence comes in. Accordingly, now such entities would exercise voting rights flowing from their investment in the companies controlled by PDB in the manner to be guided by the APL. So, after saying no orders can be passed against third parties, this observation comes in. It's not there in the operative portion. Now, this was the subject matter of the appeal, and the appeal has been allowed, not specifically, not
So that was set aside.
nullifying this. Specifically, also amongst other things, saying that this is completely without jurisdiction of the probate court. Probate court is this much, it can't go an inch further.
Yes.
Page 154. Am I give me this page number now? Yes. And my lord, again, my lord, after that observation, again the contrary, page 154, third para. Therefore, so far as the 3 noticee companies are concerned, upon consideration, I'm sorry, my lord,
Yes.
upon considering the submissions made by learned counsel so and so, this court, upon consideration of the ratio in so and so,
Page 190.
Lord, your lordship has got page 190.
Yes.
Yes.
193.
Yes, not
154.
third para.
Third paragraph. Yes. From that the present noticee company being not parties to the proceeding, no order can be passed against them as spread for by the defendant in their application being GA 1735 so and so. that person is also certified.
Correct. So, my lord, once more clarified even after that. Lord. Now, my lord, from there, please come to the next page. Now comes the operative portion. So, not your lordship has found A, B, C.
Correct.
Now, A. So, this is the operative portion. Plaintiff shall implement the decision dated 19th of July and 30th of July taken of the APL committee taken by majority, as also all consequential decisions of the APL in furtherance of such decision, and shall be restrained from drawing any benefit personally out of the assets of the estate of the deceased during the pendency of the testamentary suit. This we are not concerned with. Then Lord B. Plaintiffs are also restrained from interfering. So this from the decision, interfering with the decision of the APL and any decision that might be taken by it in future by majority if the same directly or indirectly relates to the estate of the deceased, and further the plaintiff number 1 is restrained from holding any office in any of the entities of the MP Birla Group during the pendency of the suit. Now please remember, my lord, I was not a party, I was not given notice. Now he is already saying that someone who is not a noticee can't be restrained. Now whether therefore this be not was a personal restraint on Harshvardhan Lodha.
Correct.
Now the question is whether I would then be affected by this order. Did he stand removed or not? Because this is not an order of removal. It is not in personam saying that he will
You have
not
been restrained from
My lord.
holding any office in the entities of
Correct.
the MP Birla.
Correct. Not me, my lord, this is Harshvardhan Lodha.
Harshvardhan.
He is restrained from holding any office in any of the entities
Correct.
during the pendency of the suit. So it's a personal restraint. It's not a restraint on the society. And this part is not what is clarified by Justice Radhakrishnan later. I'll show your lordship. Then not see defendants, meaning the other group, is also restrained by an order of injunction. So what is said is no one should interfere with the APL. Now, then, my lord, please see, after giving these directions, please see, my lord, at the bottom of the next page, 195.
Disposed of.
Disposed
probate
of
cannot be
GA
decided
1,
in
2.
issue against the
Now,
stranger.
my lord, please see 4.
Correct.
In view of the discussion and observation made hereinbefore at 98-99, this application stands disposed of to the effect that the probate court can't decide any issue against the stranger to the probate proceeding. And no order in this proceeding can be passed against this company. So please see the contradiction in terms. But it's clear that he did not intend the societies to be affected in any way. So this was now your lordship has found that direction at not in prayer B. Therefore, Harshvardhan Lodha is restrained from holding any office in any of the entities. Please mark this term, Lord. Any of the entities of the MP Birla Group during the
pendency.
So, my lord, these entities, if they are part of the Birla Group, MP Birla Group, may include perhaps trust societies, whatever. Now, look at the clarification which then comes, my lord. Lord, I have already told your lordship that, my lord, first, these societies have not been mentioned in the affidavit of assets. 2, not society, not a hereditary post. It's not something which can be passed down by will. She was not the owner of the not society per se, could not be. So, my lord, this is the background. Now, my lord, please come to the clarification order. Page 212. 212. And if your lordship would come to page 212, it starts at page 199.
212.
Yes, not para 20.
Yes, para 20.
We may, however, clarify. I'm sorry.
Yes, yes, yes.
We may, however, clarify that the word implement occurring in para A, we are not concerned with this part. A, among the 3 directions issued by the learned judge, means abide by. So there's a clarification on prayer A. We are not at all concerned with it. It's further clarified that the operation of para B among the directions, which is the one blood we were concerned with, would be a restriction on plaintiff number 1, Harshvardhan Lodha, to the extent of it being a restriction from holding any office in any of the entities of MP Birla Group during the pendency of this suit. Now see the underlined portion. On the strength of the shares referable to the estate of PDB.
So share, then it will come as a company.
Absolutely. But that's the point.
Suits on the strength of the shares referable to the state.
So it's made clear
PDP.
that the personal restraint is with regard to companies, and that too if the state holds shares in the company which are of control. One second.
Yes, not the society.
Correct. So not made clear.
Harshvardhan Lodha extend to being restriction from holding any office in any entities of the MP Birla during the pendency of the suit on the strength of share referable.
So, my lord, if your lordship goes back once to 194 and sees the difference, my lord, 194 bottom B. Further, the plaintiff number 1 is restrained from holding any office in any of the entities during the.
So any of the entities has been clarified as a share.
Shares belonging to Priyambada Devi Birla.
PDB.
Correct. So that clarification. Now, my lord,
yes.
So now, my lord, therefore, if I am correct, then my lord, the effect of both these orders, because according to me, my lord, Justice Munshi's order was also not a personal restraint as far as societies were concerned. And that is merely clarified by this order.
Division bench.
Because Justice Munshi had said, look, I'm not passing any order against third parties. And that is merely not clarified because he said it in 14 places. So it couldn't have been his intention when he said entities, he must have meant companies. And that is what is being clarified by the division bench on the basis of shares held by Priyambada Devi Birla. So, my lord, so this clarification given, my lord, puts the matter beyond issue. Now, my lord, read with that. I had not cited 3 judgments when I had made my submission, which say that not this is a clarification. The not language used is it is further clarified.
Clarification.
Now, the effect of a clarification, I had placed 3 judgments that a clarification dates back to the date of the order which it is clarifying.
Not from the.
It does not take effect from this date, but it goes back to the date of Justice Munshi's order. If your lordship wants to make a note, I'll show those judgments later. But if your lordship wants to make a note, now I will be showing those judgments.
Citation.
3 citations. One is that it operates retrospectively because it is only making it clear. That is 2012, 3 SCC, 340. I'm sorry, 2013, 3 SCC, 340.
Yes.
2012, I'm sorry, one more mistake by me, there's typo here. 2012, 13 SCC, 340.
2012,
13 SCC, 340.
Yes.
Also 2008, 14 SCC, 171. I've already showed the judgment, but I'll have to show these once more, my lord.
Yes.
And my lord, lastly, very strong language. On clarification, it is as if the earlier judgment is erased, and it is not there. Erased, ceases to exist, not. That is not 2007 3 SCC 557.
Yes.
Now, after this order was passed, but HVL continued in many of the companies. So they filed a contempt. That contempt was not filed against the societies. So it shows that their understanding also was that he is entitled to continue in these societies. As far as the contempts were concerned, they ultimately came to, they were dismissed. They went up in SLP, the joint APL not went up in SLP, that was also not. So that came to not, that was the end of that chapter. But it's clear, not that apart from the fact that there was no removal from the societies by the order, there was also no cessation.
Yes.
The cessation, if any, not ceased after the clarification, which dates back. So it is in this context, not that your lordship now has to go back to the notice once more, Lord. If your lordship permits me, I'll trouble your lordship once more with that notice, a circular resolution rather, not notice, not. CS20. Now, my lord, it's in this context that I once more take your lordship back to the resolution. Now let's read it in that regard.
Page?
But at page 44. It starts at 43. I just placed it. That's 16th of April 2020.
Yes, same.
Resolved that the cessation of Sri Harshloda as a trustee, not let's forget the other words, as a trustee, etc., consequent to the judgment.
These are the 2 years.
Of 18th September and the order of 1st October. Now, question is not, did he cease consequent to the judgments? Answer is no. There are two parts which I am holding out. One is he did not cease consequent to the orders. There was no cessation.
Yes.
Number two, what I am saying is, in any case, all that they are doing is that letter of the APL, they are only noting, confirming it and taking it on record.
Yes.
Third, there is no independent removal.
Yes, independent, there is no what we say.
Fourth is trying, please see how an attempt is made to mislead court. Because there is no scope for any debate on this. There is no cessation at all.
Yes.
So what they say is, look, we have taken legal opinion in two other matters. Your lordship has seen two societies. They have taken opinion. That opinion is also not disclosed. According, we took an opinion about whether he has ceased. So, please see now, how illogical this becomes. If I may put it this way, probate court says, I have no jurisdiction to pass any of these orders. Forget not clarification. Probate court says, I have no jurisdiction. The question then arises, could APL have had that jurisdiction? They misconstrue the court order and they say he has ceased pursuant to the order, which is not ex facie, not miscommunication of the or misinterpretation of the order of court.
Yes.
So, this takes care of this, and as your lordship must have noted, there is no independent removal. Three words used: noted, confirmed, taken on record.
Yes.
Don't do that. We will get into that. Now, thereafter came, the division bench final order of disposal. And that puts the whole thing, all of these actions, anything done by APL, they couldn't have moved an inch further, etc. That's a longer order. I may need to show your lordship a few more paragraphs from that. So I won't start that judgment today. What I'll do is, since we are on the chapter and your lordship has noted the three judgments, could I just show your lordship those three judgments? But I would have moved to another chapter, but I won't be able to finish. Oh, my lord, can I factually finish or one more narrative in that?
Yes.
It's better I show these three judgments, my lord. But if your lordship would first take, Lord,
Yes, already I noted that.
Your lordship has noted. So, but these three judgments were shown by me.
40 and 41, paragraph 14.
And Lord, out of that, if you're Lord, one of them, 2007 3 SCC, if your lordship would only take that once, Lord.
Yes.
Lord, it's as if the earlier judgment stands erased. Not that para.
Para 19. The doctrine of prospective overruling, although the applied for overcomes of such situation.
Lord, it para 19, and then Lord, your lordship
21.
must have seen para 20, where it quotes Lord
The earlier
Suresh
judgment.
Chandra Verma.
Suresh Chandra Verma, yes. So all the more subsequent judgment rendered on review petition is of one and only judgment rendered effective
Correct.
for all purpose, the earlier decision having been erased by the contending, continuing the review application. Yes.
So
para 22.
Para 21.
21, last.
Lord, para 20 talks about Lord, it dates back. Para 20 is dating back. Not para 20, the quotation is dating back. And 21 is the portion, Lord, where it says erased.
Yes.
Now, Mr. Mukherjee tried to Lord, distinguish it by saying one of them is a service law. And with regard to this judgment, Lord, 2007 3 SCC, he says that no law has been declared over here. No law is declared, not in.
He has relied on the paragraph 29.
Yes.
Of last line, the law declared by the court will have the retrospective effect if
Correct.
not otherwise stated to be.
Correct. So he says Justice Munshi's judgment, not when it was clarified, does not declare the law, therefore it won't. Not I don't see what difference in principle it has. Not a clarification declares the position.
Yes.
It declares the position and therefore not it acts retrospectively. Not that's borne out by all the other judgments I've cited.
Yes.
And my Lord, 2012-13 SCC, he said, look, that related to a service matter. Therefore, it doesn't apply. I don't know why. The principle is not absolutely clear there. And then 2008-14 SCC 171.
Para 35.
Lord, he says that that was a case where there was an error apparent on the record. Therefore, the clarification was retrospective. Otherwise, it won't be, which is not the correct position. My learned friend has not showed any judgment to the contrary that a clarification does not date back. He has not showed any authority to the contrary.
Yes.
Not prospective operation, your lordship will find in these judgments only.
Which one?
Prospective, not these same judgments say. Not when will it be prospective? When, my lord, there are two situations when it will be prospective. And unless the court says so, it will always be deemed to be retrospective. So in cases where it is deemed, where the court does not want it to be retrospective, it must say that it is prospective. That's what these judgments say. So my lord, that takes care of this point. In any event, not assume it is prospective. Justice Radhakrishnan's order or judgment was there long before the resolution. So clarification has taken place. I don't need retrospective.
Already there.
So the order was already there. So not this retrospective, not being retrospective will not matter. My attempt was only to show that if there is anything Justice Munshi's order which was against, that is also deemed to be gone. So, if there was no retrospective operation, let's assume it was not prospective. It means that the disqualification was there for a mere 10 to 15 days. That's it. But it went immediately after Justice Radhakrishnan's order. So, my lord, that takes care of this point.
Correct.
Lord, your lordship has kept it tomorrow. I'll continue from there.
From
Lord.
tomorrow.
I believe 4:15 your lordship has kept some other matter. Better come What? What time will it?
Mr. Ranjan Bachawat, learned senior advocate, appearing for the defendant number 2 in CS 16 of 2024 and CS and plaintiff in CS 21 of 2024 has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear tomorrow at 3 p.m.
You all decide. We can't go outside. Let's see.
Yes, tomorrow 3 p.m.
Obliged.
My lord, I appear for the petitioner.
Yes.
My lord, this is, my lord, against an order passed by your lordship on 9th of January regarding, my lord, trust. Certain orders of injunction were passed. My lord, I had placed the contempt petition. There were 2 contempt petitions, at least in the second contempt petition, after passing of the order, my lord, the income tax filing has been done, and that was post the order of your lordship. So he was still representing as a trustee. And considering the prima facie case, lordship felt that lordship would call the contemptor to be present personally.
Yes. By which order?
My lord, the parent order is, of which I am alleging contempt, is the order dated 9 January 2025.
9 January?
Yes, lordship is looking at CC 65, contempt petition 65.
Yes.
Yes, my lord, that will be at page 123 of volume.
What is the operative portion?
My lord, the operative portion is at page
the plaintiff has made out a prima facie balance and so.
127, my lord, is the operative part.
Prayer A, B, and C, A, B, C, D, E, and G.
And those prayers, lordship will find from page 55 onwards.
Yes. Restricting the defendant number 1. Who is the defendant number 1?
Defendant number 1 is the alleged contemptor.
Devkinandan Chaudhary. Giving any effect on relying on the using a manner of.
Lordship had passed A, C, D, E, and G.
Yes.
E is the relevant prayer because lordship had restrained defendant number 1 from interfering with the management of the trust.
Yes. So where is the allegation? What
Now kindly comes, there was a, my lord, kindly comes to paragraph 19 and 20 of my contempt petition, which is at page 20, my lord.
19.
Paragraphs 19 and 20.
Yes.
I'll just place these 2 paragraphs, my lord. Subsequent to the filing of the contempt application, the petitioner was, this contempt application is the first contempt application, CC 27. There is another contempt. Subsequent to the filing of the contempt application, petitioner was able to get access to the account of the said trust maintained with the Income Tax Department, Government of India on the website so and so. Contemptor had illegally and fraudulently changed the password of the trust on the website of the Income Tax Department to deny other trustees access to the said account. It is only after filing of the suit and upon passing of the solemn order dated 9 January 2025, the petitioner was able to apply through the e-filing portal of the Income Tax Department to reset the password of the account of the said trust on the income tax website. Upon having such access to the income tax portal of the trust, Petitioner downloaded the latest income tax return shown to have been filed by the said trust on or about 29 January 2025 for the assessment year 23-24. Upon perusal of the revised income tax return, petitioner was shocked and surprised to find same had been wrongfully and fraudulently filed by the defendant number 1, contemptor, on 29th January 2025 in contumacious, willful and deliberate disobedience and violation of the order dated 9 January 2025. From the said revised income tax return, it transpires that contemptor had shown investments made by the trust as rupees so and so 87,21,418 without having ever disclosed the particulars of such investment. The defendant number 1, contemptor, purported to disclose in the said revised income tax return that an amount of 2,11,768 had been purportedly applied towards purported expenditure of the trust without specifying the intended designated purpose of making such application. Well, this act of again representing himself as the trustee and dealing with the affairs of the trust or management of the trust with the income tax authorities, we had not disclosed the document inadvertently in the petition, so Lordship allowed me to file a supplementary affidavit. Kindly takes the supplementary affidavit in CC 65 and kindly comes to page 7. This is what I had shown the other day, and considering this, Lordship prima facie held that there was an act of contempt. Next. Supplementary. Supplementary then.
Page?
My lord, page 7.
When it was.
My lord, kindly takes the date of filing, my lord. Possibly there would be, my lord,
29 January.
yes. And Lordship's order was 9th of January 2025.
Yes.
And Lordship's order had restrained, my lord, this defendant number 1, my lord, who is the alleged contemptor here now.
Yes.
From, my lord, dealing with the my lord. So therefore, Lordship was prima facie of the opinion that this is an act of contempt and that order requiring his personal appearance was passed. It so happened that the business of the court did not permit the contempt petition to be taken up earlier. Therefore, I had mentioned and Lordship was kind enough to fix it.
Who?
But so far as his personal appearance is concerned, it was pursuant to the document which I had produced in my affidavit in opposition to CC 27, the first contempt. They had taken the point that because after the order he had forged this particular document. He had forged this particular document, to come out of the contempt. This document, is an appointment letter of one Niranjan Dev Sharma.
Page
21, This document is dated 10th of January, They had stated, that after 9th of January, an order which my lord had granted the ad interim injunction, they had said, they had said, they had said, that this document was forged, to come out of the contempt, because this was my defense that it was made before. Now, I have filed a supplementary affidavit. I'm handing over a copy to my learned friend, only to bring on record, the WhatsApp chat, which was on 10th of January 2025 at page 10. I have a better copy also. Same thing I brought a printout. This is that same document. The appointment was made on 1st, and this document was made on 10th of January itself. No, there was no contempt so far as CC 27 is concerned, because this document was not forged. I have stated on an affidavit, and this is the WhatsApp communication at page 10. My lord, may kindly see.
What is the date of the order?
The date of the order is 9th. I had received the copy of the order along with the application on 13th. So, my lord, this cannot be a document which has been forged by me, to come out of the contempt so far as CC 27 is concerned. Your lordship may kindly, my lord, at page 10 of the supplementary. Kindly see that the top, the date.
Page 10 of the supplement.
I
I just filed a supplementary one just now.
Yes.
Affirmed on 13th November 2025. Your Lordship may kindly see that the doc 10th of January 2025.
Correct.
Your Lordship may kindly see the document and your Lordship may kindly compares with the document at page 21. Is that same document which was made on 10th of January? It was sent to Niranjan Dev Sharma. His appointment was made on 1st and this was the authorization which was made on 10th of January.
Appointment was made on 1st of
January 2025. It was before the order the appointment was made and Lord, order was served on me on 13th and this document was made on 10th. So my Lord, there is no contempt so far as this is concerned because this document was made on 10th and it was Lord, through WhatsApp it was served to Niranjan Dev Sharma. I have the mobile also through which this screenshot has been taken.
who has sent this?
This has been sent by the defendant number 1, my Lord.
Who is the different number?
Lord, the person who was called today.
No, so who has sent this?
This has been sent by Devkinandan Chaudhary, the alleged contemner, to my Lord Niranjan Dev Sharma, who has been authorized on 10. So my Lord, there is no question of contempt so far as this is concerned, because this document is not forged at all. On the last occasion, if my Lord remembers, this was this was the topic of discussion that this is a forged document. You have made it only to circumvent this document. So, my Lord, this WhatsApp communication.
No, what is this document?
This is the document at page 21, my Lord. They have relied in their contempt, my Lord, that I have done it after I was aware of the order.
What is this document?
This document, my Lord, authorizes Mr. Niranjan Dev Sharma to take care of the properties in, my Lord, Ratangarh, Rajasthan, in the absence of Devkinandan Chaudhary.
Correct.
So, my Lord, the order of injunction was not restraint on him to act as represent as a trustee. This order was passed on 9th of January 2025, admittedly served to me, my Lord, on 13th of January. This appointment and this authorization was all predated, my Lord, 9th of January 2025. This was made on 10th, before I got to know about the order. And Lord, that is why your Lordship, on that day, my Lord, your Lordship was of prima facie of the view that this document is forged. So you bring the person, you bring the alleged contempt. His appearance was called for. That is why, my Lord, he is appearing today.
Okay. That's all.
This is so far as first.
My Lord, so far as this CC 27 is concerned, this also would show, my Lord, that it is an act of contempt. Kindly takes the date. Though I have not used an affidavit, if Lordship wants, I can also use an affidavit dealing with the supplementary. I have just been favored with a copy. Kindly comes to page 10.
Yes.
My Lord, the date is 10th of January.
Correct.
My Lord, this order is dated 9th of January.
Correct.
A document is prepared on 8th of January. Let us proceed on the premise that the document is not a document which has been prepared after the order. So, my Lord, on 10th of January, a document can be prepared with a date of 8th of January, unless you show from the WhatsApp communication that this document was sent from defendant number 1 alleged contemner, I will not say alleged, contemner, to my Lord Niranjan Dev Sharma on 8th, that is before your Lordship's order. It means like this, my Lord, I prepare a document, I keep it. Then I see the order, and then on 10th, next day, I send the document and then justify that no, this is predating the order. So this is a clear case of contempt here, my Lord. What is that document, my Lord? Kindly take CC 27, the affidavit in opposition. If I have understood my learned friend's contention correctly, kindly compares this, my Lord, supplementary affidavit page.
Who has made the notary?
This was exactly Lordship's, my Lord, query on the last date.
Who has made the notary?
Notary has been made, my Lord, by Qazi Khalekujaman.
And what was the necessity of a notarial certificate in this document?
That is not, my Lord, with deepest of respect, that cannot be the jury.
No, I am not on that.
I have the mobile WhatsApp also, I can show it was sent on there.
That is different thing. I want notary. You know the notary, how the notary is to be done, how the notary is to be proved.
Lord, the person who is affirming this has to be in front of the
Where is the number?
number.
By which number did, which serial number the notary was registered?
And register.
The notary has to
Right, so, Milord, it's there, Milord. Serial number 101
But
dated
that's why I'm asking, where is the number
at the top, Your Lordship, just after the page number.
after the
Page 21, Milord, where 21 is written -21 in
Page
the affidavit in opposition, Milord.
this one?
Of the affidavit in opposition, Milord, or to CC 27.
No, I am asking from this document.
Yes, Milord, from the
Where is that?
Milord, this document.
Where is that? Because the number is to be kept put in the document itself. Where is
And
the
I'm handing over, Milord, kindly seize the mobile. At the top, Milord, in the red ink, it's written.
That's why I'm asking. 101.
101.
Hmm.
This alleged contemptor has, Milord, given this authority. He has signed. That is why he was present before the notary. Milord, this cannot be, Milord, a false document. On 13th, I was made aware of this order. Kindly seize the WhatsApp. I'm carrying the mobile also. This was made on 10th. So, Milord, there's no question of contempt that I forged this document. This was the hue and cry on the last day.
Mr. Ali should not be that vociferous when he is representing a contemptor, my lord. I will demonstrate here from both the petitions that he is still in, my lord, contempt.
Seriously.
Yes, next.
That is why.
Next. What about the
No, Milord, this is concerned, Milord. This is not an act in contempt, Milord. In my deepest of Milord, respect, Milord, this is not an act.
next? 65.
Milord, 65, Milord.
Milord,
65, Your Lordship may kindly takes my explanation, but there cases, Milord, that I have filed this. I'll just show, Milord. Yes, from 29, paragraph 29, Milord, with my Lord's liberty, Milord, I'm just reading it.
Where?
Of my opposition to CC 65.
Yes.
Page?
Page 20.
Yes. Para 29.
Yes, Lord. Paragraph 29. Lord, we have, Lord, I have stated that, Lord, on and from December 20, 2024 till 8th of January 2025, the defendant number 1, who is the alleged contemptor here, Lord, was traveling and was not in town for his medical reasons, and subsequently, Lord, I'm being led by Mr. Please continue. And subsequently had to urgently travel to Ratangad on December 18, 2024, as the plaintiff was causing nuisance and obstruction in the affairs of the Public Charitable Trust.
Correct.
The acts of nuisance and or disturbance of the plaintiff was duly communicated to the Ratangad police station by the defendant number 1 on 16th of December 2024. After the return of defendant number 1 to Calcutta, the defendant number 1 visited the office of the chartered accountant on January 8, 2024 and provided the relevant instructions and or clarifications as regard the alleged demand is concerned. So, my lord, this particular filing, my lord, was not a filing of the annual return. It was, my lord, an answer to the demand raised by the income tax authorities to the tune of rupees 32 lakhs on me, on the trust. The auditor was instructed to comply with the income tax demand so as to ensure that the demand is not finalized upon the public charitable trust and to do the necessary revisions as required. It is pertinent to mention that certain statutory compliances are to be done on a monthly basis and frequent intervals for which no special instructions are given. Next, it is the auditor who had filed the revised return on January 29, 2025 on the basis of the clarifications given by the defendant number 1 on January 8, 2025. It is pertinent to mention that on and after January 9, 2025, no further instructions were given to the auditor for the income tax demand for the assessment year such and such. It is stated that the trust is a public charitable trust and had the auditor not filed the revised return in view of the public interest, the trust would have had incurred a tax liability of 31 lakhs 56,930, excluding further interest and penalty. The filing of the revised return was a necessity to avoid tax impositions upon the trust.
Correct.
The revised return filed by the auditor was accepted by the income tax department and the demand was set aside. The income tax authorities had issued a refund of rupees 19,000 in favor of the public charitable trust. The instructions of the defendant number 1 was not after January 9, 2025 and on knowledge of the order dated January 9, 2025 and the same predated the order dated January 9, 2025. Then the plaintiff on the one hand is alleging mismanagement of the trust, whereas at the same breath is challenging the revised.
What was the amount of the return?
Return lot 19,210. It was refunded.
No, the return amount. No, what is the amount deposited at the time of filing of the income tax return?
Amount was not deposited.
Not
There was a demand on the trust
Mhm.
to the tune of 35 lakhs. That clarification after we gave the
This page paragraph page 7 the income tax return.
Yes.
Income tax return you submitted.
Yes.
When you submitted.
Income tax return was accepted. But before the statutory time period, which is most probably August 24, September or August 2024. So after filing of the return, there were certain clarifications called for, and in view of and along with the clarification, a penalty was sought to be imposed. That penalty, your lordship may kindly see at page 24. It starts
24
of the opposition, my lord. That is the income tax communication.
Lord, two apologies. One for my client.
Till date, no apology. Till date, no apology has been asked for. I have taken note of it. He has argued that high voice. He has not asked for the apology. That's why I have taken note of it.
See for us.
Till date, he has argued the matter being a contender in a high voice, but he has not taken the apology.
So that's unfair on the client.
Not unfair on the client, because I don't want to open the mouth. Yes.
I apologize on behalf of my junior also, but I actually tender unconditional apology on
Because
behalf of
now,
my
if the juniors appears in the contempt matter, so they should be shown to the court. And first they have to, the senior is asking also, but he is taking as a gesture.
Oh, Ultramarch. It's the teaching, no? Only the court is teaching, no?
Yes.
One thing is a matter, the other is an officer of the court. In fact, the other day
That's I'm
I-
telling, not neither the court is having any grievance of any of the parties.
And it's to our, as members of the bar, it's to our advantage that people respect the, it's the first thing that one must do for the institution.
Yes.
Absolutely. If that has not been done, I'm sorry. And that's why I wanted to give two apologies. One for myself, that I should have been here.
Okay, now what, it's okay. This page number 7, that is the income tax return.
Yes.
Correct.
May I just show two things, and then I'll actually be at your lordship's mercy. Just once, please have a look at page 24 of my affidavit in opposition.
24.
Yes, please.
Yes.
Yeah, then. So your lordship will find this is addressed to the trust. Please find attached the income tax intimation with respect to the return of income filed by you for the assessment year 23-24. Apropos my lord's query, please have a look at one document. I'll just show that to show when it was filed.
Yeah, that's why I want when you have
Yes.
filed.
Yes,
Because
the date is here. I just saw that date. At page 26, please have a look at.
page 26.
Also in English, I just saw it in English. If I read it in Hindi, your lordship will issue a contempt against me.
Page 26 of the affidavit.
39 of my affidavit. Yes, page 39 of my affidavit.
Yes.
You have a demand. At center of the page, your lordship will find
Page
date of
39.
filing.
39.
Page 39
Of the
my
affidavit.
in opposition. Yes,
Of 27. Of 65. Of 65.
yes, 65.
65. Page 39 is different.
Why affidavit in opposition?
Acha, supplementary affidavit. 39.
Yes.
Yes.
Have a look at the date of filing, Lord. It's somewhere in the center. 29th November 2023.
Correct.
Order is dated 20th of December 2024. And this came to us on 20th of December. This your lordship will find corroborated at page 24. 39 that date, your lordship will find at 24. It's dated 20th of December 2024. With respect to return of income filed by you, this was filed by me in January 23.
So your case is that the return was deposited filed on 29/11.
Yes, not from
Thereafter,
statutory documents.
and thereafter the 20th December demand was made.
Demand was made.
And
which we clarified.
and as per the demand, then you have submitted this.
And at 39, your lordship will find there's an amount of demand of 31,56,930. And at page 53,
Yes, page 53.
Page 53, this is the refund.
Refund of?
Refund for the same assessment year 23-24.
Yes. Yes.
This is what we have done. Now, with the unconditional apology, but this was really legally, if I have to put it on the basis of doctrine of necessity, I had to do it. It came to me. It was for the benefit of the trust. I don't want to get into it. I genuinely have advised my client also not to get into it. If the court in the slightest of has hesitation about my conduct, I'm sorry, my client is here. I'm tendering that apology. The apology is also there on my affidavit.
Yes.
But there possibly has been no willful disobedience. Lord, will kindly consider that.
Yes.
And the way Mr. Banerjee has, my lord, now represented his client, I otherwise would have agreed. But I still want to draw my lord's attention to two facts and then I leave it to your lordship. Because it is my duty as an officer also to bring it to your notice, my lord. Kindly comes to my lord, CC 27 once. The first, my lord, contempt petition, had this been one occasion, my lord, we would have also, my lord, understood. But it is now being repeated. Kindly comes to the supplementary affidavit which Mr. Ali handed over. And what is the significance of this document? Why is he, my lord, showing this WhatsApp message?
Yes.
As I said, my lord, the date at page 10, my lord, of the WhatsApp communication, from it, my lord, it will appear it's 10th of January. So on 10th of January, a document which appears to be dated 8th of January is being sent by the contemptor to Niranjanji of Ratangarh, possibly, whose name is Niranjan Dev Sharma. What was my allegation? My allegation in the petition was that this gentleman, defendant number 1, was trying to usurp and intermeddle with the affairs of the trust. Lordship was pleased to hold that there is a prima facie case and restrain the gentleman by orders of injunction. So he could not have appointed anybody to seek control of the trust property. This trust property was in Ratangarh. Now what he does, my lord, in his affidavit at page 13 to this contempt petition, kindly takes my lord affidavit in opposition. This was the supplementary.
Yes.
My lord, page 13, subpara A.
Yes.
He says Niranjan Dev Sharma was appointed on 1st January 2025 as the Vyavasthapak to ensure proper maintenance, safety and upkeep of Chaudhary Bhavan. Upon such appointment of Niranjan Dev Sharma, his name was printed at the outside wall. Then Niranjan Dev Sharma was authorized by the trust to do various acts on my behalf and in my absence by way of authorization dated 8th January 2025. If this was there, my lord, this would have, my lord, at least, my lord, in the affidavit to the main petition, they would have taken this as a stand, or they would have, my lord, got the order modified on the ground that I had already prior to the order appointed somebody. So please modify the order to that extent. There is no such application. On the contrary, they now try to justify with a notarial certificate document, which is, my lord, clearly after your lordship's order of 9 January, dated 10 January, and that document was sent to Niranjan Dev Sharma on 10th of January. So this is, my lord, the first act of contempt in CC 27. I don't think, my lord, he has purged himself out of this contempt.
Okay.
This is one. Second, my lord, in CC 65, kindly comes back to CC 65. I will show only one page, my lord, from the supplementary affidavit. I had shown the date of filing to be 29th of January. That is after your lordship's order. My lord, the stand in the affidavit is that I have not done that. I was traveling. When I came back, I gave instructions. My auditor did it. Now kindly comes to page 62 of the supplementary affidavit.
Yes.
Someone must take responsibility. 29th of January is the filing date. Who is the person who is verifying? I, Devaki Nandan Chaudhary, the, my lord, contemptor. What is the date, my lord? 29th of January. My lord, all these statements in the affidavit is belied by the document itself.
Yes.
There is an order of the court. I can understand. Maybe I was not entitled to the order. You can appeal from the from that order. You have other recourse available. Not by this method. That you will not respect the order of the court. You will go on acting in violation of the order of the court. You will go on representing the trust, and then come and say, no, my auditor did it. And when I was, my lord, I placed my, when I had submitted earlier on these contempt applications, my lord, it was really this page which prompted your lordship to, my lord, call the contemptor personally.
Yes.
And in his affidavit in CC, my lord, 65, one paragraph, paragraph 32, at page 20, in the opposition they have filed to CC 65, page 20, paragraph 32.
Yes.
It is the auditor who has filed the revised return on January 29. Then why is your signature, your name appearing there in that document at page 62? It has to be digitally signed. Somebody, auditor cannot upload the document without a digital signature. A DIN is necessary.
Yes.
This also, my lord, according to me, is a clear case of contempt.
Yes.
My lord, a rule should be issued calling for an explanation. Lordship had granted them an opportunity to file an affidavit.
Yes.
Therefore, my lord, this is a clear case of contempt. I rest, my lord, I leave it to your lordship.
Yes.
This, apropos, my lord, only one thing. The lordship has seen page 24, my lord, this comes on 20th of December 2024, the notice. And finally at page 59 that I had shown. 53.
Yes.
53, your lordship has seen the date, no? It was only on 5th of February 2025.
50?
Page 53 of my affidavit in opposition. It was 5th of February 2025. Now, my income tax understanding is very poor, so I checked up myself. Unless I file revised return after a penalty notice is issued, but I'm again, the trust is going to be exposed to certain kind of other penal implications. The revised return had to be filed. I have just taken instruction that digital signature is mine. But the auditor can actually do that because it has my digital signature, it just has to be uploaded. But we have never really even remotely tried to violate your lordship's order. It was something that was necessary actually for the benefit of the trust. My learned friend seeks contempt, I understand that. But on the other hand, he should have been happy that I've saved the trust 31 lakhs. The money has not come to me. In fact, your lordship has passed orders, where out of my pocket I have held pujas. The money hasn't come to me. By doing something, I have not interfered. Your lordship's injunction I should not interfere with the affairs of the management of the trust. I have not interfered with the affairs. In fact, due to this digital signature, he's right to a certain extent. It has to have my signature. But the money actually comes back into the trust. I have saved the trust 31 lakhs from a demand. But you will kindly consider that. The intention was never to interfere with the affairs
and functioning of the trust.
But that is not the explanation. See, digital signature.
Kindly just also indicate.
Kindly come to the page 20, paragraph 32.
Your Lordship is looking at?
Supplement affidavit in opposition.
To 27?
Yes.
No, to CC 65.
65.
Para 32.
65, paragraph 32. It is the auditor who had filed the revised return.
On the basis of clarification, this is also my stand. One more aspect.
Correct. But the signature you're telling that, no, is a digital signature taken by them. Where is that?
Yes, but that stand is consistent that I had not done anything. One more aspect, if your Lordship could just allow me to. One aspect for your Lordship's kind consideration, that if your Lordship looks at the injunction which is at page 158, I'll just place it. Your Lordship, kindly consider it one.
What do you want?
Injunction order 9 January.
এখানেও আছে page 123 of this petition.
Page 123, the
123 of
operative
this
portion, page 124, 127, 127.
Operative part, yes.
Operative part, your Lordship, what he gets is an ad interim injunction in terms of A, C, E, and G.
Correct.
But if your Lordship looks at the prayers in the injunction, what he didn't
Page
get
55.
at page 55.
Volume 1.
Yes, page 57, E come to E. Page 57, page 57, E.
He's telling me I am assisting you.
Page 57,
Yeah.
E. Order in.
Interfering with the management of the trust. So very humbly.
No,
No, it continues.
No, can you
Management of the trust.
manage?
In any manner dealing with any of the assets and the properties of the said trust being so and so.
Correct.
So with extreme humility, and with a lot of apology, this may not really be interfering with the affairs, and in fact the prayer that we had and it did not get.
Okay.
If your Lordship see,
The petitioner has filed two contempt applications.
Content. One was for Niranjan Dev Sharma, Vyavasthapak appointed despite your Lordship's order. One was this income tax pilot filing.
Filed the two contempt application with CC 27 of 2025 and CC 65 of 2025 on the allegation that the alleged contemner number only one contemner. The alleged contemner has violated the order passed by this court dated 9th of January 2025. Full stop. The petitioner submits that this court has passed the order dated 9th of January 2025 and passed the ad interim injunction, a restraining ad interim injunction in terms of prayer A, C, D, E, and G of the A, C, D, E, and G of GA1 of 2025. Full stop. The petitioner has communicated the said order, and the order was duly received by the alleged contemner. But in spite of receipt of the order passed, interim order passed by this court, the alleged contemner has. Where is that document? Supplementary. The alleged contemner has the document which you're. Where is the document in 27? From the opposition.
yes, page 21 of the opposition is the 8 January document. Opposition page 21 that 8 January document. And the voters today they have filed
by the alleged contempt, but in spite of receipt of the order in spite of having the knowledge of the interim order passed by this court, comma, the alleged contemner has issued a certificate under the heading to whomsoever it may concern. So to whomsoever it may concern, inverted comma, yeah? Dated 8th of January 2025. 8th of January 2025, which was alleged to have been notarized on 10th of January 2025, wherein the alleged contemner has, what is this? Alleged contemner has appointed one Sri Niranjan Dev Sharma as Vyavasthapak of the Kanhaiya Lal Rajkumar Memorial Trust. Memorial Trust. Full stop. The other contempt application, the petitioner alleged that the alleged contemner has violated the order passed by this court dated 9th of January 2025 by verifying the e-filing of the income tax return of the trust on 29th of January 2025. 2025. Full stop. 2020. The alleged contemner is present and filed affidavit in opposition as well as supplementary affidavit. In the affidavit in opposition of CC 27 of 2025, comma, the alleged contemner has stated that one Niranjan Dev Sharma was appointed on 1st of January 2025 by the trust as Vyavasthapak for proper maintenance of the properties of the trust. It is further mentioned that the alleged contemner had authorized one Niranjan, it is further submitted that Niranjan Dev Sharma was authorized by the trust to do various acts on behalf of the trust and in the absence of the alleged contemner, and accordingly on 8th of January 2025, he has executed the certificate in favor of Niranjan Luthra. Niranjan Dev Sharma, in favor of Niranjan Dev Sharma, and subsequent, though on 8 January, he has issued the certificate in favor of Niranjan Dev Sharma, and the order passed by this court was received by the alleged contemner on 10th of January 2025, and accordingly the 13th of January 2025, and the certificate issued by the alleged contemner is in favor of Niranjan Dev Sharma on 10th of January 2025, and as such, the petitioner had no knowledge about the order, and the order was received only on 13th of January 2025. Thus, the petitioner the alleged contemner has not committed any violation of the order passed by this court. As regard, full stop. Consider the submission, full stop. Learned counsel for the petitioner submit that in the affidavit in opposition, at paragraph 19 within bracket small a, The alleged small a. The alleged contemner stated that Niranjan Dev Sharma was appointed on 1st of January 2025 as Vyasthapak of the trust, but there is no document has been submitted to prove that the trust has appointed Sri Naranjan Dev Sharma as Vyasthapak on 1st of January 2025. He submits that the alleged contemner had the knowledge that this court has passed an order and only to save their skin from the contempt, proceeding, have backdated the documents at 8 January 2025 and 10th of January 2025. Full stop. Considering the above, full stop. The alleged contemner has also filed a supplementary affidavit by disclosing the WhatsApp message of 10th of January 2025, wherein it reveals that the certificate which was executed by the alleged contemner on 8th of January 2025 was forwarded on 10th of January 2025. Full stop. Considering the submission made by the counsel for the respective parties, peruse the materials on record. This court find that admittedly the alleged contemner has received the order passed by this court on 13th of January 2025. The document on the basis of which the petitioner has filed the contempt application is of 8th of January 2025 and 10th of January 2025. Thus, this court did not find any materials on record that the alleged contemner has antedated the said document to save from the contempt proceeding. Accordingly, this court did not find any willful and deliberate violation of the order passed by this court with respect of the CC number 27 of 2025. Accordingly, the same is dismissed. As regard the CC 65 of 2025, the alleged contemner has verified the income tax return on 29th of January 2025. The alleged contemner had the knowledge with regard to the order passed by this court dated 9th of January 2025. The police counsel for the alleged contemner submit that the alleged contemner already filed the return to the income tax department, which is the page on 29th of November 2023. Now, file the income tax return on 23. Where is that? 29th. But this is with regard to the 29th and that 2023. Kya bola? Has filed the income tax return with return on for the financial year 23-24. After filing of the return, the income tax department has made the demand on 20th December. Made the demand on 20th of December 2024. And after receipt of this demand from the income tax department, the alleged contemner has informed his chartered accountant with regard to the same, and given proper instruction to the chartered accountant, and the chartered accountant has deposited, has taken has taken appropriate steps and informed the department that the amount is to be returned to the alleged contemner, that is to the trust, and thus the chartered accountant, by using the what by using the digital signature of the alleged contemner, has submitted the revised return to the income tax department, and he submit that by submitting this revised return by the income tax department, the alleged contemner has saved rupees 31,56,930 of the trust. Full stop. He submit that the petitioner has not committed any contempt. The said return was the document which the petitioner has relied upon. That is the digital signature of the alleged contemner, which was used by the chartered accountant only to give the revised return to the income tax department as per the query raised by the income tax department as per the query raised by the income tax department. Full stop. Full stop. Learned counsel for the petitioner submit that the petitioner the alleged contemner had the knowledge with regard to the interim order dated 9th of January 2025. He could have been taken the he could have been filed an application before this court for modification of the clarification of the order, but without clarification of the order, he has authorized the chartered accountant to use the digital signature, which alleged to have been use the digital signature of the alleged contemner. Considering the submission made by the counsel for the respective parties, full stop. Though the alleged contemner has filed the income tax return in the year 2020 in the month of November 2023 for the annual year 23-24, but in the month of December 2024, the income tax department has raised query, and the petitioner has submitted the query through the chartered accountant on 29th of January 2025. That is after the order passed by raised query on 20th December 2024, and the petitioner through the chartered accountant had submission is revised claim to the income tax department on 29th of January 2025. That is after the interim order passed by this court. Full stop. Passed by this court by using the digital signature of the alleged contemner. The alleged contemner ought to have brought to the notice of this court and for modification of the order for using of the digital signature after the with regard to the assets of the trust, but the alleged contemner failed to take any leave from this court. Thus, this court is of the view the alleged contemner ought to have been taken leave from this court before filing the revised claim before the income tax officer by income tax authority by using the digital signature. Thus, the alleged contemner is directed to be cautioned in future and to not to violate any order passed by this court in future. Full stop. The ऊपर में देते ना, the learned counsel appearing for the petitioner has prayed for unqualified apology if any, if the alleged contemner has committed any Both contempt application is disposed of. हाँ वही एक dismiss हो गया एक dispose of this dispose of rule if any issued against the alleged contemptor is discharged.
And our all staff, they cannot get money. They cannot carry salary staff for months.
So why you are mentioning here?
Already find what is our advocate party paper of hand, and we are going to use last date for application of the new years. Our that is closed, salary is closed, principal is not come there, all the fundamentals stop. So immediately, sir, if you want to take case in the morning, that will be better.
Who are you?
I am the officer of the college. Our advocate, I wanted to advocate in the copy, and he yes, today one of mentioned as you are the officer to please do this, sir. Because we want to National Commission for Human they will give permission, and permission depend on the salaries of 1 year and the teacher and the salaries of the staff 1 year.
Okay, it is extended to 22nd February. Correct. So what you are asking for before this court? What is the prayer in the writ petition? Who has filed the writ petition?
Our bank is closed. All the accounts of
So you are for the bank.
yes.
So you are objecting for their application.
I now join as a principal of the college. Our college.
Who filed the writ petition? College has filed the petition. So it will be coming tomorrow. No, this is not the way because it is the original side. Okay, you do one thing. Come tomorrow at 10:30. I will hear. Today it is done. It is there. Okay, I will see. If it is there, then I will see. I will see to that. I will see what is the urgency pleaded by your advocate. Then I will see.